Of the Employment Rights Bill, Baroness Jones of Whitchurch.
My Lords, I beg to move that this bill be read a second time. My Lords, when this government came into office, we made a commitment to deliver the biggest upgrade to workers' rights in a generation, a commitment I'm particularly supportive of, given I have been a proud member of Unison for many, many years. We promised to introduce a bill focused on improving workers' rights and creating the necessary conditions for long-term economic growth within 100 days of taking office. This was delivered in October last year, fulfilling a key manifesto commitment. This bill addresses the pressing issues faced by workers today. Workers who've waited too long for change due to the legislative stasis over the past decade and more. Average salaries barely increased under the previous government, and the average worker would now be over 40% better off if wages had continued to grow as they did leading up to the 2008 financial crisis. This lack of action means that today there are far too many people in low-paid and insecure work. As few as 1 in 6 low-paid workers move into and then stay in better-paid work, and 2 million employees report feeling anxious about hours worked or shifts changing unexpectedly. This is why Labour committed to making work pay as a key pillar of our election manifesto last year. In that manifesto, we were clear that our core mission as a government would not just be economic growth, but growth which raised living standards in every part of the United Kingdom, so working people had more money in their pocket. The mandate that the British people returned was clear. And further polling by Opinium and Focal Data since the election has yet further highlighted that there is a broad and strong support across the political spectrum for the policies in this bill. British people have waited long enough. They now urgently want to see protections in their workplaces from day one of their job. They want an end to exploitative zero-hours contracts, and they want greater flexibility so that work works around their lives. This legislation was developed in close collaboration with business and trade unions, and we're committed to ongoing engagement to ensure all stakeholders, including SMEs, receive appropriate time to prepare for the ensuing changes. The improvements it offers in terms of improving workers' well-being, increasing productivity, reducing workplace conflict, and creating a more level playing field for good employers would grant significant benefits worth billions of pounds per year. This bill seeks to address the gaps and outdated provisions in the current employment law framework and helps us turn the tide on the debilitating trend of in-work poverty. My Lords, I will now speak to the specifics of the bill. Part 1 introduces changes to various high-profile areas of employment law, and here we make good on our commitment to end exploitative zero-hour contracts. The government is committed to ending one-sided flexibility, ensuring that all jobs provide a baseline of security and predictability so workers can better plan their lives. The changes set out will require employers to offer qualifying workers guaranteed hours, reflecting the number of hours they work regularly during a reference period. This will be set out in regulations, but is expected to be 12 weeks. We will also require employers to provide in-scope workers with reasonable notice of shifts, as well as payment for shifts that are cancelled, curtailed, or moved at short notice. Corresponding rights are being introduced for agency workers, who may also experience that one-side flexibility. These changes could improve the security of work for around 2.4 million people, approximately 8% of all the people employed in the UK. On flexible working, this will be made the default, except where not reasonably feasible, to benefit workers and their families. Businesses also benefit from this change, as it will help give them access to a larger pool of candidates. However, we recognise not all workplaces can accommodate requests for flexible working. Businesses will still be able to reject unfeasible requests, provided the decision is reasonable and based on one of 8 business grounds. On statutory sick pay, the government's view is simple. No one should feel forced to struggle through work when they are unwell. This legislation will mean that 1.3 million of the lowest paid employees will have access to the safety net of sick pay at a rate of 80% or the flat rate, whichever is lower. And we're removing the waiting period for SSP, meaning employees will be able to access it from the first day of sickness, benefiting millions of people. My Lords, the previous government took laudable steps to improve the law around tipping, and we are building on this by strengthening the law to make it mandatory for employers to consult with workers at the place of business when developing their tipping policies. Then, turning to entitlements to leave, we will improve access to paternity and unpaid parental leave by making them day one rights, and by allowing paternity and shared parental leave and pay to be taken in any order. This will give employees the peace of mind that changing jobs will not affect their access to this leave, and it will provide working parents with greater flexibility. We will also establish a statutory entitlement for a day one right to bereavement leave. Under this, at least 900,000 workers will benefit from bereavement leave following the death of a loved one every year. This sensitive issue is one we will consult on, with the detail to be set out in secondary legislation. Regarding harassment in the workplace, it remains a sad reality that too many people often find their workplace unsafe. This can have a detrimental impact on people's lives and careers, and this is particularly true for women. We're clear as a government that we will do all we can to tackle this. We're legislating to strengthen the legal duty for employers to take all reasonable steps to stop sexual harassment before it starts, including harassment by third parties. And we will strengthen protections for whistleblowing to make it clear that if an employee speaks up about sexual harassment, they can qualify for whistleblowing protections. We're making changes around dismissal as well. Firstly, we will make it unlawful to dismiss pregnant women and mothers during maternity leave and for a 6-month period after they return to the workplace, although there will be exceptions to this in specific circumstances. Secondly, we will create a new automatic unfair dismissal right for employees that have been unscrupulously fired and rehired, or fired and replaced, ending the unnecessary threats of these practices. And thirdly, we will ensure that all employees are better protected from unfair dismissal by making it a day one right, benefiting nearly 9 million people. My Lords, turning to part 2, changes will be made to collective redundancy. These changes will ensure employers fulfil collective consultation obligations, which will be triggered where, firstly, 20 or more redundancies are proposed at one establishment, as is currently the case, or 2, a threshold number of employees are proposed to be made redundant across the organisation. The threshold number will be set in regulations following consultation with those at stake in good employer-employee relations. And we will set the threshold for this requirement at a level that balances the needs of growing business and protecting employee rights. We are also amending notification requirements, so employers must notify the government when they are proposing to make employees redundant across their business and when they meet the new threshold. This will ensure employers acting in bad faith cannot circumvent their consultation obligations by proposing smaller numbers of redundancies across multiple work sites, allowing more employees to benefit from those collective consultations. And we're closing a loophole in the maritime sector to ensure seafarers have the collective redundancy protections that they deserve. We will also deliver on our commitment to reinstate and strengthen the 2-tier code on workforce matters. This was first introduced by the last Labour government and repealed by the coalition government of 2010. By reinstating the code, we're taking a step towards ending unfair 2-tiered workforces, where employees hired from the private sector to work on an outsourced contract have less favourable employment terms and conditions than those transferred from the public sector. My Lords, our country has a national gender pay gap that stands at over 13%, so we are also taking overdue action through action plans. These plans will require employers to take action to improve gender equality, as well as better support staff during the menopause. This is good for women, good for economic growth, and good for our country as a whole. My Lords, turning to Part 3, this addresses pay and conditions in specific sectors. Chapter 1 will reinstate the school support staff negotiating body to give a voice to support staff who make up roughly half of the school workforce. Not only will this body negotiate pay and conditions, but it will also advise on training and career progression to properly recognise the vital role that these staff undertake. Whilst an important part of reinstating the body is to improve consistency, it does not commit us to a one-size-fits-all approach. Our intention is for support staff in all state-funded schools in England to benefit from a core pay and conditions offer, whilst allowing the flexibility for all schools to respond to local circumstances above minimum agreements reached. We will be consulting on this over the summer. The body will help address the recruitment and retention challenges that state schools of all types face, and drive up standards to ensure that we give every child the best possible chances in life. Chapter 2 will establish a framework for fair pay agreements in adult social care in England, and, after constructive discussions with the Scottish and Welsh governments, this will be the case for the adult and children's social care sectors in these nations too. This will help empower workers' representatives and trade union officials, employers and others in partnership to negotiate pay, terms and conditions. The introduction of sectoral agreements aims to ensure that care professionals are properly recognised and rewarded for the important work they do. It will help tackle the long-standing workforce issues in this sector and improve the situation for both workers and those for whom they care across Great Britain. Chapter 3 focuses on 2 measures relating to seafarers. Together, these changes will benefit our seafarers, who are the present-day standard bearers of the UK's proud maritime history, and it will send an important signal that we continue to be a world leader in international maritime employment law. The first change will deliver a legally binding Seafarers Charter, achieved by expanding the scope of the Seafarers Wages Act to provide powers to require harbour authorities to request safe working and remuneration declarations from operators in scope. It will require operators to confirm that they are meeting the requirements of these declarations, the exact details of which we will consult upon in due course. Secondly, we will give effect to international maritime conventions the UK has ratified, such as the Maritime Labour Convention, which will fix a powers gap that has been left following the UK's exit from the European Union. Part 4 focuses on trade unions and the right to take industrial action. Firstly, we will introduce a legal duty for employers to inform workers about their rights to join a trade union. This aligns with the government's focus on empowering workers by ensuring they are fully informed of their rights. We will also be providing for a right of access for trade unions. This will provide a framework for the negotiation of access agreements between employers and trade unions. Once agreement is reached, trade union officials will be able to access the workplace to represent, recruit or organise members and to facilitate collective bargaining. These arrangements also cover digital forms of communication. Changes will be made to the conditions for trade union recognition too. Where an employer refuses to recognise a trade union voluntarily, currently it can apply to the Central Arbitration Committee to obtain statutory union recognition. There are, however, unnecessary hurdles that apply to that CAC process, which hinder the recognition process. This bill will tackle those hurdles. for example, by deleting the current requirements for unions to have the support for at least 40% of the workforce in the proposed bargaining unit in a trade union recognition ballot. In future, unions will only need a simple majority of those voting to ensure that they get greater fairness in that process. Other changes we are making include: 1, strengthening the existing right to reasonable paid facility time for union representatives to carry out their duties; 2, simplifying the information required for industrial action notices; 3, to the law around blacklisting, ensuring those lists produced by predictive technology cannot be used to discriminate; 4, protecting against detriment for those that take industrial action; and 5, protecting against dismissal for taking such action. My Lords, turning to the punitive trade union legislation passed by recent governments, we will be making repeals to the Trade Union Act 2016 to effectively return the law to its pre-2016 position. There are 3 exceptions to this. Firstly, we will retain the industrial action ballot mandate expiration date, but extend it to 12 months. Secondly, we will shorten the notice period for industrial action from 14 days to 10 days, rather than the 7 days it was before 2016. And thirdly, we will retain the independence of the certification officer from political control. We are also repealing the Strikes Minimum Service Levels Act that has failed to prevent a single day of industrial action. Yeah. The framework set by this government will foster a new partnership of cooperation between trade unions, employers and the government. My Lords, the current system of state enforcement is fragmented and inefficient, which is complicated for workers and employers. So Part 5 focuses on the enforcement of labour market legislation and lays the groundwork for the establishment of the Fair Work Agency. This agency will deliver upgrades to enforcement of workers' rights. It will bring together existing state enforcement functions, including the regulation of employment agencies, national minimum wage enforcement, gangmaster licensing, action against serious labour exploitation, and the Unpaid Employment Tribunal Award Penalty Scheme. This will simplify the overall enforcement process and improve access to rights for workers, whilst levelling the playing field for the vast majority of businesses that already operate in good faith. We also expect the agent to be able to make more effective and efficient use of the resources currently used by enforcement bodies. Creating this agency is more than just shuffling deck chairs. It will have a wider remit than just the existing enforcement bodies, such as enforcing holiday pay for workers. These reforms will help to ensure non-compliance doesn't pay. That's fair for workers and fair for businesses too. Finally, Part 6 contains provision to increase employment tribunal time limits for making claims from 3 to 6 months. This will benefit both employees and employers by providing more time for disputes to be resolved internally, potentially reducing pressure on the employment tribunal system. The additional time will support employees to consider the merits of bringing a case to the employment tribunal, which will help improve the quality of claims entering the system. My Lords, this bill is a significant upgrade to legislation, and I look forward to the forthcoming debate, including the maiden speeches from my noble friends Baroness Grey and Baroness Berger, and the noble Baroness Cash, and the noble Lord Young of Acton. When placed in the context of our ambitions to make work pay, I hope noble lords will agree that this government is delivering on improving workers' rights. I emphasise this legislation seeks to benefit employers and the economy by levelling the playing field between good employers and those who already go beyond the measures in this bill, and the less scrupulous ones. These benefits are recognised by many of the businesses that we have engaged with throughout the bill's development and passage to date, including Centrica, the Co-op, Richard Sands and Thomas Neal & Co. In the words of Nick Cooper, Managing Director of Manchester's-based SME, Adept Corporate Services, fair treatment and job security aren't luxuries. They're the foundation of a high-performing workforce. When less scrupulous businesses are challenged, it's those that are already doing right by their workers, as the vast majority already do, that benefit. I urge the House to support this bill and the commitment it represents to improve the lives of millions of people and growing the economy. My Lords, I beg to move.
The question is that this bill be now read a second time.
My Lords, I begin by drawing attention to my interests as detailed in the Register, in particular as a practicing solicitor and partner in DAC Beechcroft. I thank the noble Baroness, the Minister, for opening the debate, and we now look forward to the maiden speeches of my colleagues, Baroness Cash and Lord Young of Acton, and also those of Baroness Berger and Baroness Grey of Tottenham. My Lords, I've always believed fervently in workers' rights and trade unions. Indeed, as a young solicitor, I often acted for the Transport and General Workers' Union in a wide variety of cases. By the late 1970s, however, by which time I was a Member of Parliament, it had become abundantly clear something had gone seriously awry with the trade union movement. They seemed to be abusing their powers, pursuing not only the legitimate interests of their members, but also an overtly political agenda. I remember in the House of Commons, in the other place, when in the final year of the Callaghan government, the unions all but brought the country to its knees. So a new settlement was needed. Then successive Conservative governments between 1979 and 97 gradually changed the nature of the social contract between employers, employees and the unions. Days lost to strikes tumbled from tens of millions a year to a tiny fraction of what they had been. Thanks to the more flexible labour market we had created, renewed economic growth brought a dividend of rising employment and falling unemployment far more quickly than anyone expected. That wasn't the Wild West. Indeed, workers' rights and protections were often extended, not diminished. The last Labour government, under both Tony Blair and Gordon Brown, broadly accepted that renewed social contract, and they embraced the flexible labour market, which serves both employers and employees so well. So what has changed? Furthermore, what's changed during the passage of this bill? It has a brief lifetime, but we've already had 160 government amendments at committee stage in another place, including 11 new clauses and 2 new schedules. This farrago was followed by a further 40 new clauses and 5 new schedules at report stage. It was an extraordinary decision to run the progress of this bill in parallel with a series of directly connected public consultations. As they showered us with amendments of their own, ministers used their majority in the other place to defeat some very sensible ones from my own party, but also from the Liberal Democrats. More amendments are now promised, or should we say threatened. No one can convince me that there has been fair, effective and comprehensive parliamentary scrutiny of this legislation, which is scandalous when we think of the profound effects it is bound to have on British business and how our businesses operate. To date, 11 government bills, including this one, have included Henry VIII powers, and this bill contains 11 such powers. So great is the uncertainty this creates that a meaningful second reading debate is almost an impossibility. What in fact are the principles of this legislation? Whatever they are today, might they change significantly with further amendments or when the Henry VIII powers are triggered? Ministers are effectively asking Parliament today to empower them to do whatever they decide to do, whenever they decide to do it. Apparently, in total, this bill contains 173 delegated powers. I was just musing, if Henry VIII were alive today, he might be tempted to use this kind of skeleton legislation to legalize uxoricide. Whatever. I ask ministers why they are so disdainful towards the concerns expressed by the Attorney General in his Bingham lecture on the rule of law last October, when he warned, and I quote, "Excessive reliance on delegated powers, Henry VIII clauses or skeleton legislation upsets the proper balance between Parliament and the executive." He recommended, I quote again, "a much sharper focus on whether taking delegated powers is justified in a given case and more careful consideration of appropriate safeguards." But perhaps the most chilling warning about the specific inadequacies of this bill came from the Regulatory Policy Committee, which identified 8 of the government's individual impact assessments as being not fit for purpose, 6 of which were in the highest impact measure category. Surely it's the principal responsibility of ministers fully to think through the potential impact of legislation before unleashing it on the world. This government has failed in that basic task. Meanwhile, the Recruitment and Employment Confederation's Voice of the Worker campaign vividly reminds us that temporary work is often a choice made by workers, not an enforced compromise. Its survey of temporary agency workers found that 79% of respondents appreciated the flexibility temporary work provides, whilst more than 2/3 believes it affords them a better work balance. These values, flexibility and balance, should be celebrated and supported by us all, not jeopardized by half-baked laws. Workers should be empowered to engage in the workforce in ways that best suit their personal circumstances, and we must ensure that legislation does not restrict their ability to do so. While the intention may be to increase security, these measures risk over-regulating agency workers who are already well provided for under the agency workers' regulations. Under current law, these workers are made aware of permanent vacancies and enjoy protections that balance flexibility with job security. Additional regulations could well tip this balance too far, ultimately harming the very workers that this bill seeks to protect. I also wonder whether ministers have fully considered the financial, economic and social impact the measure would have on public bodies, especially in the National Health Service. Well, let's also consider the proposal around statutory sick pay eligibility. Reducing the eligibility criteria and requirement for SSP to just 1 day would increase financial pressure on employers, particularly those who employ workers on temporary contracts or in sectors that rely on flexibility. Employers also now face the prospect of greater tribunal risk when managing employees' sickness leave, which could act as a further deterrent to hiring. Small and medium-sized enterprises are so often the driving force in our economy, delivering growth in production and jobs. They need our encouragement and support, not new burdens. And they will inevitably be more hesitant about taking on new employees if they fear facing immediate legal risks from day one. I do implore ministers always to look at proposals from the point of view of an employer making a marginal decision on whether or not to take on that extra employee. The proposed new union recognition rules would also hit SMEs disproportionately, and in our view on these benches unnecessarily. And then let me turn, as the noble Baroness did, to strike some ballot thresholds. Under current law, unions must provide 14 days' notice before a strike, allowing employers sufficient time to prepare contingencies and manage the potential disruption. The proposed change to reduce this notice period to just 7 days raises significant concerns. Will this help to generate the much desired and much needed economic growth about which we hear and have heard today so much? In response to the latest ONS labour market data, the Institute of Directors shared some deeply troubling data of its own. That data shows that 47% of business leaders facing higher national insurance bills plan to reduce employment as a result. Business hiring intentions over the next year remain around lows last seen at the height of the COVID-19 pandemic. Even the government's own rather feeble impact assessment concedes that this bill is going to impose a £5,000 million cost on businesses. So what do they offer in return? Unfounded, optimistic speculation that this legislation could lead to growth. No evidence, no guarantee. Their own declared primary mission is economic growth, and yet they put forward a policy that actively undermines it. My Lords, this bill is not only anti-business, in my view, it is anti-worker. If it passes in anything like its current form, it could be more appropriate to call it an unemployment bill. The measures in this bill will make it harder for existing businesses to thrive and near impossible for new ones to emerge. The result? A stagnating economy, diminished opportunities, and worse outcomes for workers right across the country. The only growth this bill would deliver would be growth in industrial strife, growth in administrative costs for business, growth in uncertainty, and ultimately growth in unemployment. Unless it can be seriously improved on these benches, we will oppose this bill all the way, in the best interests of the working people of this country.
My Lords, it's a privilege to contribute to this important second reading today, and I acknowledge, unlike the noble Lord Hunt, that this bill contains several provisions that, if implemented properly, could have a significant positive impact on many individuals. However, as we deliberate, I am mindful that the bill presents both promise and areas of concern. In particular, I would like to focus my remarks on the challenges faced by carers, an often overlooked but integral part of our society. Their needs, as the bill progresses, must not only be considered but also prioritised. I'm going to rely on my noble friend Lord Fox to deal with many other aspects of the bill other than the bits that I'm stressing. First, I must turn to paid carers leave. While the government is committed to reviewing the Carers Leave Act 2023, I question why we delay a measure that is both necessary and beneficial. The government recognises that carers' inability to work costs the economy £37 billion annually. In light of this, paid carers' leave should be a priority, not just an afterthought. My Lords, this is not an expensive proposal. Carers UK estimates that introducing paid carers' leave would cost between £5.5 million and £32 million per year, depending on the level of compensation. In return, over 2 million working carers would benefit. Businesses would save billions through improved staff retention, and workforce participation would increase. Given these clear advantages, can I ask why the government has excluded this measure? During the passage of the Carers Leave Act, members of the now government challenged this omission. It is striking they have not prioritised it themselves. I may ask whether the government will commit to including paid carers leave in this bill. To neglect this opportunity will fail both carers and the economy. My Lords, beyond paid leave, employers should be required to consider employees with caring responsibilities in their equality action plans, alongside commitments to closing the gender pay gap and supporting employees experiencing menopause. If we are serious about workplace equality, we must acknowledge the specific challenges that carers face. Furthermore, the government must prevent discrimination against carers. One solution will be adding caring as a protected characteristic under the Equalities Act 2010. Many carers face workplace marginalisation and are penalised for their responsibilities. May I ask, will the government explore this reform? My Lords, every year 200,000 people leave the workplace to take on caring responsibilities, costing the economy £8 billion annually. By failing to support carers properly, we harm their well-being and weaken economic potential. Paid carers leave would help carers stay in work, strengthening both the labour market and the economy. Another issue is the recognition of kinship carers. I recently heard of a couple catering for their grandchildren out of love and duty, yet they receive none of the employment rights or support given to foster carers. I ask, is this not an injustice? The government must consider extending employment rights to kinship carers. My Lords, additionally, I support the bills, and as said by the Minister, of provisions on third-party harassment in the workplace. I've heard from young women in retail and hospitality who feel sick with anxiety knowing they will face harassment during their shifts. Their employers must have a duty to protect them, while the bill takes steps in the right direction, and I acknowledge that. Stronger action is needed to prevent non-disclosure agreements from silencing victims. I now turn to probationary periods. A balanced approach is needed to protect both employees and employers from unnecessary tribunal costs. I note what the Minister said, the Honourable Lady the Minister said, on statutory sick pay. Will the government consider a standardised probationary period of, say, 3 to 9 months to provide greater certainty? My Lords, may I ask whether this bill would generally drive economic growth? We judge from the Noble Lord Hunt that it won't. I would say there is possibilities. Which is one of the government's cornerstone ambitions, to have economic growth. Business leaders and HR professionals I have consulted welcome the bill's aims, but question whether it strikes the right balance between employee rights and employer obligations. It must not stifle economic activity, nor should it miss opportunities for meaningful reform. The noble Lord Hunt spoke about the number of amendments in the other place, and I will not repeat those remarks. But they do show that I think there were 200 government amendments at report stage, which does show a certain amount of indecision, if nothing else. My Lords, this bill is driven by noble intentions. I agree that. But it risks becoming a tangled quagmire of complex employment bureaucracy, with uncertainty over whether it will genuinely recalibrate the balance between employers and employees in a way that promotes a fair and productive employment. One member in the other place, I like this, likened it to Snow White's apple, appealing in appearance, but ultimately sending the economy into a slumber. Let us ensure this bill is not a missed opportunity, but a transformative step forward for carers, families, and our nation's economic future.
Well, my Lords, I have just 4 minutes, so will not beat about the bush. While I do understand the need to bear down on unscrupulous employment practices, this bill, I fear, is fundamentally misguided, out of date and out of touch, and will wreck the spirit of enterprise. It will damage jobs, productivity and wages across both the public and private sectors. That's not just my view, but the OBR's. And the impact assessment, claiming the bill will have a net positive impact on growth, is guilty of fantasy economics, suggesting its authors have little feel for or experience of creating jobs, developing careers, or even meeting payroll. Perhaps most troubling is that all the clauses within this 300-page bill and its 200 pages of explanatory notes apply to all employers without exception, whether you're a UK multinational with a workforce of 100,000, a start-up with 10 staff, or a family business with 2 employees. One size fits all, whether we're talking day one rights, probationary periods, guaranteed hours, or flexible working. This bill shows scant regard for building a competitive economy with modern working practices. It discriminates against SMEs, our country's engine of growth, and offers nothing for freelancers and the self-employed, for which perhaps we should be grateful. My views are shaped by my lived experience over 30 years as an entrepreneur and employer, from a start-up with 2 employees around the kitchen table to building a workforce that grew to 10 staff, then to 50, 100, and eventually to 300 employees, plus 100 freelancers. I learnt what it takes to effectively recruit and train people, to incentivise and reward them, to develop their careers, from probation to permanent, from junior to management, from internship to becoming an equity partner. I took risks and made many mistakes along the way, from hiring the wrong people, holding on to staff for too long, overpaying, underpaying, growing too quickly, and having to downsize. The rough and tumble of the free market. But here's the thing, I never once ended up in an employment tribunal, and experiences with staff and freelancers were overwhelmingly positive, driven by common mutual interest and without the need to resort to onerous employment manuals, interfering HR departments, or indeed employment lawyers. My Lords, this bill suffers from overreach and will kill entrepreneurial spirit, coming as it does on the back of the misguided Nix bill, on which I have fought hard to protect our smaller businesses. And I'll go into battle again on their behalf at committee stage for this bill, mindful that the Federation of Small Businesses reports that 2/3 of their members say the proposals on this bill will make them curb hiring. 2/3. My Lords, there are 2 professions that will benefit from this bill, HR practitioners and employment lawyers. But in terms of productivity, this bill is terribly timed and represents another giant vampire squid sucking the life out of our economy.
My Lords, I'm glad to speak in this second reading and look forward to to the maiden speeches and welcome new members to your Lordship's House. Some years ago, I undertook research on the Apostle Paul and work. Paul was never one to shy away from hard work and spoke of the personal cost of his tent-making business, describing it as wearisome and fraught with the challenges of local politics. 2,000 years later, we continue to live amidst diverse uncertainties. The desire to make work pay and improve workers' rights, as proposed in this bill, must pay attention to the obvious. People who work are human beings. A strong economy needs resilient workers. As we scrutinise this legislation, we do so affirming that workers matter. If we get this right, we can move closer to a society in which people are viewed with inherent value and dignity. When people are valued and supported in what they do, they contribute to greater economic flourishing. Noble Lords will know that in-work poverty has risen significantly in recent years, particularly in the North East region, with those in less secure work much more likely to be experiencing poverty than those whose contracts offer basic protection and guaranteed hours. The disproportionately negative impact on the lives of children is well documented, with the North East Child Poverty Commission reporting heightened concern following yesterday's spring statement. With the bill before us today, legislating against exploitative contracts is a step forward in ensuring that every person can access good work, plan ahead, and provide for themselves and their families. But there may be unforeseen consequences. I welcome reforms to parental leave and strengthened flexible working. I'd like to see a statutory right to paid kinship care leave on a par with adoption leave, a point made just now by my noble friend, Lord Palmer. A right to paid leave would enable kinship carers take time to make necessary adjustments and continue in paid employment. This is a matter I have already raised with the noble Baroness, the Minister, and I was very grateful for her time in listening. And I raise this matter again here today and look forward to further conversations. My Lords, at a time when SMEs face additional pressures, a challenging economic environment and additional costs through rising national insurance contributions for employers, I urge the Government to continue listening to the SME sector, many of whom are part of the social enterprise economy, adding to community and individual resilience. There is deep concern amongst SMEs about the potential impact of union access to the cohesive nature of employer relations, points made by noble Lords already. In conclusion, my Lords, while I welcome this bill in extending basic rights, protections and entitlements to workers, concerns do remain as to how these individual protections will truly enable collective flourishing and a stronger and resilient society for the confident future desired by everyone.
A very bad bill for very many reasons, and I'll have to ration myself to just two areas. First and foremost, this bill is unequivocally bad for businesses and therefore bad for growth. It is not pro-growth to impose £5 billion worth of costs on businesses. It would be pretty bad if this bill existed in isolation, but it is not in isolation. It's part of a triple whammy, which also involves the jobs tax, which will add over £20 billion to private sector wage bills, and the national minimum wage increases, which will add many more billions. The government seem to have forgotten that they need private sector businesses to grow if the government are to achieve their overall growth objective. The economic impact analysis, which accompanied the bill, claims the possibility of a small positive impact on growth. But the probability is a big negative impact, as suggested by the OBR in their spring forecast yesterday. For that reason alone, the government should have killed this bill at birth. The country cannot afford it. Now, in response to the triple whammy, Most businesses are expecting to raise prices, to reduce pay increases, and to reduce employee headcount. That leads to inflation, lower employment, reduced profits, and reduced taxes. It creates an environment in which businesses will not invest, thus hobbling another leg of the growth ambition. A key plank of the UK's ability to attract inward investment has been the flexibility of our labour markets. This bill destroys that competitive advantage. It is an economic disaster zone. SMEs are particularly hard hit by this bill. The economic impact analysis assessment is clear about this. And of course, anything which is bad for SMEs is also bad for growth. But policies which bear down excessively on SMEs are particularly destructive to the foundations of the way that we do business in this country. At the last count, there were over 5.2 million micro businesses with fewer than 10 employees, and a further 220,000 small businesses with 10 to 49 employees. And between them, they employ nearly 13 million employees. Why would the government want to put this huge group of employees at risk? Now, I will be looking at amendments to this bill to protect SMEs from its excessive burdens, and I look forward to working with the noble Lord Lonsborough on this. My second area is this bill is bad for some significant employee groups. For example, people with a history of health-related absence or young people with no track record will be less attractive as employees because of day-one rights and higher sick pay. There are many people who value zero-hours contracts, but they may be deprived of that opportunity because of the way that employers will be trying to avoid the risks of getting involved in conferring rights to guaranteed hours. This bill will make life worse for many who want to work. My Lords, there are many aspects of this bill which will need to be explored in detail. Your Lordship's House has a responsibility to ensure that this bill, as a minimum, does no harm. That will be a difficult task because this bill has deep flaws, but we must try.
Lords, I wish luck to the new peers with their maiden speeches, and I look forward to listening. Employment legislation constantly needs to be updated to reflect the changing needs of our society. Therefore, a review is necessary from time to time, but does this bill reflect a balanced review for both employees and employers? I wish the House to note my interest in the Register being a part owner of a small to medium-sized company employing 130 people. As a relatively small employee, Part 1 of the Employment Rights Bill is an area I wish to focus on. The changes to the right not to be unfairly dismissed and the removal of the qualifying period will generate uncertainty within employers, and especially SME employers who do not have significant HR resources. The changes is not a bad one, and it will focus employers to get systems in place to ensure individuals they employ can fulfil the roles with the skills and knowledge required and the right attitude for the business and the job. Therefore, I ask the noble Baroness the Minister, we need more clarification with regards to the probation period, as already spoken by Lord Palmer. This is essential to allow employers the flexibility at the beginning of a contract to see if a new employee does perform or fulfil the needs of the job for the business, and if treated responsibly, the contract can be terminated. To meet this requirement, to dismiss someone in a non-unfair way is very time-consuming, costly, stressful for both employee and employers. To support this change, please can the Government review the provision of occupational health services to the SME sector, which is so commonly needed which relates to breakdowns between employees and employers. The second area I wish to address, where we look to research further before committee stage, is the dismissal for failing to agree a variation of contract, more commonly known as fire and hire. The question for the noble Baroness the Minister is why the change to the current relation is needed, as it appears to be working. Having recently been through the process in our business requesting variation to individuals' employees' contracts, to improve efficiency and services to our clients, the current rules certainly ensured we treated them fairly and with respect, and that it allowed us the flexibility to change things. These change proposals will make it extremely difficult for employers to make small, reasonable changes to contracts as the new demands are so unclear and demanding on the businesses. The third area of concern is regards to sexual harassment power to make provisions reasonable steps. The change to all reasonable steps just adds fear and uncertainty to employers who want to protect their employees but currently have no clear guidance. So please, I ask the Development Minister to provide more clear details in the future of what is meant by all reasonable steps.
My Lords, it is an honour to rise to contribute to this debate and to join this House. I begin by extending my sincere thanks to all the people in this place who have been extraordinarily generous in their welcome. Blackrod, the doorkeepers, the special advisors, the catering staff, the mailroom team, the clerks, the reception attendants, the tech and security specialists. Everyone has been so accommodating and helpful while I walk around in circles trying to navigate this side of the estate, or try and tap my phone to Apple Pay my vote instead of using my pass. My special thanks to Mrs. Mimi Tsehai Gebret Sadek, who has been a warm, smiling face every time I've gone for a cup of tea in Millbank House. I'm particularly grateful to my introducers. My noble friend, Baroness Smith of Basildon. I am in awe of her leadership in this House. I look forward to learning much from the noble Baroness over the coming months and years. And my noble friend, the Lord Mitchell, who has been a dear friend and mentor to me for 2 decades. Thank you also to the Chief Whip, Lord Kennedy of Southwark, for his extensive counsel and guidance. And to members from all sides of this House, thank you for your kindness. I look forward to working with you on mutual areas of interest and expertise. I'm speaking in this debate because this vital new legislation speaks so much to what is important in our great land, my motivations for getting into politics, and the experience I have amassed. I grew up in Wembley Park and spent my weekends studying at Brent Town Hall Library. I loved the diversity of my neighbourhood. My dad is from Northampton, where all his family worked on the markets across the county. I started my working life helping my grandfather on his market stall, selling ladies' fashions, and in London in my parents' interior furnishing shop. I am certain that I was never paid the minimum wage in the family businesses. But what I did gain was an opportunity to listen and connect to so many different people. It was at Birmingham University where I engaged in vociferous debate with my Labour economics tutor, Professor Siebert, as I advocated for workers' rights, much to the amusement of fellow students, and I immersed myself in student politics. I joined Labour because I passionately shared the party's values and goals of striving for equality, social justice, and a world free of discrimination. Labour also spoke to my core Jewish values of tikkun olam. How do we adequately take action to improve and repair our communities? I went on to start my working life in roles for the Commission for Racial Equality, various central government departments, and the NHS Confederation. I'm also inspired and proud of my family's political heritage. My great-great-uncle, Lord Shinwell, known as Manny, was a national trade union official before he was first elected to the other place in 1922 and was later elevated to your Lordship's house in 1970. Lord Shinwell would have warmly championed the bill we are scrutinising today, which will bring the UK's outdated employment laws into the 21st century, turning the page for our economy that for far too long has been blighted by insecurity, poor productivity and low pay. As a solo parent to Amelie, aged 8, and Zion, aged 6, and in my role as chair of the Maternal Mental Health Alliance, I applaud this government's commitment to bringing forward practical measures to value and support working parents. I'm delighted that this bill will establish day one rights for parental and paternity leave. I also strongly support the measures to ban exploitative zero-hour contracts. It was such an honour and privilege to represent the people of Liverpool Wavertree. And in my 9.5 years as their Member of Parliament, I had so many constituents come to my advice surgery adversely affected by these awful contracts. They couldn't plan their lives, their childcare or their finances. These damaging practices impacted on people young and old alike, and any mental health challenges were exacerbated by this precarious work. I can still hear my former constituents' words ringing in my head. I can't lay out to buy a belt because I don't know if I will be earning money next week or the week after to cover my bills and basic food. The provisions in this bill are foundational to the dignity and well-being of our workforce, and I know that this legislation will make a difference to thousands of people across the UK. I hope to make a difference in this place, but will endeavour to do it slightly differently from my great-great-uncle. Lord Shinwell resigned the Labour whip in 1982 in protest at left-wing militancy and sat as an independent until he passed away just before my 5th birthday. While I never wanted to leave Labour during the dark years when anti-Semitism was rife in the party, I am so glad to have been able to return to my political home under the leadership of Sir Keir Starmer. Lord Shinwell famously had a piece of the ceiling of this place fall on his head. During my time here, I very much hoped to protect my skull. Of course, Lord Shinwell was also the last person to throw a punch in the other chamber when a member told him to go back to Poland. While I will never shy away from necessary challenge, I will always aim to use the power of my words rather than my fists. Manny Shinwell, born into a world of tumult and revolution, once said that he chose Parliament over the barricades. In a world today of increasing violence and populism, where dark elements threaten, it is here in our Parliament that the painstaking work of democracy is done. As part of that work, my lords, I will dedicate myself to serving in this House and the people beyond it with humility and diligence and all the passion and insight I can offer.
Yeah. My lords, it is a great honour to be able to be the first to congratulate Lady Berger on that truly wonderful maiden speech. There's no doubt that her great-uncle would be beaming with pride, and he sounds like he was quite a character. He'd be good at our group meetings, I feel. And it doesn't feel like that much has changed when it comes to maintenance of the building here either. And I look forward to the many other maiden speeches here today. Now, I first came to know Baroness Berger back in 2010, when she was first elected for Wavertree. And I greatly admired her professionalism and her passion for raising the issue of mental health. Back then, it wasn't a fashionable topic to be discussing. Now, we became very, very good friends, very, very dear friends, and we've been through so much together. From music festivals to hen do's to riding the infamous pink bus back in 2015. Listen, I stand by her, all right? So we've very much been through the good, the bad and the ugly together, but none more ugly than the shameful years when she suffered untold misery, abuse and threats simply for being a young Jewish female Labour MP. It is a time which really shamed our party, and on behalf of all of us, I am so deeply, deeply sorry for what she had to endure. Her dignity, her strength, her courage, her grace during that time was inspiring and incredible. She didn't hide. She stood up to the bullies, to the anti-Semites, and she made the Labour Party and the wider world take action. So we on these benches are so lucky to have her, as are all of us in this House. And I know that she will make a brilliant, brilliant, principled, fearless contribution. And on a selfish note, I look forward to spending the next sort of 30 years hanging out, probably 40 years in your case. And we are also living proof, by the way, that Muslims and Jews can be very, very good friends, which I feel is quite timely. I now turn to the topic of our debate. Now, there are many speakers, many experts, especially from the trade union movement, who will have more detailed points, but I just wanted to make a few broader arguments. We have seen and heard some predictably negative discourse about this bill and its aims. And it does feel that people saying that it's all too much, I don't understand, that giving workers more rights will somehow mean that the pillars of the temple will fall down. I remind my colleagues that the same was said about the introduction of the national minimum wage. The same was said about giving parents more rights. At the same time, we're also having a discussion about why it is that people are reluctant to go back to work and why that's a terrible thing for society, which I, by the way, agree with. So why can't we join up the dots? If you want to encourage as many people back to work and into the workplace, you've got to make sure that work pays and that they have decent conditions. We were all appalled when P&O Ferries sacked 800 workers in the most dehumanising and appalling way. We've all been shocked and disgusted at how those women at Harrods were treated and subjected to sexual abuse. And I know my good friend Lady Kennedy will raise the issues of NDAs which silence women. And as we've heard, we all know the difficulties of 0 hours contracts when you're trying to plan your life and your family life. We all need to recognise that having a workforce which is happy and treated well is a workforce which will be motivated and productive. We also need to stop demonising the work that trade unions do and pitting them against business. We should regard decent employment rights as part of our growth and industrial strategy. I consider myself very lucky to have known the late, great trade unionist and MP Jack Dromey, who taught me so much about industrial relations. He always made the case that good bosses and good business leaders understood the need for smart partnerships with workers and trade unions, particularly in big, heavy-duty sectors like car manufacturing. Now, we are all very fortunate to have made it to this place, right? Many of us have lawyers or headhunters or even agents, in my case, who can help us make sure we have good terms and conditions. Why shouldn't other people have some of that? If we want growth, decent standards are not a luxury. They are an imperative. And we should support trade unions to do that. As Jack Dromey said, a good trade union is like having a strong friend at work. And that is something we should all strive for in a civilised, modern society.
First of all, I want to congratulate Baroness Berger on her excellent maiden speech and wish her well, and I look forward, very much forward, to the remaining maiden speeches to come. My Lords, ever since this government were elected in July of last year, we've been told that growth is their key marker for success, and the bill that we are debating today does therefore seem completely counterintuitive to that stated desire. Of course, employees need to have rights in the workplace, and these have developed in a sensible and proportionate manner over the years, whether that be in connection with pay or in connection with conditions of employment. However, this bill, my Lord, completely unsettles the balance required for competitiveness, for growth, for productivity on the one side, and the rights of employees on the other. And that can only lead to discontent, a lack of investment, and will inevitably lead to a fall in growth and productivity, not an increase. This bill comes, indeed, after hits have already been made to businesses across the country. The recent increase in the minimum wage, on the face of it, is a good thing. However, when taken with an increase in national insurance contributions at the same time, it is not hard to understand how many small firms are struggling. If we take one sector, the retail sector, Retail NI conducted a survey which was published in February of this year. It established that 86% of those surveyed expect to cancel expansion plans following the increase in employer NI contributions and the rise in the minimum wage. It also found that 74% of those surveyed were planning to reduce the number of employees and other staff following those announcements. And these are significant figures and cannot be ignored or brushed aside. Government is certainly listening to the voices of trade unions, but are they balancing that in a responsible way by listening to the voice of job creators, both big and small? And speaking of the unions, small business owners are very concerned about how this bill allows access by unions into workplaces, almost regardless of their size. As one small business in England said to me, Typically, small businesses are run in a spirit of good teamwork, care for staff, with a drive and vision for business to succeed. In a difficult trading environment, small businesses could easily be overwhelmed by this legislation, and indeed would, and especially the need to proactively engage with unions to comply with the law. Now, I hope that His Majesty's Government will clarify that they are not intending to burden businesses of less than 250 staff with these proposals. In the time left, I want to concentrate on one aspect of the bill which I think is highly detrimental to growth and will really need to be revisited by government, and that's the ability to gain full employment rights on day one of employment. That's definitely going to slow down business expansion and slow down growing the workforce. I would also argue it will impact on investment in research and development and innovation, as there's little incentive to innovate when the costs are prohibitive when it comes to growing the workforce. Because in a survey carried out nationally by the FSB on this issue, the largest issue was that issue of the worry of unfairly dismissing employees from day one. 75% of small business employers listed it as the #1 concern, followed quickly by the removal of current 3-day waiting period, so that statutory sick pay will be payable from the first day of absence at 74%. In Northern Ireland, I can quickly say that we have the additional problem of a poor economic inactivity rate, currently at 26.6% of the workforce. If we cut the opportunities for more jobs, then how can we deal with that issue, never mind the issue of the unemployed? My Lords, government alone does not grow the economy, but it should facilitate the private sector to grow. To be competitive at home and internationally, we must give businesses the tools and the environment to grow, and I don't see that presently in this bill. I look forward to the detailed examination of the bill, therefore, where hopefully we can deal with some of the issues raised.
Thank you. My Lords, it is a huge privilege to stand here today. I wish to start by thanking noble lords on all benches across the House for the warmth of their welcome. Thank you also to my supporters, the noble Lord, Lord O'Donnell, and the noble Lady, Lady Harman, for their personal encouragement, and of course my noble friends, the Leader of the Lords and the Chief Whip. I also wish to thank all the House staff, including the doorkeepers, digital services, catering, post and cleaning staff, for their patience and for so ably showing me the ropes these past few weeks. My job today is to introduce myself and my background and to hopefully make a small contribution in today's debate. My mum and dad came to London from Ireland in the 1950s, moving into a rented flat in Tottenham, the place I came to know as home. I grew up surrounded by aunts, uncles and cousins who all played an important part in my life. My parents were proud to be Irish, and this was not the easiest of times to be Irish, but they also embraced life in Britain, working hard to provide for their family and creating a home. My dad had a minimum of 2 jobs, and my brother and I were instilled with a strong work ethic built on values of fairness, community and respect for others. I left school before completing my A-levels on the early and unexpected death of my dad. My brother and I also had to support our mum, who struggled with her mental health before taking her own life some years later. The deaths of our parents had the biggest impact on our lives. My Lords, I joined the civil service at the most junior grade, and it is why I chose today's debate, and I commend the work of my good friend, the Deputy Prime Minister, and her team for the work and consultation put into this legislation. On joining the civil service, I was not on a mission to work my way to the top. This is probably best illustrated when I took a career break, which has been much commented upon. Put this way, although the civil service encourages its future leaders to get outside experience, running a pub in Newry, County Down in the late 80s was not on their list for outside placements. But a pub is a great place to get to understand communities, their needs, their worries and their aspirations. Throughout my career, I've learned to take the words of the late Joe Cox: we have more in common than that which divides us. On returning to the civil service, I did indeed start working my way up.
Some of the issues I worked on included creating the propriety and ethics function, which included conducting 1 or 2 high-profile investigations, establishing public inquiries into Grenfell Tower and infected blood, where I wish to pay huge credit to the noble lady, the former Prime Minister Baroness May of Maidenhead, for her steadfast commitment to ensuring the truth was told. Initiating the scheme to bring prison leavers into the civil service, where my path first crossed with the trailblazing Lord Timpson, who recognised the importance of giving people a second chance. The Boardroom Apprentice Scheme to encourage people from all backgrounds to serve on the boards of public bodies, an important part of the reform agenda, and goes to the heart of the Opportunities mission. Here I wish to acknowledge the work of the noble Lord Maud of Horsham and the noble lady Baroness Finn, who provided the positive backdrop to allow these initiatives to be developed and flourished. Thank you. Between 2018 and 2021, I undertook the role of Permanent Secretary in the Northern Ireland Executive's Department of Finance. This was a very different experience for me and demonstrates again the range of opportunities that exist in the civil service. The return of the Executive brought its own challenges of working in a mandatory 5-party coalition, which made the 2010 coalition seem remarkably straightforward. Returning to Whitehall in 2021 allowed me to put into practice the benefits of closer and collaborative working with devolved governments and mayors. Devolved government is an important and integral part of the architecture of this country, and the noble lady, Lady Foster, will understand, will be a big part of Northern Ireland in that. I will continue to be a strong advocate for it from my position in your Lordship's House. A number of the senior officials I had the privilege of working with are now members here, and I wish to say a personal thank you for their support. I also want to remember 3 important people in my career who are sadly no longer with us: Baroness Jowell, Lord Prescott and Lord Hayward, exemplars of the very best of public service. I would also like to thank those who guided me in the challenging last few years of my career in and around Downing Street, whether working in it or investigating it. This includes Dave Penman and the FDA team, and I'm not sure what it is about the mention of my time in Downing Street that brings me to the issue of job security and employment. But more seriously, I want to return to my first set of jobs in what was the Department for Social Security, working in employment support, as I think it is highly relevant to today's debate and to the future of our civil service. Back then, I worked with truly heroic and committed people, striving every day in very difficult circumstances to help people in even more challenging situations. They were the civil service at its best, on the front line, as far away from Whitehall's machinations as it's possible to be. Today, I see the same sort of brilliance. What these and other civil servants are doing is central to the government's and the nation's mission to bring back growth into our economy and security to our society. That is why I would caution all of us to be careful, not just about our decisions, but about our language. When we hear the phrases of blobs, pen pushers, axes, chainsaws, and other implements, they hear it too. Yeah. Difficult decisions are needed, of course, and the civil service will be keen to be part of any reform journey, but we need them and other public servants to succeed. I will continue to support a progressive civil service. I hope others will do the same. Thank you. Yeah.
Lord, I'm delighted to follow Lady Gray and to be able to congratulate her on her fascinating maiden speech. She has a long and successful background in the civil service, and she described today some of the things that have affected that experience. My message to ministers is that they would be well advised to take her advice when it comes to how to get the best out of civil servants, because she has been remarkably good at it. I first met Baroness Gray when she was running the propriety and ethics function within government. I was chairing a commission investigating whether the Freedom of Information Act was working as intended. I have to say the group of journalists who spent their time looking at FOI stories regarded her to be the most powerful obstacle in their career. And that was before she was in the public eye. Maybe she wishes she might have stayed there. Instead, she became known everywhere for her forensic talents, which were brought to bear on the Partygate scandal. There was a period when it appeared that no politician could appear on television and face a question without answering, "That is an issue for Sue Gray." She did not seek the job, it was thrust upon her. She carried out that task with great skill and courage. She's a person of immense integrity, a delightful colleague, and she will be a very valuable member of this House. I have to say, I enjoyed also the speech of Baroness Berger. Somewhere I have a photograph of myself with Manu Shinwell in County Durham, aged 16 or thereabouts. And I have very fond memories of that occasion. I also look forward to the maiden speech of the noble Lord Young of Acton. He swells the ranks of members of, it's a very small group, I should say, of this House who have families who support Queen's Park Rangers, and he is very welcome. I enjoy his match reports. I doubt if the manager and the team always feel the same about them, but I suppose that's what is freedom of speech. I also look forward to hearing from Baroness Cash and hope that she also enjoys the experience. Turning to this bill, I'm going to limit my comments to the provision in the bill concerning trade union finances. Clause 59 of the bill would change the way in which trade union members pay the political levy. Under the proposal in the bill, all trade union members will automatically pay the political levy unless they personally take the decision to opt out. I'm concentrating on this because I have been there before. In 2016, the Trade Union Bill of 2016, it introduced by the newly elected Conservative government the proposal to do exactly the opposite. They proposed to move to an opt-in system for political funds, with union members being required to opt in writing if they wish to pay the political levy. Following the Lord's second reading, the noble Lady Baroness Smith, then leader of the opposition, tabled a motion to establish a select committee to consider the impact of the clauses dealing with trade union political funds. The motion was agreed, the committee was appointed, I was asked to be the chairman, and we were given a very short deadline for reporting. The committee took evidence and came to the view that reintroducing an opt-in process for all members could have a sizable negative effect on the number of union members participating in political funds, and that there would be a significant reduction in union payments to the Labour Party. The committee concluded unanimously that the opt-in system should apply to all new members. New members would be required to actively opt in to paying the political levy. But there was disagreement within the committee on whether the opt-in should also apply to existing union members as well, and whether they would remain on an opt-out basis. The majority of the committee thought that the opt-in should not be extended to existing members unless it was part of a wider reform of party funding. In the report, I tabled amendments that new members should opt in and that existing union members should remain on an opt-out basis. This was carried almost on a 2-to-1 basis in this House. Several days later, the government accepted these amendments despite some significant unhappiness on their own side. Given this history, I have to say I am surprised that the new government wished to move back to the pre-2016 position, whereby all members automatically pay the political levy unless they opt out. I had hoped this issue had been laid to rest for the time being, but it appears not. I have some questions for the noble Lord Minister. There is a long tradition of Labour governments legislating for opt-out, while Conservative governments in turn legislate for opt-in. Do we really want this opt-in, opt-out ping-pong to go on with every change of government? Does the government really want to take the risk with the future funding of the Labour Party the next time there is a change of government? Would it not be better to let this issue rest where it is and to maintain the compromise we reached in 2016?
My Lords, it truly is an honour to take a place on these venerable benches and to make my maiden speech today. And I would like to start by congratulating the noble Baronesses Baroness Berger and Baroness Grey for their excellent maiden speeches and no easy acts to follow. But of course, I don't really need to worry too much, I believe, because truly I'm just the warm-up act for Lord Young today. Someone who's already starred in many of his own features in life and a fine colleague. So I look forward also to hearing his maiden speech. I thank noble lords on all sides of the House for the warmest welcome. It is true what everyone says about the courtesy and the embrace when one arrives here. And I'm very grateful also to all of the officials and staff, particularly our dedicated doorkeepers. I'm grateful to my sponsors, some of the finest academic minds and most principled people I know, Baroness Faulkner of Margravine, who is also my chair at the EHRC, and Lord Godson, who has been also a dear friend for nearly 30 years. I'm also grateful to Baroness Finn and Baroness Morris of Bolton. I have two mentors. I haven't dared to ask why they thought I might need double supervision, but I thank them for their courage in stepping up to do it. Since learning I would be joining your lordships, I've received many kind messages and kind words, including rather delightfully from my primary 7 teacher, Ken Cardwell. And that reminded me that when I was 10 years old in his class, he had also once trusted me to make a speech on a subject of my choice on the day of a school inspection. Unaccustomed as I am and have always been to public speaking, I relished this prospect, and he was confident that this particular child would not let him down. When I ran into him 20 years later, the horror was still palpable on his face when he described how I had stood up in front of the class and announced rather cheekily, "I'm not giving a speech today." His heart sank, and there was the most terrible pause until I whisked from behind my back a hand puppet, announced that he is, and proceeded to lecture them all on ventriloquism. I'm not going to be quite as random today, and I've chosen this debate because I have a life that some of you don't know as much about. I've been very lucky to know some of your lordships in parts of my career as a barrister, a parliamentary candidate, or indeed a policy wonk, something I still love. But what is less well known is that I have, for 10 years, prior to now, chaired the UK's leading behavioural science business, which in fact we took onto the stock market. And during that time, I have seen firsthand the challenges of running an SME. We confronted the pandemic. We then had costs ratcheting, salaries insecurity as a result of Ukraine. And now we are looking forward to really strangulating increases in national insurance. I also know from running that business, because we work with 62% of the FTSE 100, that most employers want the best for their employees. It's not a them and us. Talent is what makes businesses work and what makes them grow, and they're highly valued by the majority of people. It saddens me enormously to know so many people in business who are being spoken about in some of the ways we've heard in the other place. But this wasn't my first experience of business. I grew up in Northern Ireland in the 70s. That was the height of the Troubles, but it was also a low ebb for our economy. I spent my early years in the anteroom of a tiny newsagents run by my parents. They worked incredibly long hours, while my father also held down a full-time job. It was not easy, and costs were high. Those micro-businesses, and I owe my parents a world of thanks for the way they worked in theirs, but those micro-businesses provide 33% of the workforce. They employ 33%. That's an enormous number of businesses between 0 to 9 employees. And the consequences of some of the changes introduced in this bill and subjecting those tiny businesses to some of these new ideas is to strangle them. mostly at birth. Costs are rising, taxes are rising, profits, that dirty old word, profits for them are falling. Profits for those businesses are the difference between a pair of trainers for their children, the hope of a family holiday. Are we really going to do that to 33% of the providers of our workforce? From the CBI to the Federation of Small Businesses, every group, every representative group is warning, pleading that the implications of this bill mean a disaster for growth in this country. Yeah. It's not all bad. Of course we want to see more fathers take parental leave. There are other good things, but the overall direction of travel is to create unintended consequences. And if I have learned anything from leading a behavioral science business for 10 years, it is that often the things we want to achieve a certain outcome have exactly the opposite effect. This bill is destined to destroy our growth.
My Lords, it is truly a great honour to follow on from my noble friend Baroness Cash's maiden speech. When I asked those who'd worked with Baroness Cash over the past few years how they would describe her, there was absolute unanimity in their responses. The first thing they all talked about was her courage, brave as a lion, or possibly a lioness, perhaps learnt, as we heard, from growing up in Northern Ireland at the height of the Troubles. But they all said there is no issue that is too hard for my noble friend to tackle, and anything she tackles with single-mindedness and rigour. She was described by The Observer as a modern freedom fighter, and without question she has been a tireless and hugely effective advocate for free speech and for Western values. The second word that is used when talking about my noble friend is forensic. Colleagues have described her to me as intellectually one of the most rigorous and honest people they have worked with, as well as a consummate professional in her approach, and that, of course, is borne out by her track record. My noble friend has excelled in so many different areas, in her work as one of London's most distinguished human rights lawyers, to upholding equality on the board of the HRC, to her leadership of Parent Gym with its practical approach, supporting parents and promoting social mobility. But finally, colleagues talked to me and friends about my noble friend's compassion and her modesty, modesty that we heard in her opening words in your Lordship's house today, and crucially for her ability to build alliances, something that all of us know is so important in our work here. And I know that all noble lords across the House will, like me, be looking forward to working with my noble friend and agree that we are fortunate to have someone with such exceptional experience and skills. Turning to this legislation, my lords, I will confine my remarks to two specific areas of the bill. The first relates to the proposed reintroduction of the school support staff negotiating body, and the second that the bill presents in terms of an opportunity to clarify the employment status of foster carers. On these benches, we support measures to improve the pay and conditions for school support staff who are so vital to the effective running of our academies and our schools. But we have concerns about the impact of the government's proposals in practice. Our worry is that the government's proposals will lead to a significant increase in workload and costs for academies, taking funding away from the front line. For example, the proposal to review and align working hours based on a 12-week reference period will create administrative complexity, particularly for staff on variable hours or term time only contracts, such as midday supervisors, exam invigilators and music tutors, and without an exemption for term time or education-specific roles, this will lead to higher costs and cumbersome recording and averaging systems. The vast majority of academies comply with the National Joint Council for Local Government Services terms and conditions, while retaining a degree of flexibility where needed over local terms and conditions. Can the Noble Baroness, the Minister, reassure the House that this local flexibility will be retained and that the SSNB will not be a one-size-fits-all approach? In my experience, Academy Trusts are using their flexibility to improve conditions for their staff. For example, using the apprenticeship level to allow all support staff to achieve level 3 qualifications, offering support staff 18 weeks of full maternity pay and 8 weeks at half pay. And again, if the Noble Lady, the Minister, could just confirm that nothing in the bill will prevent academies from improving on the terms and conditions agreed by the SSNB if they feel it's in the best interests of staff and pupil. Rather than rigid uniformity, my lords, we need a system that encourages innovation and that benefits pupils and staff. And this is particularly true if we are to deliver the reform of the special educational needs and disability system, where we must retain the ability to innovate and be flexible with our workforce. And finally, the reduction in thresholds for strike ballots and the removal of minimum service levels legislation increases the risk of strike action, which puts the education of our children at risk and will require greater investment in contingency planning. Trusts typically have very good relations with their unions at a local level, but national negotiations are outside their control and risk straining staff relations unnecessarily. Turning to the employment status of foster carers, the Minister in the other place, himself a foster carer, stated it would not need a new clause but a new bill to address this. But as the Noble Baroness, the Minister, will be aware, there are serious concerns among foster carers and among local authorities about the need for clarity on their status to prevent piecemeal definition by the courts. And without this, there is a real risk of a decision at an employment tribunal effectively ending foster provision as we know it. And I would really urge the government not to take this risk, and for the Noble Lady to clarify, firstly, that the government has no intention that foster carers should be defined as employees, and secondly, that she will agree to introduce amendments to this legislation which address this important matter. In closing, I would just like to congratulate all those noble ladies who've already spoken, and if I may offer an apology to the Noble Lady Baroness Grey, who I pestered remorselessly in the many months where I was waiting to know whether I was actually coming to your Lordship's house or whether someone had changed their mind, and she was the only email address I had to contact. I think she had more important things to worry about, but I'm very grateful for her patience.
Could I begin by expressing my congratulations to the Noble Baronesses Berger, Grey and Cash for their maiden speeches today, and I look forward with interest to the maiden speech of the Noble Lord Young. My lords and ladies, I rise to express my wholehearted support for this landmark piece of legislation which aims for the first time in a generation to rebalance the labour market in the direction of fairness. This will not only eradicate some of the grossest injustices suffered by far too many people in recent years, but also drive higher standards across the world of work in place of the race to the bottom. And decent employers have nothing to fear from this. Instead, they will be protected from being undercut by rogue competitors. As Churchill said, where there is, and I quote, no organisation, no parity of bargaining, the good employer is undercut by the bad, and the bad employer is undercut by the worst. Where those conditions prevail, you have not a condition of progress, but a condition of progressive degeneration. Well, the objective of this bill is nothing less than establishing a condition of progress. There are so many groups of workers who stand to gain if this bill is enacted. Those workers who've been fired only to be offered rehiring if they accept a savage cut in their terms and conditions of employment. Those workers unable to get a mortgage or even plan their week-to-week household budget because their income under a zero-hours contract is completely unpredictable and can disappear altogether at the whim of their employer. Victims of sexual harassment, let down by their employer, unprepared to accept their responsibility to take the necessary actions to prevent this kind of totally unacceptable behaviour towards their employees. Many of the provisions in the bill strengthen the legal rights of countless workers currently feeling powerless and vulnerable. But the bill is more ambitious than that, because it rightly recognises that the most powerful force to hold bad employers to account and to uphold workplace legal rights is effective trade unionism. This reality is recognised around the world and upheld in the conventions of the International Labour Organization on freedom of association and collective bargaining. It's a matter of shame that governments led by the party opposite have been found too often to be in breach of these international obligations as a result of crude and unworthy attacks on free trade unionism. So it is wholly proper that the rights for unions to secure employer recognition for bargaining purposes should be strengthened to allow workers to make that free choice. And right, too, that trade unions should have proper access to workers without rogue employers being able to bully them out of exercising their right to effective representation at work. Of course, there are countless good and responsible employers who recognise that respecting and valuing their workforce is the right way to achieve success. They should not be undermined by the irresponsible or malevolent. And surveys have shown how popular this package of progressive change is within the community at large. Millions of people are crying out for change. So let us get this bill on the statute book and begin to change the world for the better.
Yeah. My Lords, I rise to congratulate my noble friends. I'll start with Baroness Cash, who I've known for 35 years when we were students together, and she was elegant then and eloquent, and that will continue. I also am looking forward to my noble friend Lord Young of Acton, as I'm sure he will certainly spice up if we can judge by some of his past publications. I also extend my congratulations to the noble baronesses, Baroness Berger and Baroness Grey of Tottenham. I do actually, without destroying their reputations in this House, consider them to be friends, recognising coming into the House together, but also working with the noble Baroness Grey in government too. I'm sure they will continue to be staunchly upholding their principles as well as contributing to national debate. In terms of national debate, my Lords, this Employment Rights Bill entered the other House after 100 days into the government with 149 pages. After committee, there were 191 pages, and now there are 299 pages presented in this bill, which I think it will be generous to get through in 7 days of committee consideration. But in today's contribution, I want to focus on just a handful. Clause 59, relating to union finances, I do agree with the noble Lord Burns. I really do not understand the trend of all the consumer and legislation protection that we put in, encouraging people to have to opt into contractual arrangements. The default now, by and large, is that you are automatically opted out, and I believe that should be continued. Especially when there is a section in the legislation which suggests that members who haven't opted out should only be reminded every 10 years that they have the opportunity to do so. In terms of consideration of small businesses, I know in particular that the FSB is particularly concerned on two matters. One, the day one risk of taking people on in terms of that there being no statutory probation period yet in law, but also in terms of statutory sick pay. Now, it used to be the case that SSP would be rebated to all employers. I know that because when I worked at Mars, I used to fill out the forms every year getting the refund. However, that got taken away, recognising some of the improvements to be made in occupational health. But with the shift to day one, I think it really is important that the government reconsiders that, or at least does an impact assessment in its consideration. Turning to getting automatic rights on day one of employment about unfair dismissal. We know this already applies through the Equality Act, consideration of people with disability and other protected characteristics. And I do support actually the government's measures of right to try in trying to get people a job. Well, perhaps the same should apply to jobs, to employers. They have a right to try out employees. And I do believe that the statutory period of notice should be put on the face of the bill and not left to regulations. It is important that we continue the work started of the Occupational Health Task Force in order to make sure that we have that positive arrangements in terms of thinking about how people can start, stay and succeed in work. But we do need to remove this uncertainty because I do fear that companies will simply choose not to grow. And I know that from my experience in Suffolk, thinking of potentially some of the flexible working practices, which I understand why the Labour government has chosen to perhaps put even more controls on. But nevertheless, without the support of small businesses, we will not simply get the growth, both in productivity and indeed economic growth more generally. In terms of Fair Pay Agency, I completely welcome the construction of this combination of regulators. I think it's a sensible approach. But I do point to what I consider to Clause 113 to be novel. Well, now, when I asked the Minister of the other House, Justin Madders, he seemed to suggest that the EHRC had similar powers. When I looked at the Equality Act, it actually gives the same powers as what happens in Clause 114, where legal assistance can be provided, including advice, representation, other forms of assistance, but not the situation where the Fair Pay Agency could take a case on behalf of a worker, or indeed somebody who isn't even a worker, someone who's applied for a job, to take it on their behalf. And by the way, in subsection 6, to remove any liability from the Secretary of State towards that same worker. Of course, there will be aspects of recovery, legal costs from the worker. I understand that if a big payout is done, that the government may want to recover the funds it is given. But the regulations do need to change to affirmative rather than negative. And frankly, in Clause 114, who is going to get this money to take people cases to court? Is it going to be the unions? Is it going to be a bunch of law firms? Because that doesn't feel like the approach that we should be seeking to do with taxpayers' money, while admittedly, in other ways, strengthening rights. I should say to the Labour government, I have nothing against trade unions at all. I actually actively encourage people to join them. I think they can do a valuable role. I've never felt the need to do one myself, although it is in my blood, clearly. I looked at the 1921 census. My grandfather was an apprentice shipbuilder. It also noted in the census he was on strike. So it does certainly run through the coffee veins. Indeed, the other people were trade union organisers. But I do think we need to be careful that we do not end up destroying growth rather than promoting it.
My Lord, I must first apologise. I need to honour a long-standing commitment which might oblige me to miss the wind-up speeches. I declare that I'm a lifetime member of the First Division Association, but may I first warmly congratulate the maiden speeches, the 3 so far, and I anticipate with interest the next. It's a pleasure to return to the intricacies of employment law, which I spent much time on a while ago, to welcome this bill, which puts right so many injustices. I won't rehearse the range of provisions which will give back much of the security whose deterioration has so adversely affected the well-being of so many working people. They will be widely welcomed. They are being widely welcomed. I would like, drawing also on my experience as a former member of employment tribunals, to ask my noble friend the Minister questions in two areas. First, can she set out in a bit more detail how the new arrangements for the protection of seafarers, their charter, will be devised? Quite a few seafarers on British ships do not speak English. So how will they and their representatives be consulted? Ships are very dangerous places. In container ships, for instance, so important to our trading economy, seafarers have a higher rate of mortality and of injuries and ill health than workers on land, significantly so among the lower ranks, but, until now, much less legal protection against exploitation, dangerously long hours, and less access to medical care. It is a matter of pride that we can right these wrongs after so long, so clarification would be welcome. My other point is about what is not in the bill. On employment tribunals, many cases of sexual harassment or sackings while pregnant were settled after the first hearing and never proceeded to a full hearing and a decision. I heard of court cases with similar outcomes. There was a non-disclosure agreement instead. In some instances, an immediate settlement sum was so important to the victim that she preferred this, even though the sums might have been paltry. In some, the outlay for carrying on was in any case prohibitive, and quite severe allegations of behaviour, very damaging to the woman concerned, and I only ever saw women in these cases, went unacknowledged, and the perpetrators were never brought to book. That is injustice, Lords. I was heartened to see that in the other place, the Minister, my honourable friend Justin Madders, said, I quote, "We will continue to look at the issues." Can my noble friend the Minister tell us when we can expect this injustice to be addressed, with a provision to override or nullify a non-disclosure agreement if the victim chooses?
My noble lords, I'd like to say how difficult my task is, because I have to follow three such excellent maiden speeches, and I'd like to congratulate the noble lady Baroness Berger, the noble lady Baroness Grey of Tottenham, and my noble friend Baroness Cash. And I'd like to thank Baroness Cash and all the noble lords who've welcomed me with such warm words, particularly the noble Lord Burns, my fellow QPR supporter. I asked various people for advice before thinking about what to say in my maiden speech, and I was given three quite strong pieces of advice. Thank the doorkeepers, praise the people who introduced you, and keep it short. For inspiration, I looked up the maiden speech of my father, Lord Young of Dartington, who was made a life peer by the late noble Lord Callaghan of Cardiff in 1978. But his maiden proved not to be terribly helpful. He forgot to thank the doorkeepers, he didn't praise either of the people who'd introduced him, and he spoke for 18 minutes. My noble lords will be reassured to know that, in that respect at least, I don't intend to follow in his footsteps. So I'd like to thank the doorkeepers, Black Rod and her staff, the clerk of the parliaments and all the clerks, and all the wonderful people who work here and who've gone out of their way to help me when they found me wandering lost along one of the corridors. When I heard the expression corridors of power, I didn't realise there were quite so many corridors of power. I have no sense of direction and have made various errors trying to navigate this place, schoolboy errors. So, for instance, I entered the chamber the other day. I remembered to bow to the throne. I took my place with what I thought was the minimum of fuss. I congratulated myself on having done it, I thought, with some elan. And then a moment later, I got a text message from my noble friend Lord Effingham, which read as follows: Lord Young, on the basis that you have taken the Conservative whip, may I please suggest that you sit on the Conservative benches? I then noticed I was surrounded by Labour peers. When my elevation was announced, I wrote an article in The Spectator in which I said I thought I was only the second child of a life peer to be made a life peer, the other being Lord Brooke of Sutton, the late Lord Brooke of Sutton Manville. But in fact, it turns out I'm not the only child of a life peer to sit in this House, and I would like to take this opportunity to apologise to the following people: Lord Maud of Horsham, Lord Palumbo of Southwark, Lord Pryor of Brampton, Lord Solmes of Fletching, Lord Waltham of Apsley Guise, Baroness Bonham Carter of Yarnbury, Baroness Chisholm of Alpen, Baroness J of Paddington, Baroness Smith of Cluny, Lord Pick Heathley of Camden Town, whose mother, the noble lady Baroness Pick Heathley, is also someone who sits in this House, and Lord Vesey of Didcot. And I really should have remembered that one, because Lord Vesey's father, the late Lord Vesey of Greenwich, was one of the two people that introduced my father in 1978 and whom he forgot to thank. I don't want to make that mistake, so I'd like to thank my noble friend Lord Moynihan of Chelsea and the noble Baroness Lady Fox of Buckley, who I'm also proud to call my close friends. And I'd also like to thank my excellent mentors. Like Baroness Cash, I needed two. So I'd like to thank my noble friends Lady Evans of Bowes Park and, of course, Lord Borwick. So a little bit about myself. As was disclosed, I'm a keen QPR fan, a QPR season ticket holder. I'm the editor-in-chief of the Daily Sceptic, a news publishing site I set up in 2020, and I'm an associate editor of The Spectator, where I've written a weekly column for about 25 years. I'm interested in education, having co-founded one of England's first free schools, as well as 3 other free schools and the Multi-Academy Trust that they now sit within, alongside 5 other schools. And I'm the founder and general secretary of the Free Speech Union, a mass membership public interest body that stands up for the speech rights of its members and campaigns for free speech more widely. And in the past 5 years, with the help, I should say, of our extremely able chairman, my noble friend Lord Biggar, in the past 5 years, the FSU has come to the defence of over 3,500 people, not all of whom share my political views. The FSU really is a non-partisan organisation, and I often find myself defending people whose views I don't share. For instance, I've been a lifelong supporter of Israel ever since my father sent me to a kibbutz when I was 17. My late father-in-law, Ivo Bondi, escaped from Prague in 1939 by the skin of his teeth. He was Jewish, and I was one of the co-founders of the Jewish Friends, the British Friends of Israel, shortly after October 7th. And yet the FSU has come to the defence of several people who found themselves in trouble for their outspoken support of the Palestinian cause. Before I sit down, I want to just say a few words about the bill. One misunderstanding, I think, has arisen about the extension of liability for third-party harassment. This bill doesn't extend employer liability for the sexual harassment by third parties of their employees. Employees are already protected from third-party sexual harassment by the Employment Rights Act 2024. What Clause 20 of this bill does is extend employers' liability for the non-sexual harassment of their employees by third parties, and I fear that that will have a chilling effect on free speech. If you think about it, how will the owners of hospitality businesses, how will publicans protect their employees from being harassed by third parties, given that the Employment Tribunal has defined harassment as including indirect harassment, which includes overheard conversations which aren't necessarily directed at them? How will publicans be expected to protect their employees from overhearing conversations in pubs by customers that they may find offensive or upsetting in virtue of their protected characteristics? When it was suggested in the other place, that pubs might have to employ banter bouncers to police the conversations of customers as one of the reasonable steps that publicans are expected to take to protect their employees from indirect harassment, it was met with derisive, dismissive laughter by the government benches as a sort of ludicrous straw man. But I don't think it is a straw man. Before you dismiss that concern as unduly alarmist, I draw your attention to the briefing published earlier this week by the Equality and Human Rights Commission, so ably chaired by the noble lady Baroness Faulkner. And the EHRC pointed out that employers will have to balance the rights of third parties to express their legally protected beliefs with the rights of their employees not to be harassed. And that's an extremely complicated area of law. And I don't envy publicans trying to get their heads around that. To quote the EHRC briefing, the interaction of the third party's protection from discrimination and the employee's protection from harassment is complex and likely to be challenging for employers to navigate. Challenging for employers to navigate. For challenging, read expensive, since publicans will have to take legal advice about how to limit their liability. And I wonder how many publicans will decide, in the face of all their other difficulties, that this new duty, the cost of complying with it, and the additional risks it entails will mean the game is no longer worth the candle. According to the Campaign for Real Ale, pubs are closing at the rate of 37 a week. And I hope your lordships will think carefully before approving the clause in this bill that I fear will accelerate the erasure of such a vital part of our history and heritage, the good old British pub.
My Lords, what a privilege to follow the fourth of those four outstanding maiden speeches. May I reassure the noble lady Baroness Hazarika that I echo her sense that Baroness Berger's humanity and dignity in the face of extraordinary provocation was an inspiration not only to the many people who uphold the best and most decent tendencies in the Labour Party, but I think to everyone in this country who values tolerance, religious pluralism, civility in public discourse, and the supremacy of parliamentary life. I hope I won't destroy her credibility when I say that of all the people in the independent group, she was the only one I was secretly rooting for during that bizarre moment in our political life. And what a pleasure also to follow my friend of 3.5 decades, the Baroness Cash. I remember seeing a picture of my noble friend, I think in the Observer in about 2009, with the most extraordinary array of lefty lawyers, including, if memory serves, the Baroness Chakrabarti and also the Baroness Kennedy of the Shores. And they were making this great defence of liberty. And that, I think, has been her core belief throughout her political career. Very apt that when she stood for another place, she fought in Westminster, the constituency of both J.S. Mill and of John Wilkes. If there's one precept that this country has developed and exported and contributed thereby to the happiness of humanity, it is personal autonomy. But of course, my real privilege is in following and welcoming my noble friend, Lord Young. He is, I think, a one-man advertisement for the hereditary principle. It's an unfashionable cause to be making at a time like this. He didn't mention that his father was a Labour peer. I mean, you'd have got it if you were listening between the lines. And his father was best known for writing a book called Meritocracy, which he was against. And my noble friend, I think, has had a career that tests the outer limits of what we understand by meritocracy. Actually, right from the start, he got into Oxford on the basis of having received an acceptance letter in error. They posted it by mistake, even though he'd failed to make the grades. And he then successfully argued that they had a moral obligation to take him anyway. And so he went on to have this extraordinary career, which I can really only describe as cinematic. Cinematic, actually, in the literal sense, in that a film was made of my noble friend's life. He was played by Simon Pegg in 2008. I think the only other person I can think of who's had a biopic before he was elected to anything is the current Vice President of the United States, but I'm not going to push that resemblance. And my noble friend then went on again and again to show that quirkiness, that independence of character, and that courage that is, I think, one of our greatest virtues as a people. I mean no disrespect to our political system when I say that you can get to this chamber by being careful and correct and conformist in your views. I know one or two people who have made it to the top in politics by waiting until everyone else has spoken before they express a view, by knowing how to nod sagely and talk slowly. No one would describe my noble friend in such terms. And the two particular causes with which he has been most recently associated, the Free Speech Union and the Critic, which began as an anti-lockdown campaign, showed extraordinary moral courage. Not the simple courage which some people have and some don't, but that readiness, that intellectual readiness to be incredibly unpopular, but to stand by a position that you know to be right. And personally, I have to say, on the lockdown, I remember the days when people were accusing him of being a eugenicist and a mass murderer and all the rest of it. With every day that has passed, he has come to be more and more vindicated. Turning to the bill itself, I can be very brief. I'm afraid, my lords, I find it contains absolutely no redeeming qualities whatever. I could go on at length about what's wrong with it, but I'd be repeating many of the arguments we've already heard, not least from my noble friends Baroness Coffey and Baroness Noakes. I will focus on just one solitary provision, which is the rights to work from day one. I think we are in real danger in this nation of having more and more workers' rights and fewer workers. Because here is an unpopular truth, something that people very rarely like to admit and never really like to verbalize. The way of encouraging people to hire is to make it easier for them to fire. The way in which you encourage employers to take on more staff is to give them the reassurance that they're not going to be stuck with duds or embroiled in weeks and weeks of acrimony for the price of a second-class stamp or an email by somebody who they had then to remove from employment. And that, my lords, has been the secret of our country's success for some 3 decades. Whatever the world has thrown at us, the global financial crisis, the pandemic, structural employment has always been higher here than in Europe, because we have this relative flexibility in our labour market, which means that we bounce back very quickly from downturns because companies are prepared to take people on. And I think that is ceasing to be the case now. I speak as the father of 2 children who are just entering the workplace. I listen to what their friends are saying. If you speak to anyone of that age, there is a palpable freeze now, an uncertainty among employers in anticipation, both of this bill which we're discussing now and the related rise in national insurance. And I have a fear that those 30 years of structurally low unemployment are about to come to an end. You'll be able to look back at my words and laugh at me if I've got this wrong. But I suspect that we're at the beginning of what is going to be a sustained and secular rise in unemployment. As I say, I hope to heaven that I'm mistaken about that. But as Scotland's national poet once said, forward though I canna see, I guess, and fear.
Yeah. My lords, you wait like buses for one Nepo peer to come along. I rise to speak in support of this bill, and I refer the House to my register of interests. Firstly, I want to congratulate all those who have made their first contributions today. The House is blessed with 4 eloquent and distinguished new members, and it is a particular joy to be joined by my noble friends Baroness Berger and Baroness Grey, who acquitted themselves so well, and I look forward to getting to know Baroness Cash and Lord Young. My lords, as an employer and entrepreneur, and through my work with business improvement districts and workspace provision, I have seen firsthand both the challenges and responsibilities of employing people. Good businesses do more than create jobs. They foster opportunity, stability, and prosperity in our communities. For most responsible employers, the principles behind this bill are nothing new. Anyone who has run a business knows that keeping and supporting a great team is a daily concern. Whether it's offering flexibility, ensuring fair treatment, or helping staff through difficult times, most employers already do much of what is set out in this bill, not because they have to, but because a happy, motivated team is the foundation of success. Businesses thrive when their people thrive. That said, rising unemployment costs are a reality. Businesses have adapted to higher minimum wages, pension auto-enrolment and other well-intentioned interventions, all of which add to the cost of employing people. And while these measures bring benefits, they also create pressures, particularly for small businesses, as we have heard already today. The government's impact assessment acknowledges this, but we must be mindful that if costs rise too far, businesses may turn to automation rather than hiring staff. This is not an argument against the bill, but a reminder that to support both employers and employees. In that spirit, could we do more to improve access to insurance products to help businesses manage employment risks, such as covering statutory sick pay? Such products seem rare to me, and it may be worth engaging with people like the Association of British Insurers to explore better provision in this area. We should also consider practical support for businesses adapting to new employment obligations. Could advisory services or incentives help them implement best practices? A culture of shared responsibility between government, businesses and employees will be the key to ensuring these measures work in practice as well as in principle. Ultimately, this bill strengthens workplace rights in a way that is fair and balanced, I believe. It reflects what responsible employers already do while ensuring bad practice is tackled, creating a level playing field for all. Businesses that uphold high standards should not be disadvantaged by those who do not, and legislation like this helps good employment practices, helps to make good employment practices the norm. It is a step forward, and I support it.
My Lords, I add my congratulations to the quartet of maiden speakers today. I think all have laid down a mark, and people will look forward to future contributions that they make in this House. I want to pitch my remarks to some of the messages coming from across the chamber at the moment, almost as though, why have we got this bill in the first place when our wonderful flexible labour market is doing so well? But actually, for me, a key justification for this bill is deep concern about the UK's relative position in the world. Just a couple of OECD figures. Of 40 major economies, we are the most affected by rising inequality. In Europe, only Bulgaria and Lithuania fare worse. The gap between top and bottom earners, of course, in this country continues to soar to some eye-wateringly amounts, which are not always linked to corporate success. When it comes to worker participation in management decision-making, the OECD ranks us 26 out of 28 European countries, propped up only by Latvia and Estonia, doing worse. We're not in the Premier League on these particular measures, are we? We're more like the Vanarama. Of course, if we'd been outstanding economically, as the advocates of deregulated labour markets in the 1980s hoped, if our productivity and investment record had been better, you could justify high unemployment, high inequality and poor participation in management. Perhaps it would have been a price worth paying. But you know, the result has been that we are currently 20% poorer on average than workers in France or Germany, with very different labour markets, with much greater degree of regulation. Now, I could go on making these depressing, unfavourable comparisons, but if some people thought that trade unions were overmighty subjects in the 1970s and 1980s, and many people, I think, did do so and still do so, and that unions could do with a good regular dollop of restrictive legislation loaded on them, I hope that today they will honestly acknowledge that British workers have paid a very heavy price for what has happened since. The flexible labour market and its dark sides, I acknowledge there are some upsides for some people in certain circumstances, but there are many dark sides for others who have very little choice. Lower pay, lower protection, lower skills, poor productivity. This is not a happy picture for our nation, and it's one which the present government have determined to do something about. Now, Mrs Thatcher did not expect the flexible labour market to produce some of these awkward facts, but they have to be actually faced by her successors. Now, the bill strengthens the workers' voice in the workplace, and I hope that that will echo too in boardrooms across the country. It needs to if firms are to prosper as effective communities and teams. The bill should boost job security. It should reduce bad behaviour in a number of areas, a number of abuses in the workplace at the present time. And I commend to Lord Hunt, who I'm happy to renew dialogue with after many years, to have another look at the biography of Stanley Baldwin to see what he did after the general strike and promoting collective bargaining. Now, this bill will put unions in a stronger position. I don't apologise for that. The balance tilts with this bill if it goes through in its present form. And it can help tackle inequality and help and improve, I believe, through that productivity. So we need the bill, and we need it soon.
I too would like to add my thanks and congratulate the four maiden speakers on their excellent speeches. My Lords, this bill marks a significant milestone in the campaign to strengthen employment rights in the UK. For many workers, the measures it contains, Day One rights, enhanced sick pay, protections for unfair dismissal, represents long overdue reforms. But we must ask, how do these reforms serve the backbone of our cultural economy, our freelancers? In the creative industries, over a third of the workforce is freelance. I declare my interest as a freelancer in the visual arts. In sectors such as theatre, film, publishing and design, it's more than 50%. Freelancers contribute billions to our economy and underpin the UK's global cultural reputation. Yet this legislation, while welcome, still leaves too many of them in the margins. The bill includes small measures, such as blacklisting protections, enhanced health and safety requirements, and the right to a written contract, but otherwise offers little in the way of concrete protections for freelancers. There is no guarantee of fair pay, no enforcement of late payments, and no formal route to challenge exploitative contracts or to clarify issues around single worker status. While further consultation is welcome, it must safeguard the creative autonomy and IP rights that freelancers depend upon. A blanket reclassification could cause real harm. I support calls from across the sector by organisations such as DAX, ALCS, BEC2, Creative UK and the Cultural Policy Unit for the creation of a freelance commissioner. A dedicated advocate is needed to ensure freelancers are included in future reforms. Too often they are out of scope, out of protections and out of pocket. However, we must also maintain the balance between protecting individuals and supporting the viability of organisations that employ and commission them. That balance is increasingly fragile. Consider the Royal Society of Arts, where a polarised dispute between unionised staff and leadership over pay has spiralled into reputational damage and breakdown in trust. Or the Tate, a DCMS-sponsored body, which cut nearly 7% of its workforce to manage deficits. The Royal Academy of Arts has warned of cuts to 18% of its staff. Many cultural organisations are operating on the brink, with commercial income still in recovery and reserves depleted. Faced with new obligations, some employers may delay hiring, turn to long-term contractors, or shift work offshore. For agencies and studios, hiring freelancers may appear less risky, potentially increasing short-term opportunities. But without protection, this shift may only deepen insecurities across the sector. This underscores the need for phased consultative implementation and enhanced public funding mechanisms. Rights must be matched by resources. Without support, organisations may reduce opportunities or close altogether. We must act strategically. That means sector-sensitive collective bargaining, better enforcement mechanisms, and targeted support for smaller and mid-sized arts bodies. My Lords, this bill opens a long overdue chapter in employment rights, but for the UK's world-leading creative industries and the freelance workforce which they depend, it must not be the final word. Let us ensure that these reforms support all workers, however they work, and provide the resources needed to sustain the culture we value.
My Lords, we've heard 4 excellent maiden speeches this afternoon, and I would like to add my congratulations to my noble friends Baroness Grey and the noble lady Baroness Berger, and the noble lady Baroness Cash and the noble Lord Young. I'd like to start by reminding the House that this big package of improvements to employment rights has been a long time coming. Governments since 2010 have made promises to upgrade employment rights, and there have been some improvements, but for the most part, the promises made were watered down, delayed or abandoned. But this Labour government is delivering on its promises. As my noble friend the Minister said in her introduction, there have already been extensive consultations on this bill with all interested parties, including, of course, businesses of all sizes. And much of the bill that we now have in its present form represents a balance between different points of view and different interests. And in my short time that I've got, I'll focus on the early sections of the bill that are aiming to end one-sided flexibility. These are the clauses that give workers a right to guaranteed hours and reasonable notice of shifts. They introduce payments where shifts are cancelled or curtailed at short notice, which does frequently happen. These provisions mirror recommendations that were made by the Low Pay Commission in 2018 in a report that was commissioned by the then government, who at that point recognised the problems in the precarious parts of the labour market. These recommendations were not taken forward. Around 2.4 million workers in the UK are on 0 hours or low hours contracts or in agency jobs. And over the last 10 years, there has been a 65% increase in 0 hours contracts. These contracts, of course, suit some workers, as several noble lords have already said this afternoon. And of course, people value flexibility in their employment. But if you're not in control of that flexibility, a 0 hours contract can put impossible pressures on you. And the reforms in this bill aim to remove some of these pressures. They will help solve the very real problems that I came across with increasing frequency over 10 years serving on the Low Pay Commission. Over that period, I and other commissioners spoke to very many low-paid workers, and we spoke to their representatives. And over the years, more and more of these workers told us about the problems that they were experiencing with their erratic hours and erratic earnings, and how they made it impossible for them to plan their lives, manage finances, and get credit. These sorts of hours and volatility can happen right across the labour market, but it's more common for the low-paid, and they don't speak up for themselves because they're afraid of reprisals. And of course, the majority of employers do things the right way, but many of them do not. The bill's provisions will encourage employers to provide work schedules in advance and not to cancel shifts at the last minute or part way through. I recognise there is a lot of concern among employers and among workers about how all this is going to work in practice. A lot of this is going to be sorted out in regulations on which there's going to be a lot more consultation. I find that reassuring, and I hope other people with concerns also find it reassuring that they'll get a chance to express their views as this bill progresses through its stages.
Pleasure to take part in this important second reading debate. Great to see so many noble lords taking part, and particularly welcome and congratulate the maiden speakers. I hope they'll be working with all of us, particularly those on the government benches, to constructively improve this bill. For this is a bill that the Green Party welcomes, and my noble friend Baroness Jones of Moulscombe will shortly be providing a listing of the many points on which we agree. So I'm going to focus on the big picture context in which this bill comes before us. In doing so, I'm going to respectfully but strongly disagree with the pleasantly colourful opening speech of the noble Lord Hunt of Wirral. For what this bill does is modestly, and we Greens would still say inadequately, seek to rebalance the power of workers and employers, a relationship that was thrown profoundly awry under Margaret Thatcher, particularly by strangling the ability of workers to get together in unions to support each other against the power of the bosses, particularly the bosses of large companies. The imbalance was then enhanced by allowing zero-hours contracts and other insecure forms of employment to explode, working hours to extend across many sectors of our economy, something that was not permitted to happen in many of our European neighbours, who benefit now from healthier, happier workers who have the capacity to contribute to their communities and societies generally, as the noble Lord Monks highlighted. We saw the wage share of workers collapse, the rise in inequality, the inefficient and destructive financialisation of our economy, all of which it can be at least in part attributed to failures to make work safe, fair and adequately remunerated. There was a failure to recognise changing social structures, where the previously unpaid and unacknowledged labour of women has been brought into the paid workforce. That work has to fit around the continuing demands they still particularly face. We are people, as the Right Reverend Prelate, the Bishop of Newcastle and Lord Palmer both highlighted, with responsibilities and needs outside work that our working structures do not adequately acknowledge. And the economy is paying the price of this too, with skills, energy and talents excluded by inadequate labour protections. Now, the Blair and Brown governments failed to redress the imbalance between workers and employers created under the Thatcher government. So we are where we are today. They too allowed the minimum wage to drift downward in real terms, subsidising the profits of giant multinational companies in particular, at the cost of us all. As the noble Lord Barber said, we've seen a race to the bottom in employment, and that has to stop. I often hear from the government benches saying they want to get workers into good jobs. Well, we in the Green Party take a different view. We want every job to be a good job, and those that are unavoidably difficult and unpleasant to have the conditions to reflect the conditions of work. We clapped essential workers during the pandemic, but we didn't lift their pay or the respect in which they were held, and this bill has the potential to do much more than it currently does. I invite noble lords to consider the relative position of sewer cleaners and bankers, and what would happen if we didn't have the former working for us all. Now, a fair society, a fair working environment is particularly important in what I've often described as the green areas of the economy. The Climate APPG on Monday had a really interesting meeting about the just transition, and that's something I want to look at in this bill. I'm also greatly concerned about the impacts of new technology on workers, the employers and agency staff at that great parasite Amazon, forced at cost to their health to act like robots, working themselves into the ground, a kind of surveillance that spread to many other areas of work. Workers need the right to breathe at work. Hospitality workers travelling home at night, the Get Me Home Safely campaign, I'm going to work on that. And generally, health and safety at work needs much more attention, and I want to see how we can build this more strongly into this bill.
My Lords, during my time as TUC General Secretary, I met many employers who value good industrial relations and agree terms far above legal minimums. But I also met dedicated care workers who didn't earn enough to give their own children a decent start in life, loyal P&O crew who were fired and replaced with labour paid below the minimum wage, Amazon workers whose boss is running roughshod over the basic British liberty to organise collectively and bargain for better conditions, and teenage workers at McDonald's who faced sexual harassment and even demands for sex for shifts. On that issue, can the Minister please update us on the government's approach to tackling non-disclosure agreements regarding discrimination and harassment? Because frankly, it is obscene that NDAs are used to silence victims and that silence puts workers, especially young women, at risk. The bill has strong public support across the political spectrum, and no wonder. The UK is now an outlier amongst OECD countries for labour standards. On rights for temporary workers, the Work Foundation reports the UK is bottom of the league of 22 OECD nations, only just above the United States. Statutory sick pay is the lowest in Europe, and the lowest paid have been excluded, which means they can't afford to stay home when sick. As we saw during COVID, that endangers public health. Other countries, New Zealand, Italy, France, Germany, and many more, banned exploitative zero-hours contracts long ago, but the UK did not. Under the Conservative government, rights failed to keep up with the pace of the gig economy. In fact, Conservatives worsened protection against unfair dismissal, some sex discrimination rights, and the human right to withdraw your labour. The party opposite claimed that tilting the balance back towards workers would be bad for business. Nonsense. On the contrary, there is strong evidence that fairness at work boosts both productivity and innovation. In the UK, too many people are stuck in a revolving door of low-skilled, insecure jobs and unemployment. This bill will promote better quality jobs and positive flexibility so that more carers and people with disabilities or poor mental health get the chance to get work and stay. Of course, individual rights need effective collective enforcement. That's why it's so important that this bill also strengthens rights to organise and to be represented by a trade union. Finally, a word on the UK-EU trade deal, the mother of all costs to business. According to the London School of Economics, trade barriers have hit small businesses hardest. 14% stopped exporting to the EU altogether. One reason why we ended up with a second-class trade deal is because the EU feared unfair competition, that the UK would undercut them with worse workers' rights. The Conservative government's broken promise to bring forward an employment bill and a tax on trade unions only confirmed that suspicion. Now, this bill can help ease EU fears and support negotiations for a better deal. That is just one more reason why this bill is good for jobs, good for workers, and good for business too.
My congratulations to the excellent four maiden speeches that we've been privileged to listen to in the course of this debate. My Lords, I would like to focus on a small section of this very wide-ranging bill concerned with the establishment of an adult social care negotiating body in England and social care negotiating bodies in Scotland and Wales. In particular, a well-trained adult social workforce
especially for those living with dementia, is both important and long overdue. I declare my interest as co-chair of the all-party group on dementia and as an Alzheimer's Society ambassador. According to the explanatory notes accompanying the bill, the government hopes that sectoral agreements to be negotiated by the social care negotiating bodies will help to address the ongoing recruitment and retention crisis in the social care sector, and this will in turn support the delivery of high-quality care. However, despite the beneficial impact on recruitment and retention of adult social care workers, education and training are not currently specified as matters for the negotiating bodies to consider. Last year's State of Adult Social Care Sector report by Skills for Care stated, access to training was among the top 5 reasons influencing retention. Turnover rates were 7.4 lower for those who did receive training than for those who did not. There is evidence that lack of learning and development is given as a reason to leave. Ensuring that adult social care workers, the adult social care workforce is able to access high-quality training is not only crucial for recruitment and retention, it's also essential for ensuring the delivery of high-quality care for those who need it. This is particularly true for almost 1 million people living with dementia in the UK today, a high proportion of them needing that essential social care. For example, 70% of residents in residential care have dementia, and we know this figure is going to rise. It's therefore shocking that only 29% of adult social care staff in England are recorded as having undertaken dementia training, and that no legal requirement exists for them to do so. The Alzheimer's Society are calling for dementia training to be made mandatory for all adult social care staff, and I agree. My Lords, I intend to table amendment at committee stage which would include education and training within the remit of the social care negotiating bodies. This would send a positive signal to the sector, to people who draw on care, about the importance the government and this House accords to the training and education of the social care workforce. It would also bring social care negotiating bodies in line with that of school support staff negotiating body, which does have training within its remit. I look forward to more detailed discussion at committee stage.
My Lords, like others, I would like to congratulate all of those making their maiden speeches today. They were absolutely brilliant. And my Lords, I too speak in favour of this bill. How often have we heard myths extolling the virtues of a society with a light touch, a society where markets prevail and benefits trickle down? For so many, the reality is so far different. Profits, yes, but made at the expense of vulnerable workers. Loopholes exploited. A compliant workforce with few protections. Trade union rights stripped back. And the result? Almost 7 million citizens in severely insecure work. Of those, almost 4 million workers on universal credit. The UK shamed earlier this year the 8th most unequal economy out of the 40 studied. And that is why this bill is so important. A bill creating stepping stones towards building a modern workforce. New measures to tackle insecure work, scrutiny of procurement with the two-tier workforce agreement restored, enhanced rights against unfair dismissal, contracts reflecting the hours worked. But most of all, this bill lays the foundations of a modern system of industrial relations. Social partnership, not conflict at its core, tackling some of the most intractable issues facing our economy. The school support staff negotiating body restored, the key to professional recognition for a group of workers overlooked for so long. That nothing could be more significant than the proposals to transform social care. Social care so close to breaking point, weighed down by a toxic combination of chronic underfunding and dysfunctional markets. Over 130,000 social care jobs unfilled, 25% annual turnover, 400,000 social care workers living on the verge of poverty, travelling time not paid, 14-hour shifts, 0 hours contracts, little, if any, career progression. And meanwhile, on average, 4,000 people every day are not able to leave hospital because of the lack of care. This bill heralds the action so desperately needed, creating the Fair Work Agency and the first pay agreement in adult social care in England. My Lords, today as we speak, an employer in Knowsley, Live Housing, is a stark reminder of why this bill is so important. Faced with legitimate action for fair pay, Live Housing does not engage. It does not look into the underlying causes of the dispute. Instead, it offers a pay increase only to non-union workers and to those willing to give up their union. It threatens outsourcing, brings in strike-breaking companies, Dickensian tactics, bully boy tactics, which cannot be fair by any standard. And I would ask my noble friend the Minister to urgently look into what is happening in Live Housing. My Lords, this bill is our chance to instil fairness back into the workplace, to restore balance, to ensure workers are treated with dignity and that their contribution is valued, especially those at Live Housing. It is a bill which makes a profound and positive difference to people's lives. Our chance to make a difference, our chance to secure a better life at work.
My Lords, can I place on record my thanks to the 4 maiden speakers and also to the 3 former TUC General Secretaries who've joined us for this debate, not to mention the last speaker, the Noble Lord Prentice, whose union was always very helpful to me when I was David Cameron's envoy to the TU movement. I will declare an interest. I'm the president of BALPA, the Pilots Union, which is the TUC-affiliated union. I don't think I'd be giving many secrets away if I said that the majority of our members are probably voting Conservative at most elections. Most people don't join trade unions for political reasons. They join trade unions because they want to have looked after. They want to have someone to consult if times get rough. But the other thing is, most of them join because you get a good car discount on your car insurance and you get a free legal advice service. My subs to AUEW TAS, which is now part of Unite, were covered completely by the amount of money I got off my car insurance. And just to rub it home a little bit, the legal service was excellent. My children went to a private school. We once got into a bit of trouble with the bursar, who was trying to pull a fast one. I rang the union legal service, and a very helpful solicitor drafted me a letter. And I said, I dare say you're not used to helping your members challenge private schools. And I always remember his reply. He said, Sir, we are not here to judge the members, we're here to help them. And, you know, those two facts about unions are a great comfort to many ordinary people who have to work for their living. But I'd also say, I've known quite a lot of Prime Ministers. The only Conservative one I thought was on the right track was Ted Heath. And I think if things had turned out differently, this party might well have a somewhat different relationship. I also got to know Ted quite well after he'd retired, because he used to enjoy coming to Brussels, and where they're so obsessive about having political balance, I was about the only Labour Party member willing to sit next to him at dinner. So we had lots of very interesting conversations. I welcome this bill. I'm probably the only one on this side who does, because I think it clears up a lot of anomalies that need clearing up. I served 25 years in the European Parliament, and I saw their European trade unionism based on the papal encyclical Rerum Novarum, where you respect the rights of workers. And it's as simple as that. But I do think if we're going to move forward, the TU movement itself is going to have to change. You've got to get Conservatives into the annual Congress. You've got to make them come and explain what they're up to, not have them as the hate figure on the wall. And the TU movement itself has got to look at how it deals with the 1/3 of its members who vote for the Conservative Party. That is as much a challenge as our challenge to pass this law and make things better for the workers.
I declare an interest as a freelance TV producer. My Lords, I welcome aspects of this bill. It does much to improve the rights and status of millions of employees and workers in this country, at a time when holding down a job is increasingly precarious. In particular, I welcome the changes to zero-hours contract arrangements. I understand this will create some extra burdens for SMEs, which need flexibility, but it will give important security to many low-paid workers. However, I, like many other lords, am worried that much of this bill is reliant on Henry VIII powers. I hope the noble lady, the Minister, will listen to these concerns. In firming up employees' rights, I'd like the government to look at umbrella companies, which are being used increasingly in the supply chains to pay workers. They're seen by clients and recruitment agencies as useful because the umbrella company, not the actual company for which the individual is working, is the employer and responsible for PAYE. My concern is that these umbrella companies are not regulated. Their lack of transparency means it's unclear whether they're treating workers fairly, not applying hidden charges or withholding benefits workers are entitled to. In far too many cases, clients which use umbrella companies do not always carry out due diligence on them. I'd be grateful if the noble lady, the Minister, would tell the House whether the Fair Work Agency, which is being set up, will have a role in overseeing umbrella companies to ensure that they're compliant and transparent, and to ensure that non-compliant umbrella companies do not enter the work supply chain. My Lords, this is the Employment Rights Bill, so it deals with employees, but I echo my noble friend Lord Freiberg when I ask the government to take seriously the rights of the self-employed as well. They're a growing part of the workforce. There are over 4.1 million self-employed workers in this country, over 500,000 of which are self-employed mothers. They contributed £366 billion to the UK economy last year. The Labour Party policy paper, Make Work Pay, says Labour is the party of self-employed and recognises their significant contribution to the UK economy. It promises to strengthen rights for self-employed and deal with many issues which have long dogged the freelance world, such as the right to a written contract, action on late payments, and health and safety protections for the self-employed. In bringing this bill to Parliament, I ask the government to be aware of the danger of widening the gap between the employed and the self-employed, the gap between the rights enjoyed by the employees and those of the self-employed, who lack protection for sick leave, parental leave, and protections against unfair dismissal. This needs to be a major consideration for the government. I understand the current definition of employment under common law employment tax rules are vague and open to interpretation, which can lead to conflict, often ending up in the tax tribunal. So I welcome the Deputy Prime Minister in her second reading speech on this bill in the other place, saying there were plans to set up a single category of worker to amalgamate the employee and the worker's status. However, I ask the Minister to be aware of the concerns of the self-employed from creating a single status of worker. This could disadvantage freelancers who make up much of the workforce, especially in the creative industries. The nature of their work means they bob in and out of all these current employment statuses. The single category must incorporate this flexibility in employment. And I too add my support for setting up of a freelance commissioner who could sort through these concerns and report to government. There's one final issue which I'd like to draw to your Lordship's attention, that of unpaid internships. I made my maiden speech some time ago against this scourge on our employment landscape. It's particularly prevalent in the creative industries and creates a serious barrier to social mobility. Can the noble lady, the Minister, tell the House whether there are plans to ban all unpaid internships longer than 4 weeks? Our economy can only thrive if it's accessible to people from all backgrounds. I hope that the government will follow this bill with many of the pledges in Make Work Pay paper to ensure that the UK maximises the opportunities for our workforce and safeguards the positions of workers, whatever their employment status.
My Lords, it gives me great pleasure to participate in this debate, and I thank the noble lady, the Minister, my noble friend, for her introductory comments. She mentioned in that introduction the clauses in the bill which relate to equal pay, and I'm very pleased to hear that, but I must urge with words of caution and remind the House that it's 50 years this year excuse me, since the Equal Pay Act was put onto the statute book, and as she said in her opening comments, we still have a 13% pay gap as between men and women workers. It's been my true belief for many years that whilst the legislation is of course absolutely hugely important, we can't do without it, legislation on its own doesn't do the trick. And my experience of the introduction of positive action programs, which I can just very briefly explain to the House, has made a very important difference in a number of areas. During the last Labour government, we had introduced a programme following the work of the Women and Work Commission, which worked with the various employment sectors, worked with the employers in those sectors, where we identified women who had the ability and the desire to improve their situation in the workplace. Many, many women take up jobs not necessarily at the top end of their ability, but jobs which fix in with their family commitments. Those commitments may decrease over the years as the children get older and women are stuck with those positions. So giving those women the opportunity to upskill, to train and retrain, and therefore move further up the salary ladder has been an exercise which has proved extremely fruitful. Interestingly, in that exercise, more money was put into the delivery of the programme by employers than it was by government. Employers loved it. In the very short time that it was allowed to be, over 25,000 women benefited from the programme, and I would like to hear comments from my noble friend as to whether or not the current government would consider looking at some kind of positive action programme to ensure that the legislation we have on the books is actually able to benefit women and to make a difference. And very quickly, the other side of things on the positive action front is looking at the situation of girls and boys in school. and identifying ways in which girls learn differently to boys. There was a programme that ran called Computer Classes for Girls, and that was teaching girls about computers in quite big detail, in ways which they felt better and more comfortable at assimilating that information, and therefore giving them the skills to move into work that was going to be more highly paid for them. So I hope the noble lady will be able to tell the House that she's open to ideas on this front, and that we can therefore see some true movement on the equal pay front.
I'd like to welcome our 4 new colleagues after excellent speeches, and I look forward to their future contributions. Now, obviously, I agree with everything that my noble friend, Lady Bennett Manicastle, said earlier. We do, surprisingly enough, support this bill in its general purpose, because we like the fact it's making fairness at work a priority, and well done to the trade unions for actually making sure this has never slipped off the public agenda. Because at the moment we've got a divided and very unequal society, and this bill does help restore a bit of balance in the workspace. Without that balance of power, we will forever have working class people going to food banks and claiming universal credit because their paid work doesn't give them either a living wage or job security. Because we have a two-tier economy. The rich have been getting richer much faster, while the rest of us are stuck or going backwards. And these two facts are obviously linked. Last year, the collective wealth of the UK's small band of billionaires increased by about 35 million a day. And meanwhile, according to the IFS, the past 15 years have been the worst for income growth in generations. Like many, I was appalled by the Spring statement. It means that the situation I've just described will get much worse. However, we will support the changes that Labour are putting forward, but it is nowhere near enough to really change things and make the majority of people better off. The duty we all have in your Lordship's House is to fill the gaps in the bill, to make it work for everyone in society, but especially the poorest. And to do that, you have to end the rip-off by privatised services like water industry and energy suppliers. You need rent controls and more social housing. You need a wealth tax and a more equal society. So one of our amendments, for example, will be to introduce a maximum 10-to-1 pay ratio so that no worker should see their CEO getting paid more in a day than they do in an entire year. The point being, you can pay your CEO whatever you like as long as the cleaner gets 10% of that. Plus, if you want more productivity in this country, then you must value your staff. If you want to lower the tax burden, then you must end the corruption that comes with privatised procurement, contracts and services. And then, of course, we have to protect whistleblowers, we have to protect SMEs. There's a surprising amount in this bill that could have been taken straight from the Green Party election manifesto. Loads of very common sense ideas. I want to congratulate the Labour Party for perhaps casting an eye over what we've said. For example, a fair deal for those working in adult social care, enhanced rights from day one, quality auditing and sick pay. This employment rights bill could turn the tide on the undermining of employment rights that's taken place since the 1980s. It's time to recognise that stronger collective bargaining rights and better working conditions can be good for both workers and for businesses. But it isn't complete. The government clearly needs some help in further drafting, and this House is the perfect place to do that.
Hear, hear.
My Lords, it's a pleasure to rise and speak in support of this much needed legislation. And it's a pleasure also to have an opportunity, following the Noble Baroness Jones, to remind her that much of this bill was in our manifesto. We have a strong mandate, I remind the Conservative benches, for this particular. It's been a pleasure, my Lords, also to follow so many powerful contributions based on expertise and deep engagement on these issues. But mindful of time and the likely duration of proceedings at committee and report stage, I shall focus my remarks on just a couple of headline measures in this bill and the backdrop against which they are being introduced. But before I do that, I want to congratulate my noble friend Baroness Lady Jones of Whitchurch for her introductory speech. This is a very complicated and large piece of legislation, and I thought she made a great job of delivering an explanation of the most important parts of it in her introductory speech. I also want to associate myself with the congratulations to a bevy of maiden speakers and Lord Young. I apologise that I have insufficient time to go into the detail of the remarks I would like to make about all of those speakers. I thought their speeches were excellent, but I'll have another opportunity to compliment them, I know, in the future. My Lords, we know over the last 16 years that the productivity gap between the UK and France, Germany and the United States has doubled. Anyone who's walked past the newspaper stand or turned on the news over the last couple of months will be aware that we've a record number of economically inactive people through ill health, and that business has in recent years reported significant labour shortages. This is quite an inheritance. But I'm confident that the legislation before your Lordship's House is a real and substantive step towards engaging these challenges. To take the productivity gap first, when we ask ourselves what has caused our anaemic rate of productivity growth compared with our neighbours, we're often told that the government needs to get out of the way, and that a thicket of workers' protections is dampening the spirit of capitalism. My Lords, over the last 14 years of Conservative-led government, I long ago lost count of the number of ministerial promises to kindle bonfires of red tape, take an axe to red tape or some similarly strenuous deregulatory measure. It's clear that either successive Conservative-led governments over the last 14 years have failed by their own metric or simply were acting on an entirely false premise. Building on the words of my noble friend Lord Bunks, according to research by Cambridge Judge Business School, there's been a consistent and growing negative gap between labour law protections in the UK compared with those enjoyed by workers in other OECD countries, including France and Germany, at whose productivity rates we've cast such envious eyes in recent years. According to this research, the gap in protections began significantly to widen in 2010, the year a Conservative-led coalition took office, and what appeared were key divergences including working time, wider labour protections and laws impeding legitimate industrial action. This bill makes a substantive contribution to closing that gap. There are most celebratory remarks I would like to make in that context, but time debars me. Instead, I'll focus on one, the provisions relating to fire and rehire. Your Lordship's House will recall the most egregious example of this when the P&O Ferries instituted mass redundancies in March 2022. In response, the then Bays Minister described the practice of fire rehire as deceitful and disgraceful, and vowed that the government would stand up for workers against these appalling actions. What slingshot of redress did the Conservative government choose to employ against this Goliath of inequity? A code of practice, a voluntary code of practice that impinged upon employers only at the point a case reached tribunal. The measures in this bill are far stronger, forcing employers who engage in fire rehire to demonstrate that they have made exhaustive efforts to find an alternative, and to demonstrate that an alternative course would cause severe financial harm to the company. That sounds to me like a much better way of dealing with this than was offered to those people. My Lords, I should like now also to engage the second element of this government's challenging inheritance, the number of people currently economically inactive owing to illness. Again, there are competing theories around the causes of this. Some believe that this country has some inherent aversion to hard work. Among them, the Shadow Home Secretary, who recently suggested British people need a better work ethic. But a deeper look at the figures, and those are ONS figures, belies this interpretation. Alongside mental health, musculoskeletal disorders are the biggest cause of long-term unemployment. Which professions are most likely to be impacted by musculoskeletal disorders? Manufacturing, construction and transport and storage. There's a huge and structural disparity, in some cases over 3 times greater, between the number of long-term sick who previously occupied these professions compared with jobs in IT, science or professional jobs or public administration. These structural inequities will need wider treatment than falls within the scope of this legislation, but measures which improve protections around sick pay, End exploitative zero-hours contracts and strengthened workers' rights are a step in the right direction. The question of workplace culture may be a wider discussion, but one which speaks to the spirit underlying this bill.
My Lords, I declare my interest as an employee of a very large American insurance broker. This bill is deeply concerning, especially considering the recent legislative changes, such as the $25 billion raised through national insurance contributions and the 6.7% increase in the national living wage coming into effect next week. These developments are already creating significant challenges for businesses. Together with the regulations in this bill, they highlight a troubling anti-business and anti-growth stance that risks undermining the foundations of the business community. While the bill aims to support workers and create a fairer society, it comes with substantial costs for many businesses, particularly small and medium-sized enterprises. These businesses will struggle to absorb these additional expenses without negative consequences. The key question is, how can business continue to grow and create jobs when burdened by such regulatory costs? One of the many of this enormous bill's provisions is the introduction of a separate legal status for probation periods, alongside the removal of the qualifying period for unfair dismissal. This means businesses could face tribunal claims even during an employee's probationary period. Although the government has proposed a lighter touch approach for probation, the details are yet to be fully determined and will depend on future consultations and secondary legislation. With tribunal times waiting times already long, 18 to 24 months, it's crucial to ensure that weak claims are dismissed promptly to avoid further strain on business. Whatever happens, it's more costs. Moreover, the bill introduces reforms to zero-hour contracts, including the right for workers on low-hour contracts to receive a contract reflecting hours worked in the previous 12 weeks. However, the definition of low hours remains unclear, and this uncertainty adds to complexity for businesses in managing their workforce. Additionally, the bill suggests allowing businesses to offer fixed-term contracts during high-demand periods instead of permanent contracts. If regulated effectively, this could help businesses better manage fluctuating demand. However, shifting the responsibility onto businesses to track when such rights are triggered and offer contracts adds another layer of administrative burden. The bill's provisions on dismissal and re-engagement could also complicate restructuring efforts, potentially limiting a business's ability to adapt to the changing market conditions, such as office relocations or adjustments to working conditions. I will only briefly mention the harassment by third parties clause, which my new noble friend Lord Young of Acton has addressed so well. But I believe these put businesses in a near impossible position in trying to protect their colleagues and staff. It is essential that we find a balance between protecting workers' rights and ensuring that businesses remain competitive, innovative, agile and responsive to the challenges of a rapidly changing domestic economy. These changes, combined with the risks associated with permanent contracts, reduced flexibility in workforce restructuring, and higher compliance costs, create a challenging environment for business. The government must ensure these policies do not stifle the growth and job creation that the country needs. The anti-business and anti-growth narrative emerging from these legislative changes requires careful scrutiny. We must ensure that businesses are not overwhelmed by unnecessary bureaucracy and red tape. A thriving business environment is not only beneficial for business, but also essential for the broader economy and the growth that this country desperately needs.
Please stick to time, 4 minutes, thank you.
My Lords, I want to congratulate the 4 maiden speakers who made their maiden speeches today. They were excellent. My Lords, in passing this bill, the House will restore the UK's reputation as a nation which supports fair treatment of ordinary people in the workplace and the right of unions to take democratically determined action where necessary to employs bad employment practice and to repeal the most egregious aspects of the previous government's anti-trade union legislation, which Baroness Jones, in her introduction to the bill in this House today, rightly called punitive. My Lords, in 1919, the UK was a founding member of the International Labour Organization. Despite this proud history, the previous government severely damaged the UK's record on employment rights, passing legislation which attempted to curb the ability of unions and union members to secure better working lives for ordinary people. The ILO's Committee of Experts on the Application of Conventions and Recommendations repeatedly commented on the previous government's flouting of commitments as an ILO member. In 2022, the committee noted with regret the then government's belief that the measures it had put in place to protect striking workers from employer retribution were sufficient. The committee urged the government to review the legislation in full consultation with workers and employers' organisations to strengthen the protection available to workers who staged official and lawfully organised industrial action, and to provide the committee with information on the steps it had taken in this regard. No action was taken by the then government on this recommendation. In 2023, the committee noted with serious concern the development and implementation of minimum service level guarantees. It made clear its expectation that in preparing its regulations and other guidance, including codes of practice, the government would ensure that any minimum level guarantees imposed on industrial action in the transport and education sectors was indeed minimum, and that the government would ensure the participation of all social partners in its determination. And where no agreement was reached, it would ensure that it was determined by an independent body which had the confidence of all parties. My Lords, no action was taken by the previous government on these recommendations. In May 2023, the House of Commons Joint Committee on Human Rights found that the minimum service legislation, which made it easier to sack striking workers and left unions at risk of £1 million fines, did not appear to be justified and needed to be reconsidered. The committee found that it would be possible to introduce minimum service levels in some sectors in a way that was more likely to be compliant with human rights law. The then government took no action to respond to the committee's concerns. In May 2024, in a landmark case taken by Unison, the Supreme Court ruled that the UK trade union legislation was incompatible with the European Convention on Human Rights in failing to prohibit detriment, short of dismissal, for taking part in lawful industrial action. My Lords, this sorry history of blatantly anti-trade union legislation, whose clear and unlawful purpose was to take away individual and collective rights at work, shows why the bill being debated in this House today is so necessary. And that, my Lords, is why I support this bill and commend it to the House.
Yeah. My Lords, in principle, I welcome this bill's aspiration to enhance protection of workers' rights. But one nagging doubt, ploughing through this huge, red tape-laden, unwieldy legislation, how does it fulfil its boast to modernise employment rights and make them fit for the modern world? To me, it seems bizarrely out of sync with shifts in modern workplace culture. For example, we're told by government that more sick leave entitlement aims to, quote, reduce the number of infections in the workplace, boosting productivity and benefiting business. Really? Has the Minister not noticed the crisis created by large swathes of workers too readily not going into work, pleading sickness, stress, etc.? Also, surely making flexible working a default position will exacerbate the modern fashion for working from home as a regressive retreat from collective workplace solidarity. It's hard to cultivate a one-for-all, all-for-one culture from the individualised isolation of your bedroom office, a privilege, by the way, only accessible to white-collar workers. On trade unions, I'm delighted to see the back of the ludicrous Strikes Minimum Service Levels Act, which I argued against in this chamber. But I'm also worried that modern trade unions aren't fit for purpose. Their ideological priorities seem to often put them at odds with their members. I thought of this listening to today's maiden speeches. And by the way, a warm welcome to the Baronesses Cash, Berger and Gray. This chamber always benefits from more feisty women. But let me focus on the noble Lord Young of Acton, the founder of the Free Speech Union, which invaluably defends workers' rights when facing a specifically modern form of employer mistreatment, i.e. being punished or sacked merely for expressing legal, if dissident, viewpoints. The FSU is necessary because, tragically, too many, particularly public sector, union bureaucrats seem to have been radicalised by the toxic ideology of identity politics. Trade union officials often act as the censorious enforcers of HR departments' equality, diversity and inclusion policies, policing their members' speech rather than protecting their rights, the very opposite of the role the noble Lord Balfe described earlier. One example, Unison Conference passed a motion pledging to combat so-called, quote, gender-critical narratives and distributed materials that conflated sex realist perspectives with far-right extremism. No surprise then, a group of nurses from County Durham, more feisty women that I like, have been forced to set up their own Darlington Nurses Union. They're taking the NHS Trust to an employment tribunal, alleging the hospital's HR department intimidated and harassed them when they objected to sharing their female changing room with a biological male who identifies as a trans woman. The official nursing unions were useless, instead repeating their NHS bosses' inclusion mantras. Yesterday, Sussex University was rightly fined over £500,000 for failing to protect Professor Kathleen Stock's free speech. But don't forget, as Professor Stock noted at the time, it was her own Sussex University Union, backed up by the National UCU and General Secretary Joe O'Grady, who threw her under the bus. Things are so bad, members are taking unions to court. Two academics, Deirdre O'Neill and Michael Wayne, the makers of the film Adult Human Female, have lodged a tribunal action against the UCU for viewpoint discrimination after campus branches blocked screenings. Meanwhile, Rick Pryor, chair of the Metropolitan Police Federation, is taking legal action against his union. He was locked out of his union email and suspended after a TV interview suggesting many of his 30,000 rank-and-file officers are increasingly nervous about challenging people from ethnic minorities. To note, the Met's Professional Standards Department concluded his remarks did not amount to misconduct. These trends reflect the modern world of trade unionism. If these remain unacknowledged and this bill uncritically extends the bureaucrats' powers, it might well not help but hinder workers' rights.
Lords, I congratulate my noble friend the Minister for the elegant exposition of the bill in opening today. I also congratulate our four maiden speakers for their excellent contributions. And like Lord Balfe, I enjoyed the contributions of no less than three former General Secretaries of the TUC and one former AGS of the TUC. Lords, in this debate I appear as Oliver Twist. Whilst, like others, I express gratitude for the bill in place of the starvation rations given to workers by the previous government, I ask for more. The bill will confer many benefits on our 34 million workforce, but it's a long way short of the full but hardly gastronomic menu in Labour's Green Paper, A New Deal for Working People, drafted by a committee to which I had the honour to be legal adviser and chaired by Andy MacDonald MP. A New Deal was adopted by the Labour Conference in 2021, reaffirmed in 2022, reiterated in Labour's plan to make work pay, delivering a new deal for working people, and referenced in both the election manifesto and the King's speech. Lord's, time permits me to raise only two of the many items left off the Bill of Fare. Both are essential to increase pay and hence demand in the economy. Both are vital to substitute negotiation for litigation. The first is sectoral collective bargaining. In other words, collective bargaining between unions and multiple employers to reach a collective agreement setting minimum terms across a particular sector, called a fair pay agreement. A New Deal committed to introduce them across the economy. Labour's plan to make work pay promised, quote, to start by establishing a new fair pay agreement in the adult social care sector, unquote. The election manifesto referred to this fair pay agreement as a sector collective agreement. In contrast, the bill makes no provision for sector-wide collective bargaining in any part of the economy. Instead, it expressly provides that the school support staff negotiating body does not constitute collective bargaining and its outputs are not collective agreements. For the adult social care negotiating body, the Minister has regulatory power to so rule. In any event, ministerial control over these bodies' membership, terms of reference and manner of working, with unfettered power to override any agreement or disagreement, completely negates the definition of free collective bargaining both in statutory and in international law. Lords, my second issue is the right to strike. The bill sweeps away the Minimum Service Level Act and most of the Trade Union Act 2016. It simplifies notice and extends ballot mandate. The government is to be congratulated, but the bill does not remove the anti-union legislation of the 1980s, which hamstrings unions and has led to a near collapse in collective agreement coverage. That legislation is incompatible in a number of respects with our ratified obligations under ILO Convention 87 and Article 6.4 of the European Social Charter. This is not a matter of opinion. The supervisory bodies have so held consistently since 1989, as my noble friends Lord Barber and Baroness Bousted have mentioned. A New Deal committed this party to bring our law on industrial action into line with our international legal obligations. It's a rule of law issue. The bill will need amendment accordingly. Lords, nevertheless, the grace and eloquence of my noble friend, the Minister, makes her singularly ill-fitted to play Mr. Bumble.
My Lords, can I add my congratulations to the quad of maiden speakers we've had in our debate today. In 4 minutes, you need to cut to the chase, so that's what I'll do. I'm not someone that believes that any improvement to employment rights negatively impacts employers or the economy. But as the government itself has said, it's all about balance. And too many of the provisions in this bill have got the balance wrong, including the day one right on unfair dismissal. And the government itself recognises this. That's why it's committed to introducing a probationary period, but we have no detail on how this would work. And that's just one of many examples in this bill where the detail's not developed and employers have serious concerns. But, my Lords, not only has the government got the balance wrong in this bill, at the same time, they failed to address one of the biggest imbalances in employment rights we have, and that's on paternity leave. In the UK, we give mothers 52 weeks of maternity leave and fathers just 2, the lowest level of paternity leave across Europe. And take-up of that 2 weeks is lowest amongst dads on low pay, as the rate of pay for that leave is so poor. The noble lady, the Minister, said that new action plans would help close the gender pay gap. Well, my Lords, we can be confident that they will lead to plans, but less confident that they will lead to action. Instead, more generous paternity leave has demonstrated that it can close the gender pay gap. It's also good for fathers, for children, and importantly, good for the economy. ILO research shows it can contribute 2 to 3% of GDP. I know the government intends to do a review on this, but there's already been an evaluation and a consultation, so now is not the time for another review. It is time for action. The other imbalance I want to address is the increase in compliance costs for businesses doing the right thing, whilst leaving significant loopholes allowing labour market abuse. Substitution clauses have traditionally been used to give small businesses flexibility, but there is increasing evidence that they are being abused by contractors to gig economy businesses. With its substitution clauses, Amazon tells couriers that it's their responsibility to pay your substitute at any rate agreed with them, and you must ensure any substitute has the right to work in the UK. My Lords, this is clearly not happening. During random checks 2 years ago, the Home Office found that 2 in 5 delivery riders who were stopped were working illegally. And from late 2018 to early 2019, there were 14,000 fraudulent Uber journeys, according to TfL. It is not right to pass responsibility for compliance with criminal and right-to-work checks onto workers. The introduction of a comprehensive register of all dependent contractors would help to ensure employment rights are upheld, pay is not suppressed through illegitimate competition, and support the enforcement of right-to-work checks. And if the Noble Lady, the Minister, will not listen to me, perhaps she will listen to the app drivers and couriers union, who say, unfortunately, there is this loophole that allows some bad people to come through. They're not vetted, so could do anything. My Lords, I hope the Noble Lady, the Minister, will take action to address the balance of this bill. At the moment, it risks damaging jobs and growth, whilst at the same time fails to address some of the most significant flaws we have in our labour market today.
Well done. My Lords, this bill is very welcome, especially the provisions aimed at tackling poor job security. Recent research underlines the importance of job security to workers and the effects insecurity can have on the well-being of low-paid workers. One way in which this bill enhances security is through the welcome improvements to statutory sick pay. However, there is an unintended consequence, a loss for some of the lowest paid employees, especially women and disabled people, who are sick too long to be compensated by payment of SSP from day one of sickness. While it's true that, as the Minister told the Commons, most employees will not be worse off, surely the aim of such a change should be to leave no low-paid employee worse off. I can't believe that the government intended this. It's also disappointing that there's no indication of any future increase in the SSP rate, as the continued payment at such a low rate, which came into sharp relief during the pandemic, will blunt the impact the positive changes will have. In her letter to peers, my noble friend the Minister emphasised that the bill places the family at its heart by increasing the baseline set of rights for employees with parental or other caring responsibilities. As it's still largely women who bear the main burden of balancing paid work and caring responsibilities, it's women who will benefit most. But there are some holes here that I hope it might be possible to fill, and perhaps here I stand as Olivia Twist. The first concerns carers' leave. Carers are now entitled to 5 days leave a year, but as we've heard, it's unpaid, so many carers simply can't afford to take it. The case for paid leave rests not simply on the huge difference it would make to the lives, health and well-being of carers, the social and moral case, but also on the strong economic and business case made by employers such as TSB. The government's own estimate of the economic cost of caring in terms of lost production puts it at a massive £37 billion a year. Just a couple of years ago, a frontbench spokesman told the Commons the next Labour government will be committed to introducing a right to paid carers' leave. But recently at report stage, the Minister could only say that because the right to unpaid leave was enacted recently, we are reviewing this measure and considering whether further support is required. Now, I accept that the government has to consider how paid leave should be designed, not least because we can learn from other countries. But what is there to consider with regard to the need for further support, given we already have ample evidence? Surely we can show our commitment to unpaid carers by writing into the bill an in-principle provision to introduce paid leave. This would be in line with its spirit and with the government's missions, not least the pursuit of economic growth, while demonstrating support for a group at considerable risk of poverty. The other main hole, my Lords, concerns parental and paternity leave raised by the noble Baroness Lady Penn. The Women's Budget Group, of which I'm a member, in welcoming the bill as potentially an important contribution to a more gender-equal economy, also warns that it needs to tackle the unequal distribution of unpaid care work and structural inequalities, because unpaid care is the root cause of women's economic inequality. I've long argued that parental leave, with a period restricted to fathers on a use it or lose it basis, is a key social policy lever here, good for mothers, fathers and children. Instead, the current shared parental leave scheme is a joke, with only about 4% of fathers having used it at the last count. In the Commons, the Minister confirmed the promised review of parental leave, but separate from the bill. But why is it separate? A firm declaration of intent in the bill to reform parental leave with the aim of strengthening the rights of fathers would send a message to men and boys in the face of concern that they feel undervalued. A final hole concerns stronger workplace rights for domestic abuse survivors. The APPG for domestic violence and abuse, of which I'm an officer, calls for an obligation to be placed on employers to take reasonable steps to support employees affected by domestic abuse in place of the much weaker existing advisory statutory provision, which it would seem many employers ignore. In conclusion, my lords, I strongly support this bill, but I hope we can fill the holes I've identified in line with the government commissions without affecting its basic architecture.
My Lords, it's a pleasure to follow my noble friend Baroness Lister, and I hope the government in this bill or elsewhere follow up some of those points. It's a matter of urgency. My Lords, I am prone to write my speech at the last minute. When I noticed I was number 41 of speakers, I wondered what the hell I could actually say that was original. And I turned to a paper I had received but not read before, which was a submission to the TUC about worker conditions and trade union rights. And it compared rights here with the average situation in the OECD. And it showed systematically that the average position in all OECD countries for both individual rights and trade union collective rights was substantially better in the OECD countries than it was here. And this covered a whole range of areas, from things like hours of work, holidays, conditions of employment, dismissals, overtime, and collective aspects such as union recognition, collective bargaining, and the rules covering strike action. There were differences between different countries, but on average, every single item, bar one, or two actually, was better in the rest of the OECD than it is with us. The one exception was redundancy provision, which means you walk away with more money in the UK, but it also makes redundancy more likely in the UK. My Lords, this was systematic through the whole range of conditions. And there is one other macro feature of the difference between our workforce and workforce in other OECD countries. Can you guess it? Its productivity has risen far faster in those countries on average than it has here. I would say there is at least some degree of causal relationship between the terms and conditions in which the workers and unions operate with employers and the fact that their productivity has risen substantially faster. And I think the government and all of those who purport to speak for British employers and British industry in a hysterical way about the provision in this bill should actually address that, because it is a serious contribution. Improved productivity will be a serious contribution towards our growth targets and towards the betterment of our economy as a whole. My Lords, I think that is the macro point which speakers opposite have failed to recognise and need to. I just wanted to mention another couple of points. I am a little unclear, and perhaps my noble friend the Minister could clarify quite what the Fair Wage Agency is going to do and how far it replaces other agencies. I speak as the Minister who, when I was responsible for agriculture, seized on a private member's bill to introduce the Gangmasters Licensing Authority, which has to some extent brought some order to what is a feature of modern slavery. We're going to have a debate on modern slavery tomorrow, so I won't go too far into that. But one of the difficulties of not having direct regulators and enforcement agencies and having too large a responsibility for one new quango is that some of the injustices that arise and which are identified in my noble friend Baroness O'Grady's committee on modern slavery will not be tackled. So I'd like more detail on what the Fair Wages Agency is going to do and how it relates to existing bodies. My last point, I was never General Secretary of the TUC for some reason, but I was General Secretary of the Labour Party, and therefore I warmed to Lord Burns' point about political levy. I did sit on this committee for a part of its time, and I largely agreed that we needed to tackle the question of political funding more broadly, not only on the basis of the political levy, but on a way in which our political parties are in total financed. That goes beyond this bill considerably, but it does need addressing. And to continue to switch in-out in terms of opting in and opting out of political levy is not the way to deal with it.
My Lords, firstly, many congratulations to the 4 great maiden speeches we've heard this afternoon, which on a long afternoon were both impressive and, more importantly, I think very enjoyable. On a more serious note now, my Lords, we have heard yesterday that the Chancellor's spring statement, the immediate economic outlook for the country is grim. For a government that claims to champion growth, it is alarming just in 8 months. Business confidence has all but evaporated. Regulation has begun to strangle and stifle free enterprise. And before us today, we have but yet another example of poorly thought out legislation which, if passed in its current form, will completely undermine the agility and responsiveness of the private sector to deliver jobs and create growth. Turning to the bill itself, I want to pick up just a couple of points. And I share all the cross-sector concern around guaranteed hours. In this area, if it's left unamended, the government will be threatening the very viability of the jobs that this bill aims to protect. Exactly. I fear that the provisions covering guaranteed hours will ultimately lead to fewer people being able to get on the employment ladder in the first place, and that this section of the bill will ultimately disadvantage young people at the start of their working lives. Employers will respond, inevitably, by limiting many of the opportunities needed by young people to gain experience, test their interests in different roles and industries. And for them to do that, employers need to have a lot of flexibility. And of course, if that is too risky, they will just not do it. Government should urgently clarify and define what is meant by low hours, and bring forward mechanisms by which employees should be able to opt out of guaranteed hours, much like the individual ability to opt out of the Working Time Directive, when they feel content with their individual working arrangements. This bill, my Lords, will have a damning effect on the British manufacturing industry. Against a backdrop of rising costs, global competition, supply chain pressure and tariffs, rigid staffing models will tie the hands of our manufacturers and ultimately undermine the UK's global competitiveness. I therefore urge the government to hear the concerns that are being raised by manufacturing industries at this time, particularly in relation to zero-hour contracts and the notice period around industrial action. As it stands, this bill is an attack on flexibility and misses the opportunity to modernise working practices. The harsh reality of the current economic conditions mean that businesses will have to rapidly adapt to meet the new burdens presented by the bill. With the already crippling effects of national insurance increases, the plethora of excessive regulation imposed by this government, I can only foresee the legislation forcing the hand of employers to make redundancies, reduce employment opportunities, and increase the use of automation. And the application of artificial intelligence will, of course, replace people. As government makes it more and more problematic and costly to employ people, businesses will be forced to respond by limiting new job creation. No matter, my Lords, how much government attempt to dress up this bill as progress, the reality is that this legislation is a reckless intervention that threatens the very sectors that are vital to our economic recovery. The bill is shutting the door on employment prospects for students, carers and parents who want and need flexibility with their employment. The government is hell-bent on waging war against private enterprise, and I, for one, will certainly vote against it on every opportunity. but I am afraid that this bill is going to come to epitomise Labour's road to our economic ruin.
My Lords, I congratulate all four maiden speakers. My Lords, like my noble friends Lords Freiberg and Colville, I will concentrate my remarks on workers who are largely not covered by this bill, but are a significant part of the workforce. They are the freelancers, including the self-employed. I will make particular reference to the arts and creative industries, and I thank Dax, Beck2 and Equity for their briefings. I also declare an interest as a self-employed artist. My Lords, there are 4.39 million self-employed workers in this country, representing just under 14% of the workforce. There was a dip during COVID where many freelancers fell through the gaps of government support. But the reality is that this is a long-term expanding workforce that the government needs to ensure employment rights for. Freelancers underpin the creative industries, our second most important sector economically, and one that the government has pledged to support. 80% of musicians are freelancers, for example. They have an especial importance in that what affects freelancers will affect the sector as a whole, because the creative industries are an ecosystem. Consequently, freelancers have a significance within the workforce that far exceeds their numbers. Therefore, my Lords, a truly modern employment rights bill would have properly included the rights of freelancers and the self-employed, for many of whom that status fits the nature of their work. I acknowledge the argument about the complexities of freelance work around tax issues, including concerns around IR35, but there is also a concern about the comprehensiveness of rights in terms of the single worker status. So I ask the Minister, how will that status accommodate freelance workers with that mix of self-employed, PAYE employees and Limb B workers? My Lords, I do, however, welcome this very necessary bill for employees. Most European countries have banned 0 hours contracts, and we certainly need measures in place that help employees, but at the same time will not restrict their opportunities to work, a key consideration. Guaranteed hours will benefit many in the creative industries. However, there are various groups within the creative industries, including employees on short-term contracts and casually contracted workers, such as cinema workers, front of house and other workers in theatres, for example, who may be pushed against their will into self-employment without then the same employment rights as they had, at least currently. I ask the Minister, will the government monitor this kind of a potential effect, and how will rights be properly enforced from within the new body? Beck2 point out that in terms of parental rights, sick pay, pensions, equalities and other areas in this bill, the rights of self-employed workers, and I quote, lag far behind that of employees. Will the government introduce these rights for self-employed workers? What will be the timescale for doing so? Equally, what are the government's plans for their manifesto commitments of blacklisting protections, health and safety protection and the right to a written contract for the self-employed? My Lords, much of the creative industries support the appointment of a freelance commissioner. It is also a recommendation of the Culture, Media and Sport Committee. Such a commissioner ought, of course, to be responsible not just for the creative industries, but the whole landscape of freelance work. And that should also extend beyond the particular concerns of employment rights to include the equally urgent concerns around pay and opportunities. And as many organisations have pointed out, there is very little data on the freelance workforce, the collection of which should be a major aspect of this remit. In the same way the two departments of DBT and DWP have an involvement in this bill, DCMS should certainly have an input into both the role of a freelance commissioner, if one is appointed. They, after all, have a working party on this issue, as the Minister will be aware, and any future legislation around the self-employed, as indeed should the creative industries themselves be involved as well.
I congratulate all 4 new members on their maiden speeches today. I'd also like to thank the many members who have raised the importance of introducing paid leave for carers. Having experience being an unpaid carer myself, I have lived the very realities of working while caring. I welcome the bill as a significant step forward for workers. However, I will be focusing my remarks today on where it falls short in addressing sexual harassment and violence in the workplace. A 2023 TUC poll revealed that 3 in 5 women have experienced sexual harassment, bullying or verbal abuse at work, with the figure rising to almost 2/3 among women aged 25 to 34. 4 out of 5 women do not report the sexual harassment that they have experienced. And many workers leave their jobs rather than report it. The End Not Defend Sexual Harassment campaign highlights that young women, disabled workers and those from BME backgrounds are disproportionately affected due to their overrepresentation in precarious employment. This underscores the urgent need for measures outlined in clauses 19 to 22 of this bill. While amending the Employment Rights Act of 1996 to protect whistleblowers and requiring employers to take reasonable steps to prevent harassment is a positive move, these measures may not go far enough. Limiting interventions to sexual harassment may leave victims and potential victims of other gender-based violence in the workplace outside the bill's protections. And questions remain about how non-compliance will be enforced. By amending the Equality Act, the Equality and Human Rights Commission is understood to be the regulator here. But as it stands, they have limited enforcement powers, and its mandate limits its ability to address the health and safety implications of violence against women in the workplace, regulating only sexual harassment. A more effective solution would be to treat gender-based violence and harassment in the workplace as a health and safety issue. Under the Health and Safety at Work Act 1974, employers already have a duty to protect employees' health and safety. By amending this act, we could ensure that gender-based violence is explicitly covered as an enforceable health and safety measure, overseen by the Health and Safety Executive. The Health and Safety Executive already has the authority to inspect, fine and prosecute employers for non-compliance, offering a structured and enforceable approach to safeguarding employees, particularly women, from violence in the workplace. The Noble Lord de Clifford noted earlier concerns in relation to the clauses on harassment. However, the Health and Safety Executive has a track record on providing training and guidance, so this could be an alternative way forward. And despite years of government promises, the epidemic of violence against women and girls continues to worsen. And according to a critical January report from the National Audit Office, to end this behaviour in the workplace, we must confront misogynist culture directly. His Majesty's government's goal to halve violence against women and girls by the end of the decade demands nothing less. So I look forward to the Minister's response today and would appreciate further clarification on the enforceability of non-compliance under clauses 19 to 22, as well as measures to address gender-based violence at work. I also look forward to engaging with all members during committee on this very topic, but also along with paid leave for carers, improving paternity leave and addressing the gaps in sick pay.
My Lords, it's a pleasure, as always, to follow Baroness Smith of Llanfaes. I add my congratulations also to my noble friend, the Minister, and to today's 4 maidens. May they thrive in their new place of work, if not technically employment. As the noble Baroness Prosser so ably reminded us, this December will mark 50 years since the implementation of the Equal Pay Act. Still, the gender pay gap for all employees was 13% last year, and highest in our much celebrated and lucrative financial sector. At grave risk of being hit by a thunderbolt, may I suggest that the 1970 Act contained a fatal design flaw that has been replicated in its successor statute, the Equality Act. For my Lords, it's left to an individual woman worker, with or without the aid of her union, though in recent years some unions have done valiant work on this, to A, find out what her male colleagues are being paid for the same work or work of equivalent value, and B, in the event of disparity, to sue her employer. My Lords, with respect, for most women, that scenario is cloud cuckoo land. I hope, noble lords, who've heard me raise this during previous International Women's Months of March, will forgive the repetition. But as legislators, would we dream of providing such a paltry enforcement mechanism in any other vital area of regulation? Would we leave children to investigate and litigate school standards, consumers individually to police food standards, and citizens to do the same for environmental protection or building or nuclear safety with no relevant state enforcement agency, even as a backstop? Surely the time has come to right this historic and continuing wrong. And even, my lords, the most zealous free marketeers can't seriously advocate impunity for employers who routinely and exploitatively discriminate against women or other groups in the context of remuneration for work. My lords, HMRC already has access to payroll information for tax purposes, so it can't be beyond the wit of policymakers to extend that remit and purpose to random spot checking for equal pay as well. Indeed, my lords, this is one area where AI tools could come to the aid of employees rather than being a threat to them. Discrepancies could then trigger closer investigation, warning notices, and eventual penalties in the event of persistent non-compliance and illegality. I know that many have focused their equal pay efforts on pay transparency duties for larger employers, but this seems to me to simultaneously lack both realism and ambition. Again, would we allow food or drugs manufacturers, whatever their size, to market products unfit for consumption as long as they were labelled? So, my lords, I ask my noble friend the Minister what plans His Majesty's Government has in this area. Might, for example, Schedule 7 to the bill be amended, or regulations under the new Section 78A of the Equality Act be made to add equal pay provisions for state enforcement? Or are there plans for a separate statute in this Parliament? Will my noble friend meet with me and some of the unions and lawyers who have been working on this problem? My lords, is it finally time for a dream made in Dagenham in 1968 to be fulfilled in Westminster?
Yeah. My lords, it is an honour to follow the Baroness Chakrabarti, whose work I greatly admire, and please may I add my hearty congratulations and warm welcome to the four who gave such brilliant maiden speeches earlier today. I would like to make two contributions to the debate, one general and one specific. First, as a business leader, there is much that I welcome in this bill. My current roles are detailed in the register. Previously, I was CEO of an investment firm for 15 years, during which time pre-tax profits grew almost eightfold, or 15% a year, and that was including over the financial crisis. That success and resilience was thanks to a talented team, loyal and committed to the business, largely, I believe, because they were treated well. It was not a large business, but, for example, we offered enhanced maternity leave from day one, and staff could request flexible working fully 12 years before that being required by law. Of course, as a business leader, I am very conscious of the need to limit burdens on firms, but high employee commitment and engagement is also key to the bottom line. UK annual employee turnover is currently 34%, according to the CIPD. A third of workers are so disengaged they leave within 12 months, and the cost of replacing them is huge, up to twice the outgoing employee's annual salary. So I do not agree with the objections, including from various business lobby groups, that this bill will layer on costs without benefits. It requires a raising of standards in how employees are treated, especially the low-paid and vulnerable, such as pregnant women. Treating people decently is something that should be the norm day one, but sadly, not all firms currently do that or show any inclination to do so voluntarily. If employees feel treated fairly, in my first-hand experience, they will more than repay this in loyalty and increased productivity, things this country badly needs. Just one example where a long-term vision, not a short-term spreadsheet, paid dividends for Aviva, which introduced 6 months equal paid parental leave in 2017 for both men and women. I asked them how they budgeted for this groundbreaking policy, and they said they didn't actually know what the cost would be, but knew employees with happy family lives would be more likely to stay and develop their careers at Aviva, and they decided they should do it. The policy has been a resounding success. Men take up an average 5 months paternity leave, and there's great talent, attraction and retention. The costs to the firm have been more than offset by benefits, including lower recruitment expenses. My second point is specific and concerns the protection from harassment clauses 19 to 22. Their lordships will be familiar with the high-profile sexual harassment cases that they read about in the press. That's the tip of the iceberg. I chair the Diversity Project, and we have a confidential safe space for people to report poor behaviours. It's been going on for about 2 years now, and more than 30 reports have been submitted, 90% from women, and their accounts show that sexual harassment remains a problem. All too often, non-disclosure agreements, or NDAs, are used to buy silence rather than address behaviours. At the Diversity Project's International Women's Day event, I asked the audience, who are women in the city, whether NDAs should be banned for sexual harassment cases. The response was split 50-50. There are situations where a victim may decide she has to leave a company after what's happened. An NDA can provide confidentiality and finance while she looks for a new role. I then asked whether people would prefer a more nuanced approach, only allowing NDAs for sexual harassment cases under certain circumstances. In Irish law, NDAs are banned for sexual harassment cases except where the victim requests one and has taken legal advice. In addition, I suggested independent investigation into serious incidences and a standard template for board oversight. At present, boards don't even receive this information. They surely should. This proposal met with 85% vote in favour. And the consensus was strong around requiring regulators to ensure bad apples are not put back in the system. We know that happens. 100% of those at our events said the FCA and PRA should give clear examples of unacceptable behaviours. So I will be proposing amendments to restrict the use of NDAs for sexual harassment. There has been support and debate in this in the other place. Their lordships now have the opportunity to create stronger protections from sexual harassments in the workplace. And that, I hope, is something all members of the House, men and women, whatever their political affiliations, can agree on.
Can I just start by congratulating the noble Baroness Lady Morrissey on his remarks, raising an extremely important issue which I hope we will pursue in detail during the progress of the bill. I welcome the bill. I congratulate my noble friend the Minister on her introduction of this important, excellent and timely piece of legislation. I could spend my whole 4 minutes pointing out the excellent content of the bill. I hope she will forgive me if I raise 3 issues which I think the committee will need to look at closely. First, I will be going through the bill line by line, as they say, to check that pensions are given their due place within the legislation. Secondly, statutory sick pay. I would urge all noble members to read the excellent briefing from Mind, pointing out the importance of statutory sick pay in tackling the scourge of mental ill health, and in particular the way in which it should be structured in order to facilitate return to work and removing cliff edges. The third issue, which we will need to look at carefully during the committee stage, is Part 3, the section on collective bargaining. Although the word negotiating appears in the introduction to each section, I still need to be convinced that the actual provisions within each section deliver the grounds for proper negotiating. It's quite clear that it doesn't fulfil the definition of free collective bargaining, and I think we're going to need to look at that in some detail. I would also say, I heard the comments of the Noble Lord Lonsborough at the beginning of this debate. I want to contest the idea that it's only people who have been successful in business who know anything about how the economy works. Yeah. Now, I stand on this side of the chamber surrounded by giants of the trade union movement. Speaking as a lowly assistant at the TUC, I'm staggered by the quantity of expertise and knowledge that's available speaking in support of this bill. But of course, it's not just the General Secretaries, it's not just the senior officials, it's the whole layers of paid and lay officials who work on behalf of their members. This doesn't get the publicity that it should, but they are working tirelessly and hard on behalf of their members, and it's that experience in companies, in undertaking day-to-day industrial relations, which has informed this bill. And that's why it will be a success, because people suggest that it's going to be against economic growth. Economic growth depends on the workers. It depends on them having good conditions of work. It depends on them having security. And that's why this bill is in favour of economic growth.
My Lords, I'm going to confine my engagement with this bill and my remarks to whistleblowing protection and to NDAs, and I intend to bring forward amendments in these areas, as well as hopefully joining on amendments by others, especially Lord Wills, and I hope very much Baroness Morrissey. That's my colleague in the other place, Leila Moran, brought forward the NDA sexual harassment amendment that's in the other place. My Lords, I've long argued that existing protection for whistleblowers under the Public Interest Disclosure Act of 1999, PIDA for short, is wholly inadequate. The inadequacy is in part because PIDA is drafted as employment law, limiting the remedies to workers and seeking redress through an employment tribunal. And that's a great injustice to the many whistleblowers that in law the term whistleblower is restricted only to those categorised as workers. In contrast, and somewhat confusing matters, this House will know that HMRC has recently relaunched a significantly improved whistleblower reward scheme which invites any citizen with evidence of fraud to come forward as a whistleblower. HMRC is not alone. The CMA has a long-standing incentivised scheme for citizen whistleblowers, and now the Serious Fraud Office is also looking to incentivise citizen whistleblowers. My Lord, all of this, in a sense, we've got the enforcement agencies freelancing to try and deal with the problems in PIDA, but it gives us an opportunity, I think, to redesign the whistleblowing framework and remove the barriers that PIDA, I'm sure unintentionally, originally created. But the problems go well beyond just who is covered by PIDA, a law that few, even lawyers, really understand, as demonstrated by the alarmingly low rate of whistleblower cases that succeed in employment tribunal. About 4% of those that are brought on people who are recognised and acknowledged by everyone in the room to be whistleblowers, but they can't carry their cases through. The employment tribunal process is tortuous. It pits a whistleblower with limited resources, limited knowledge, and little, if any, legal assistance, even when there's trade union support, against an organisation with often unlimited resources and expert legal counsel. It exhausts and impoverishes whistleblowers by allowing cases to be dragged out for years. It requires the whistleblower to provide conclusive evidence to prove that they were dismissed because of whistleblowing. And the tribunal is not concerned in any way to see that the wrongdoing identified by a whistleblower is investigated. The entire system is set up to encourage whistleblowers to settle their case, and more often than not, they have no choice but to sign settlements containing non-disclosure agreements. They're known in the UK as confidentiality clauses. The NDA acts as a tool to enforce silence and suppress evidence of harm to the public. And we've heard how in sexual harassment cases it plays that key role. Among amendments I will bring, I intend to include an office of the whistleblower structured as a hub to work with regulators and enforcement. It will be a place where whistleblowers that can confidentially and anonymously deposit information and evidence of wrongdoing without fear of retaliation. It will be in a position to identify significant patterns of wrongdoing, such as the Post Office Horizon scandal. It would have helped so much in sexual harassment cases by making sure they were pulled together and visible in one place. It will have the power to impose remedies and compensation where whistleblowers suffer detriment. Now, I'd prefer it to sit under the Cabinet Office, but I've probably got no choice but to put it under Trade and Industry. My Lords, I know I'm going slightly over time, so let me just say this. I'm also supporting the duty of candour, and the folks behind that move, which is crucial, are also supporting the office of the whistleblower.
Hear, hear.
My Lords, I would like to congratulate all my colleagues on their maiden speeches, Baroness Berger, Gray and Cash and Lord Young. It was a pleasure to hear them and to be looking forward to working with them on this bill and on other issues. Also, I would like to thank all of those outside bodies who were kind enough to send me briefings for today's debate and for the continuation of the bill. My Lords, I'm pleased to support the Employment Rights Bill, a long overdue step towards modernising our labour laws, ensuring fairness in the workplace and building an economy that works for everyone, businesses, workers and communities alike. My Lords, for too long, our employment laws have failed to keep pace with the realities of modern work. Between 2010 and 2024, we saw relatively very little new employment legislation, despite profound economic and workforce changes. The key framework governing employment rights, the Employment Rights Act of 1996, dates back nearly 30 years. While the world clock has evolved, our laws have not. My Lords, this bill is about ensuring that the UK labour market is fit for the future of a labour market that delivers security, flexibility and, of course, dignity in work. A central pillar to the bill is ensuring that workers can balance employment with their family responsibilities. Today, too many parents, particularly mothers, are forced to choose between their jobs and their children. A survey by the law firm Slater and Gordon found that 6 in 10 mothers felt sidelined from the moment they revealed that they were pregnant. Additionally, a third of managers surveyed preferred, listen to this, hiring men in their 20s or 30s over women of the same age, a disgrace, fearing potential maternity leave. The bill will strengthen protection for pregnant women and new mothers, ensuring the future of this country can be fairly looked after. My Lords, additionally, making paternity leave and paternal leave available from day one of employment will have a significant impact. A study of examining Sweden's 2012 paternal leave reform, which allowed fathers up to 30 days of flexible leave during the child's first year, found significant benefits for maternal health. Specifically, where there was a reduction in anti-anxiety prescriptions, a decrease in hospitalisation or special visits, and a drop in antidioxin prescriptions amongst new mothers in their first 6 months. These improvements are attributed to the father's increased presence, my Lords, providing support, allowing mothers to rest and seek preventive care. Bereavement leave is another crucial reform. Losing a loved one is one of the most difficult experiences anyone can endure. Yet, too many workers are forced to return to work before they are ready because they do not qualify for leave. This bill will ensure, my Lords, that bereavement leave is a universal right from day one, offering workers the time and dignity to grieve. This bill will also strengthen protectors against workplace harassment and discrimination issues that disproportionately affect women. A survey by the Trade Union Congress found that 52% women had experienced sexual harassment at work, a number that raises to 63% for women aged between 18 and 24. The bill introduces new duties to employers to prevent harassment while they are simply reacting when it happens, creating a culture of accountability and safety. We need a complete ban on non-disclosure agreements in cases of sexual harassment, in cases of bullying, and in cases of general discrimination against people at work. it is really important that victims are no longer silenced. We really have to take this issue fervently. In addition, the introduction of gender and menopause action plans is a necessary step forward. Right now, 1 in 10 women in the UK... Sorry, I have to stop. I'm sorry, I can't go on.
My Lords, I declare my interests as a businessman and investor, and I welcome the excellent maiden speeches of my hereditarily noble friend, Lord Young of Acton, by my poised and articulate noble friend, the Baroness Cash, and by the 2 other noble baronesses. I also apologise that with the noble minister's kind agreement, I may have to leave before the winding up. My Lords, good economic policy brings prosperity, security and jobs. The government says economic growth is its #1 priority. Does this bill promote growth, which needs a low regulation, low tax, small government, free market environment? No, it does not. When this government came to power, it succumbed to the time-honoured temptation to focus on demand, not least by giving selected supporters on above-inflation pay raises. Demand is an attractive policy because it pursues the covetable votes of the UK's over 50 million adult consumers. Supply, which a government seeking growth should have more properly focused on, attracts just the 5 million votes or so from employers and sole proprietors. Demand stimulation, however, quickly runs up against funding new spend with available tax receipts. Tax hikes are made, hoping that tax will go up above its current 36% of GDP, but it obstinately hasn't. Government expenditures and regulation are going up, but so too are departures from this country. Entrepreneurs, high earners and achievers, young strivers, all those current and future wealth creators who would have stayed and grown the economy had a supply-side approach been taken. Even though the Chancellor U-turned yesterday, the OBR cut its 2% GDP growth projection to 1%. That's still too optimistic, yet even 1% GDP growth means about 0 growth per capita. And my Lords, there was an unmentioned elephant yesterday, this very bill. Here's what the OBR said about it. In this forecast, they said, we have not incorporated any impact of the government's plan to make work pay. They then go on to say that the impact on GDP of this bill should be negative, which drops their growth projection to below 1%. After last year's budget, the economy slowed to a halt just as we had warned it would. Now, every piece of this vast new bill seems designed directly to further ruin the economy. Banning zero-hour contracts, letting the union fox into the SME henhouse, the right to request flexible working, no waiting period on statutory sick pay, ditto on parental and bereavement leave, and unfair dismissal. Each claims virtue, my Lords, but in reality damages economic growth and jobs. My Lords, what will the economic consequences of Labour be? Higher unemployment, especially youth, lower general prosperity, many individual recessions as GDP per capita declines, an alarming prospect for the country's future fiscal stability. Yes, my Lords, it may feel good to have a heart, but it's more important to have a head.
My Lords, I too welcome new colleagues into this House, and I wish them well in their work as members. And I also want to congratulate the Minister on her introduction of this important piece of legislation. The world of work has changed, and the expectations of workers, especially women, have also changed. I want to endorse very strongly the speech that has been made by Baroness, who bears my name, my first name certainly. Let me just remind myself. It's Baroness Morrissey, Helena Morrissey, as I understand it. But Baroness Morrissey made a speech about non-disclosure agreements, and I'm going to endorse all that she has said about the ways in which their misuse to silence complainants who have been sexually harassed or bullied or face discrimination in the workplace has been a problem that we've seen expressed and exposed time after time in our press. And I, as chair of a number of inquiries, have seen how it affects lives in the workplace directly. Non-disclosure agreements have undoubtedly an important place in employment. It's a way of protecting intellectual property of an employer, and nobody should be making off with a client list and stripping a business of its suppliers or the magic ingredient in a product. So there are good purposes for which an NDA can be used, but too often, NDAs are frequently used to preserve the reputations of the powerful inside an organisation as against the interests of those at the receiving end of abusive behaviours. Now, this really was opened up back in 2018 when a woman called Zelda Perkins publicly breached her non-disclosure agreement with Miramax over the behaviour of Harvey Weinstein some many years before. And she had been paid off because she had raised a complaint on behalf of another woman with whom she worked, because she ran the London office of Miramax, and a woman had gone as part of her work to the Venice Film Festival with Harvey Weinstein, and he sexually violated the other woman. And Zelda Perkins reported this to the headquarters in the United States, the headquarters of Miramax, and hardly put the phone down before there were a great posse of lawyers on her doorstep wanting to see her. And immediately she and the young woman who had been sexually abused were presented with non-disclosure agreements. They were lawyers were brought in to advise them that this was a sensible thing for them to do. And they signed away their rights, and they were given compensation and rushed off into the world of work and told to get on with life. Well, the non-disclosure agreement stipulated that the two women could not discuss the allegations, not only not with the general public or with the tabloid newspapers, but with lawyers or doctors or therapists or counsellors or with anybody, and which was a particularly devastating thing for the woman who had been violated. Zelda Perkins bravely breached that non-disclosure agreement, and it was in the public interest. And it was very important that she was able to tell the story of how she and her colleague were silenced. And she wanted to provide corroboration, and indeed did, in the litigation that followed. In the public interest, it is important that we visit this, and I would like to see it included in this legislation. Yes, there can be an exemption, as Baroness Morrissey has said, because some victims do not want the exposure, and that has to be respected, but only where they've had the opportunity of good legal advice. So I do hope that this House, persuaded by the many feisty women, but also their male colleagues, that the government should include this in this bill in the way that Baroness Morrissey described.
My Lords, it is a pleasure to follow the noble Lady Baroness Kennedy, and I would like also to congratulate our four new colleagues who made such excellent maiden speeches today: Lord Young, Baroness Cash, Baroness Grey, and my friend Baroness Berger. I am delighted to participate in this important debate on the Employment Rights Bill, which proposes radical and, I believe, potentially rather damaging changes to our employment laws. It was only a couple of months ago that some of us here today were engaged in a debate on the budget proposal to raise the cost of national insurance contributions paid by employers and their likely lethal effect on employment prospects. Today's debate on the Employment Rights Bill allows us to consider the potential damage this bill will also do to job availability. Essentially, when more legal duties are piled onto employers, inevitably the additional cost of carrying them out leads to fewer jobs being created. That old saying about the road to hell in good intentions springs to mind, if you can call them good. I will start with one of this bill's most controversial aspects, the increased powers for trade unions, making it easier for them to organise within businesses and exert more pressure on employers, and loosening current rules for calling strikes. But if businesses can be brought to a standstill more easily by trade union activity, productivity and investment suffer, and again, jobs are at risk. Furthermore, the bill opens the floodgates to more legal challenges in the workplace. While legal recourse is clearly important in cases of genuine mistreatment, this bill encourages excessive litigation. Companies will be required to overhaul employment contracts, provide new benefits, and meet new rigid compliance standards. For some, this may be an inconvenience. For others, it could mean the difference between survival and closure. A new Fair Work agency is to be set up to help enforce the new statutory rights, and will have the right to enter homes as well as offices to examine documents which they can demand to see, and to seize electronic devices used to store information if necessary. It will also be empowered to bring employment tribunal proceedings against an employer even if the employee is unable or unwilling to do so themselves. I would say the big state has just got bigger. The bill's proposals for flexible working contracts and zero-hour arrangements are equally unworkable. While flexible hours are essential for some workers and where possible should be agreed, the bill's proposals go too far, in my view, in restricting how businesses can structure and restructure their workforce when necessary. They must have the flexibility to respond to demand, which, as we all know, can go up and also go down. This bill introduces rigid rules on flexible contracts, making them an entitlement from day one in employment, if wanted. If an employer needs to change the contracted hours for any business reason, the onus is on them to make the case. Finally, I'm deeply concerned about Clause 20 in the bill and its potentially chilling effect on free speech. Pubs, shops and other customer-facing businesses may be forced to limit what can be said by customers on their premises to avoid offending staff working there. This includes overheard, not just direct conversations. Issues like religion, age, race, or perhaps a woman defending women's sex-based rights, plus a myriad of other subjects, could all be banned, because employers will need to prove they have taken all reasonable steps to prevent what would be seen as harassment by third parties or otherwise be held liable. The Equality and Human Rights Commission has already expressed its misgivings, so I believe should we all, loudly. The final question has to be, instead of making it harder to run a business with the consequences of fewer jobs on offer, why isn't the government working with businesses and employees to find practical solutions to balance workers' rights with economic progress and growth?
My Lords, I'm very pleased to welcome the maiden speeches of the four new colleagues, all of whom will clearly make powerful contributions in the years to come to your Lordship's House. I start off with a somewhat chiding the whips, because many speakers today have gone beyond the 4-minute limit, and I think that's perfectly understandable. This is a bill of 300 pages, 157 clauses, 12 statutes, and schedules rather, and there's much to say. And I just wonder why we're finishing at 7 o'clock this evening when we're sitting tomorrow, and those noble lords who normally leave to go home on a Thursday don't have to do so today. It would have been better if we had a bit longer for this debate. The noble Lord, Lord Hannan, said earlier that he talked, maybe I detected a little bit pejoratively, of those speakers that wait till the end, listening and nodding sagely, as he put it. Well, I've nodded sagely to some of the contributions I've heard, mainly, of course, from this side. But I see he's now nodding, I hope sagely. And can I say to him that I do, for what it's worth, regard him as the finest orator in the House currently. But having said that, I hardly agree with a word that he says. So to paraphrase perhaps Ella Fitzgerald, or more recently Bananarama, it's not what you say, it's the way that you say it. I did, when I looked at the list, I saw the number of Tories on the down to speak, and I thought, well, that's interesting. They're now come round to our view in some respect on employment rights, but unfortunately, having heard the contributions, that's not the case. For far too many, I think I would definitely accept the noble Baroness Morrissey on the benches, obviously. Employment rights actually means employer rights. And I think that's a big divide that we've heard in the debate today. And some of the doom and gloom really almost defies description. We heard much, those noble lords who were here, as I was 25 years ago, at the time of the national minimum wage, thought it was going to be the end, the economy was going to crash, there'd be mass unemployment, employers would never be able to pay that. Well, here we are 25 years later, and the national minimum wage, indeed beyond the national minimum wage, is now widely accepted. So I think those sort of comments are not justified. Because of the spread within the bill, we've had many briefings, as my noble friend Baroness Gowdy said, and we will all have had them from, in my case, National Education Union, through the Law Society, even the UK Hospitality. You can't possibly do them justice in this debate, but one of the briefings that I found most moving was a briefing in person this week from the TUC. And we heard from workers who came to tell us about what they thought the bill would do for them and their situation. And I remember particularly if I can get the names right now, Fionnuala Rhodes, who was an Usdaw shop worker, and she told about how her and her colleagues go to work in fear. And that's an intolerable situation. We heard from Seferina Floresca and Garfield Hilton, GMB members at Amazon, about the appalling tactics of that company when the union was trying to organise a ballot to legitimise the union. They reached the threshold, and just as they got beyond the threshold, what did Amazon do? Employed 1,000 new workers to move the threshold further and further away. Now, this bill will stop these sort of abuses and will give to people like Fionnuala and Seferina and Garfield, so not just protection at work, but dignity at work as well. And I think that's a huge step forward. There isn't much time to say anything else. I enjoyed my contributions from many colleagues. And can I just briefly say that Baroness Prosser and Baroness Chakrabarty mentioned the Equal Pay Act. My university dissertation in 1974 was on the Equal Pay Act. And now, half a century later, although progress has been made, so much more progress still requires to be made. And this bill will undoubtedly help to redress some of that balance, and indeed it will address a lot of the imbalance in employment legislation over the past 4 decades. We're going into committee now. Can I just remind noble lords that in committee you have up to 10 minutes to speak on amendments.
My Lords, I accept that the intentions behind this bill are very well meant, but I am really concerned about the unintended consequences. There are some positives. The rules on fire and rehire and bereavement leave are just 2 examples. But overall, I'm afraid I have to conclude that this bill will damage growth, and most importantly, it will damage the employment opportunities of the most vulnerable people. Others have mentioned omissions from the bill, and I'm very supportive of the comments that have been made around NDAs and on whistleblowing. And I'm looking forward to seeing what comes up on those. The impact assessment says that the bill will impose costs of around £5 billion on business. Worse, it confirms that those costs, and I quote, will be proportionately higher for small and micro businesses. My Lords, that goes directly against the government's drive for growth. Don't take my word for it. The OBR yesterday said that changes would, and I quote, likely have material and probably net negative economic impacts on employment, prices and productivity. There's already evidence that small businesses are reducing hiring, so I really hope that the government will be willing to consider constructive ways to reduce the burdens on SMEs. Speaking of the impact assessment, the bar is not high, but this is one of the worst I have ever read. The Regulatory Policy Committee rated it not fit for purpose, stating, and I quote, given the number and reach of the measures, it would be proportionate to undertake labour market and broader macroeconomic analysis to understand the overall impact on employment, wages and output, and particularly the pass-through of employer costs to employees. My Lords, it beggars belief that any government would propose changes of this importance without carrying out such an analysis. And that problem is made worse because this is in effect yet another skeleton bill, with much of the important detail to be added later by regulation. I counted 173 regulatory powers, and I'm very glad that the noble Lord Hunt came up with the same number when he spoke earlier, including 11 Henry VIII powers. That restricts proper analysis and scrutiny. At the very least, can the noble lady the Minister please confirm that all material regulations will be provided in draft before we reach report stage to allow at least some scrutiny of those important rules? It really isn't acceptable to continue having these endless skeleton bills. We're seeing more and more of them. Given the time limit, I will raise just two detailed issues. First, I do agree that zero-hours contracts can be exploitative, and some tightening, I think, is required. But they can work well for some people, such as students, as we've heard, and we should try to retain some level of flexibility for them. But more importantly, the new rules are likely to drive perverse behaviour. Basing future guaranteed hours on the previous 12 weeks is very burdensome on businesses, but it may also mean that people won't be given extra shifts during those busy times. The unintended impact of the bill might be that people get less work, not more. Second, there's the introduction of day one unfair dismissal rights. This will directly reduce opportunities for vulnerable people. That's not just my opinion, it's the government's opinion too. The impact assessment says, and I quote, "There is evidence that the policy could negatively impact on hiring rates. For example, employers may be slower to take on workers due to the liability and increased protections," and I stress this last part, particularly for those that are seen as riskier hires. My Lords, I'm sure we all support the government's intention to get people off sickness benefits and into work, but to achieve that we need employers willing to employ them. Is this really the moment to introduce rules that will, by the government's own admission, make that less likely? Is there any real evidence that the two-year qualifying period is being abused? In my experience, the opposite is true. The qualifying period allows employers to give people with little experience or with poor employment records the benefit of the doubt when hiring them in the first place and also at the end of any initial probation period. So could the noble lady the Minister please provide evidence that the two-year qualifying period is in fact a real problem? The only winners here are going to be employment lawyers. The losers are going to be the very people the government says it wants to help. We've heard lots of comments about this being a bill for workers. What it really is definitely not is a bill for those who want to work.
My Lords, I refer to my interests on the register, and I too welcome the quartet of maiden speeches, especially those from our benches. I welcome this bill, one of whose aims is to repeal the pernicious Strikes Minimum Service Levels Act of 2023. These laws imposed disproportionate constraints on the ability of working people to organise collectively and defend their interests, weakening the foundations of workplace democracy. As President of the Royal College of Nursing, the College took the momentous decision to halt history and overturn a decision not to strike after more than 100 years of its history. The conditions that produced that decision were triggered by the previous government's record as a hostile and aggressive actor seeking to bully nurses to back down on their pay claim to remedy 14 years of pay stagflation. When nurses go on strike, we know there is something seriously wrong with the moral order. And having been on the picket line with fellow nurses, both in Northern Ireland in 2019 and London during 2022-3, I was struck by the resolve of nurses, their dogged determination to seek justice, protect patient safety, and the extraordinary support shown by the public. Throughout the strike action, the government misjudged not only nurses' own resolve, but the public mood, banking on a cynical political calculation that public support for striking nurses would wither and wane. Evidence demonstrated the opposite occurred. Not only was public support sustained, but strengthened over time. And it's also gratifying to see ways in which the bill reflects some of the priorities of the nursing profession. The bill's proposed expansion of trade union access rights is particularly important for nurses in the independent sector, many of whom have little or no exposure to trade union representation at work. But to be meaningful, this access must be available via both digital and physical means, and employers subject to a clear statutory duty to comply. The Bill's provisions to create an adult social care negotiating body represents potentially a transformative change for a sector long characterised by low pay, fragmented employment and workforce instability. Many nursing staff in this sector work under conditions that would be unacceptable in any other part of the health system. This body could help promote equality, particularly for internationally recruited nursing staff upon whom we will increasingly rely, and workers from marginalised communities. Reports of repayment clauses, bonded labour arrangements and racialised pay disparities remain disturbingly common in adult social care and must be rooted out. Modernising employment law for the nursing profession must address the systemic challenges faced by women in work, from pregnancy and parental leave protections to preventing workplace harassment and improving access to flexible working. This bill presents an important opportunity to tackle long-standing inequalities and deliver the potential for a more supportive and inclusive working environment for nursing staff, and I commend it to our Lordship's House. Thank you.
My Lords, it's a pleasure to follow my noble friend Baroness Rafferty and to hear the outstanding maiden speeches of my noble and very good friend Baroness Berger and indeed Baroness Grey, and I also congratulate Baroness Cash and Lord Young of Acton on their maiden speeches too. It's equally a pleasure to speak in this second reading debate on the government's flagship Employment Rights Bill alongside colleagues with huge experience of the realities of day-to-day trade unionism, not the flight of fancy we've heard from some members opposite. I'm not sure what the collective noun for trade union general secretaries and assistant general secretaries should be. Perhaps we need to invent one on our benches. I would say negotiation, but we can quibble over that. For my own part, I am someone of experience of both sides of the negotiating table. I worked as a lowly political officer at the Transport and Salary Staffs Association, but more recently for a FTSE-listed transport operator and for small businesses in between. I have to say, when hearing some of the contributions from the benches opposite, I recall an earlier job, though, when I had the privilege of working for our noble friend Baroness Harman when we were campaigning on the blight of low pay in 90s Britain and the need for a national minimum wage. And as my noble friends Baroness Hazarika and indeed Lord Watson of Ingowaring have reminded us, shrouds were certainly waved back then by the Conservative government and indeed some of their business backers about the devastating impact this would have. Next week, my Lords, the national minimum wage will rise again, benefiting 3 million workers. Our economy did not collapse, it will not now. My Lords, the importance of making work fair, which this bill does, is so important in delivering not just a better economy, but a fairer, more just and cohesive society. I could dwell on many individual elements of the bill. My niche favourite is the decision to scrap the pointless hoop jumping of regular political fund ballots, having organised some myself. But instead I want to consider the societal benefits of making work fair for individuals and giving trade unions more rights to represent working people when they're being unfairly exploited. Research conducted by Warwick University has found that job-related ill health is costing UK businesses up to £41 billion a year, with 1.75 million workers suffering due to poor job quality. This study highlights how job insecurity, low pay and long hours contribute to poor health outcomes for employees, and conversely, the academics say, job security, fair pay and a healthy work-life balance are linked to better well-being. Hardly surprising. My noble Lords, the number of people in insecure work reached a record high of 4.1 million last year. And I'd say, contrary to the noble Lord Hunter Wirrell's assertion, those workers don't want to be in a state of insecurity. According to a TUC poll of 0 hours contract workers, some 84% want regular hours of work, compared to just 14% who don't. And 3/4 of those polls say they've experienced difficulty meeting living expenses due to not being offered enough hours. But, my Lords, extending workers' rights isn't just good for workers. Making work more equitable, secure and meaningful is good for communities too. That's why, as my noble friend the Minister said, the wider population, not simply those workers impacted, support the messages in this bill. Polling from Hope Not Hate has found that 72% of people support banning zero-hour contracts, 73% support protection from being unfairly sacked from day one, and 74% support ensuring all workers have the right to sick pay. Hope Not Hate's polling also found that over half of people feel pessimistic about the future. And, my lords, we know from history that when an economy is on its knees, when people feel insecure and hopeless about their own futures, as well as the future of the country, it weakens community cohesion, leaving space and divisions which the far right is only too willing and able to exploit. Insecurity at work, my lords, breeds insecurity in our communities and our country. These reforms will make people feel valued and restore a sense of hope to the most marginalised in our society, and that can only be a good thing. In short, my lords, we need change, and this bill is a vital part of that positive change for millions of workers, their families and their communities.
Yeah. My lords, I too welcome the 4 maiden speakers. I congratulate them on their speeches. Meanwhile, like some of us here today, I was in the other place yesterday afternoon listening to the Chancellor's statement and her quest for growth. And yet here we are today in this chamber debating the second reading of a bill, certain parts of which will absolutely be guaranteed to regulate the life out of any growth that she wants and the country needs. But, my lords, leaving aside the economic damage that those parts of the bill will cause, we also need to consider the societal damage that will be done by Clause 20 in particular, and its effect on free speech and life's moments of enjoyment which we currently take for granted and which are now under threat. To illustrate this, I'd like to give 2 examples from my own work experience. I publish about 50 books a year, and the marketing of each one requires my employees to come into contact with the general public, those whom the bill calls third parties, at book launches and other sales events. To take a typical example of a book launch in a bookshop, the bookshop would host 2 categories of third parties. Firstly, say 50 of our own potential customers, and then a further 50 of their own from their mailing lists. Apart from the bookshop staff, I would typically have 3 or 4 of my own employees there to help. In terms of the bill, this detail is important. They are my employees, but even though they are working on someone else's premises, they will still be my liability. Now, to avoid the consequences of the bill, should I and the bookshop request our guests not to talk to staff, or even to each other in case a member of staff overhears them, about any subjects related to protected characteristics, even if what they say is perfectly legal? I ask your lordships, after seeing such an invitation, one that discourages any form of legal sociability, would any of us go to such a cold water event? My lords, this might sound fantastical, but it is not fanciful. It's all right here in Clause 20. The result in this instance is that the risks are untenable and therefore the event won't happen. And we will have given up another harmless pleasure to satisfy the whims of the ever-changing latest version of groupthink. And then again, in a wider context than this, would Waterstones, for example, risk arranging another in-store book signing by J.K. Rowling or Kathleen Stock or Helen Joyce on the off chance that one of the author's fans will arrive wearing a T-shirt saying woman equals adult human female, knowing that their employees could sue for hurt feelings, real or vexatious? Widening this out still further to cover all hospitality events, and I'm also a trustee of a national museum that stages events throughout the summer, the only practical way for any host to mitigate these dangers is to pass the potential liability onto organisers or promoters, and would either really want to take this on, bearing in mind no one involved in staging an event has any idea who the third parties will be coming to the event. Are they up to date with the current thing, the latest protected characteristic they mustn't talk about? Are they courteous? Are they even sober? Or even have English as their first language? Any encounters between so-called third parties and employees are totally beyond the employer's control, and yet in this Alice in Wonderland world of Clause 20, the employer will be responsible for these interactions, no matter where they happen, even if these interactions are totally legal in themselves. My Lords, I would urge the Government to have a massive reality check about the foreseen and unforeseen consequences of Clause 20 as the bill progresses.
Yeah. My Lords, rather than being the third party, I think I'm the 59th party in this debate. And somewhat repetitiously, I congratulate the Baroness Berger, Baroness Grey, Baroness Cash and Lord Young for their maiden speeches. And without being seen to pick one from the other, I was struck by the comments that Baroness Grey made about the benefits of having spent time running a pub. Straight after graduating, I became the manager of a busy bar in North London, and I learned more about people, but more importantly, I learned about employing people, because it was the first time I'd started to employ people, and it was a great lesson. You can learn a lot in places like that. My Lords, this has been an interesting debate, and I think we've heard very disparate views. I think on the one hand, maybe Lord Davis or Lord Hendy has put the poll in one place, and on the other hand, almost certainly Lord Moynihan has placed the poll on the other hand, and your Lordship's task will be to work out where this bill lands between those two polls, and it's going to be a tough job in committee. My Lords, this bill undeniably sets out to meet a manifesto commitment which the government very clearly articulated during the election. Unfortunately, one aspect of that commitment was to deliver it within 100 days. And the nature of what we are discussing has suffered from the lack of rigour in preparation. And that is clearly evidenced by the number of amendments that the government itself has had to bring, and also evidenced by the lack of detail and the number of consultations that are outstanding. And for that reason, my Lords, those of us on these benches will be working closely, not just on the intent of this bill, but the detail. And there's an awful lot of detail that's missing. And many of the real details are still out for consultation or are awaiting codes of conduct that will be set out in regulations that we've yet to see. So, my Lords, it's going to be quite a hard committee stage. However, my Lords, before descending into that detail, I think we should reflect somewhat on the purpose of this legislation. And we, Liberal Democrats, agree that there's absolutely is a need to ensure that exploitative employment is dealt with. There is no doubt that there is a need to do that, and we support that objective. But I hope that when this bill leaves your Lordship's house, it will be more widely equipped to help improve employer-employee relations, to deliver fair work, yes, but also to create those conditions for growth. And if it is to do that, then it has a long way to go to achieve that. My Lords, I've been a member of a trade union, and I've been part of executive management of businesses that have worked very constructively with trade unions. But it's not the only model for employment and employee. And a central criticism I would have of this bill is it seems to disregard the fact that many, I would suggest most businesses, maintain strong and beneficial relationships with their employees without the need for union involvement or intervention. And as a starting point, I do think this bill seems to have an air of suspiciousness about the functioning relationships as to how normal businesses go about their business. And I think we have to kind of go back through and inbuild the idea of the one-size-fits-all, which was articulated. We have to get away from that. There are a lot of different hybrids that work in business, and this legislation should facilitate all of those equally. So, my Lords, further, there needs to be more recognition of employees as individuals rather than as members of unions. A fact of life is that whatever the government thinks, the vast majority of employees will not be in a union, at least in the private sector. And I think we need to think about how that works. My Lords, the tone of this proposed legislation is perhaps unsurprisingly very legalistic. An awful lot of lawyers have been involved in it. But there will certainly be more employee tribunals if it passes as drafted. My Lords, I would emphasise that every time a case goes to a tribunal, both sides have already lost. So we do not want to be pushing things, and in answer to the seated interjections from Baroness Chakrabarty, the fact is that it will require, it will push things into a legal process, was what I meant by what I said. But also, given the uncharted nature of this legislation, we will be relying on case law for years to come to define its boundaries. The noble Baroness Prosser and others talked about equal rights legislation. There was years and years of case law that enshrined how that worked in the workplace. And my Lords, if the tribunals and the courts are so tied up, then that case law is going to be very slow and forthcoming. So we have to be quite clear in our definitions so that we aren't relying on those definitions for this bill when it becomes an act to function properly. My Lords, we know that the tribunal system is already overloaded with waits for rulings measured in years. Also, ACAS will have an important role to play, not just on the policy side, but with its mediation work. Will its funding be increased in order to reflect this extra burden? My guess is that the tribunals and ACAS won't be funded properly, and this will cause administrative sclerosis, uncertainty, and long waits for cases to be heard. So I think this is something that needs to be taken into consideration. How are we going to resource this bill if and when it becomes an act? Turning to some of the central points of the bill, my first question are around the legal definitions of when we start talking about 0 hours contracts. I think there's a lot of work that needs to be done to tighten definitions around that so we know what we're talking about, what we're seeking to achieve around that. The addition of agency workers further complicates this point, and there are fundamental decisions that we can't wait for legal process to deliver. My Lords, when passing through the Commons, Liberal Democrats introduced a number of amendments that we'll present to your Lordship's House. For example, Daisy Cooper MP proposed a new clause to publish a review of Part 4 of the bill on the impact to SMEs. Liberal Democrat MPs expressed concern about placing unreasonable burdens on SMEs. They duly called for clarity on aspects like probation periods at an early stage due to the significant impact this will have on small businesses. My Lord, as the noble Lord Brown noted, this is a complicated bill, and should any small business person have had time from running his or her firm and listened to the noble Baroness the Minister's introduction, very able as it was, the complexity of that introduction would certainly have alarmed them. It is daunting legislation for all businesses, but more particularly smaller businesses. And I do fear that the retail, hospitality and leisure sectors stand to face some of the biggest challenges that this bill could launch. My Lords, there is also a danger that I would caution about conflating the contents of this bill with productivity and growth, citing international examples. There is a difference, my Lord, between correlation and causation, and we perhaps shouldn't go too big on that. I think we should be using a different measure, which is what is right to do, rather than the supposition that it may or may not deliver growth. My Lords, next, as we heard from the triumvirate opposite, Lord Freyberg, Viscount Colville and Earl Clancarty, there needs to be a proper understanding of the role of freelancers and the self-employed within the workload, the workspace. Where do they sit within this bill, and what should and could their contractual rights be? It's clear also that this bill needs to focus more on the future of employment, And here we should look at closer alignment to EU positions, for example on AI involvement and on algorithm-directed employment. My Lords, these have been discussed in the past, but they're not included in this bill. So I hope that the House will debate this, and I hope the Minister will be forthcoming on these future issues. My Lord, then there is the issue of the Fair Work Agency and how this will operate. There have been alarming reports in the press, which may or may not be true, but what is clear is we need to flesh out how this agency will work. How does it supplant the work of the Treasury and probably the Gangmasters Labour Abuse Authority? Will it have access to the same data that the Treasury has, bearing in mind that this is confidential private tax data? So before we reach report stage, the government should publish full proposals for this agency. We can't approve it sight unseen. My Lords, furthermore, as we've heard from a number of your Lordships, the preponderance of delegated legislation will have to be addressed, either by your Lordships, but hopefully by the government in advance of that process. My Lords, the Spring Statement saw the biggest reduction of assistance to working carers for a decade. As my noble friend Lord Palmer set out, we will seek to strengthen provisions on carers' leave. We will also address parental issues such as absence of provisions on miscarriage bereavement leave. We will propose increasing the length of paternity leave and making it more flexible, which I hope will please be supported by the noble Baroness Penn. My Lords, as my noble friend Baroness Kramer set out, we will table amendments that seek to act on whistleblowers and the misuse of non-disposal agreements. My Lords, I share the analysis of the noble Baroness O'Grady and others, their interpretation on the need to protect workers from harassment. To conclude, my Lords, I'm anxious that the noble Baroness, the Minister, does not dismiss the negative words that she's heard today as being purely political chipping. There are genuine practical problems that we need to address in your Lordship's House, and I hope we can take forward that practical approach as we go into the second reading. My Lords, Liberal Democrats believe that the lack of detail in the bill doesn't facilitate certainty and stability for either businesses or workers, and if we're talking about growth, that's what we need. It's certainty and stability. There are huge holes in the available data and detail supporting this important bill. Much of that detail is floating in the many consultations or as yet unpublished codes. We need to have advanced sight of the important levels of detail that will flesh out the skeleton of this bill. Like many, I fear that the overall effect of this bill, this bill will have or could have on small and medium businesses, particularly through the introduction of much complexity and the threat of being taken to many more tribunals. It's friction, my Lords, and these businesses do not need yet more friction in what is already a very difficult trading environment. In the main, this bill does take rather a one-size-fits-all approach to addressing genuine problems in the workplace, and it does not look far enough forward on future employee issues. With that said, we look forward to discussing this issue on committee. Sorry, Dave.
My Lords, can I join in thanking the noble Baroness, the Minister, for her introduction, as well as of course, praising and commending the speeches of the four maiden speakers today, Baroness Berger, Baroness Grey of Tottenham, and my noble friends Baroness Cash and Lord Young of Acton. It's been a very interesting debate. Before I start, I should declare my interest as a minority shareholder in two businesses that employ people. And can I also say it's a pleasure to follow the noble Lord Fox. I found myself nodding in agreement with much of what he said, and I'll do my best to not repeat all of it. My Lords, others have said or commented on the fact that this overall is a troubling bill. And for numerous reasons, not least as my noble friend Lord Hunt of the Wirral articulated so expertly, its excessive reliance on secondary powers. So I won't expand on that now as the case has been made, and indeed reinforced just now by the noble Lord Fox. But I will focus my remarks on two areas where, to use a phrase coined by my noble friend Baroness Penn, the balance is seriously wrong. And they are the inevitable and disproportionate impact on SMEs, acknowledged in the government's own impact assessment, and the day one rights and their inevitable impact on hiring. So, my Lords, let me begin by turning to the bigger picture and quoting from the government's own impact assessment. It states, and I quote, "Many of the policies within this bill could help support the government's growth mission. Whilst we conclude the direct impact on growth could be positive, but small." My Lords, the word could appears 132 times in the assessment. 132 times. That is not the language of confidence. That is the language of uncertainty. That is the language of hesitation. And it shows a fundamental lack of conviction in the very legislation before us. And while the government dithers, my Lords, businesses are suffering. Indeed, as we saw only yesterday, the OBR downgraded growth forecast from 2 to 1%. And in a particularly telling phrase in the explanatory note, as already referenced by my noble friend Lord Moynihan, it said, "We have not incorporated any impact of the government's plan to make work pay, as there is not yet sufficient detail or clarity about the final policy parameters." They go on to say, "Employment regulation policies that affect the flexibility of businesses and labour markets, or the quantity and quality of work, will likely have a material and probably net negative economic impacts on employment, prices, and productivity." My Lords, that's an explicit acknowledgement of the uncertainty generated by this bill and an admission that implies more downgrades are to come. So let us look at the current facts. The Business Confidence Index for the United Kingdom stood at 97.4 in December 2024. That shows a sharp decline from the previous month and is the lowest reading since July 2020. That was a time, of course, of extraordinary crisis, of global shutdowns, of an economic freefall. And yet today, with no pandemic to blame, we find ourselves again teetering on the brink. My Lords, the Institute of Chartered Accountants in England and Wales, that's the ICAEW, their Business Confidence Monitor, which is the most comprehensive measure of sentiment in our business community, plummeted from 14.4 to a mere 0.2 in Q4 2024. And the Institute of Directors confirms this. Their economic confidence index dropped from minus 64 in February, to minus 64 in February, which is close to the lows reached during COVID. And on this bill specifically, the Institute of Directors survey suggests that 57% of business leaders will be less likely to hire. ICAEW members, going back to that organisation, across the UK have raised concerns about the bill's impact on costs, on labour flexibility and business dynamism. 73% of their members polled expect the bill to increase employment costs for new and existing employees. And one said, and I quote, "It's like rushing down a hill towards a lake and pressing the accelerator." And the OBR have told us how this ends, my Lords. It ends in unemployment, and it will be unemployment of the government's own making. And on the subject of unemployment, that was one statistic the noble Lords opposite failed to cite when making their international comparisons. So for the record, it is currently 7.3% in France, it is 6.2% in Germany, and it is only 4.4% here. And what is driving this collapse in confidence? My Lords, it is the suffocating weight of excessive taxation and crippling uncertainty about the future, as many others have noted. To go to small and medium-sized enterprises, which concern those of us on this bench considerably, they're rightly hailed as the backbone of the British economy, and for very good reasons, because SMEs account for 60% of UK employment and 48% of business turnover. Their confidence has turned negative for the first time since Q4 2022, falling from 12.8, that's a positive number, to minus 4.7. And my Lords, that figure is not just a dry statistic. It represents thousands of business owners lying awake at night, wondering if they can afford to keep the lights on, let alone hire new staff or invest in their future. We should be under no illusion. The cost of this uncertainty is devastating. The Federation of Small Business has reported that a staggering 33% of small employers now expect to reduce staff, and that number has doubled in just one quarter. Meanwhile, only 10% of small firms plan to take on new employees. So the result will be a shrinking economy, a contracting workforce, reduced opportunities for young people and those seeking to move from welfare to employment, increased costs and bureaucracy, and a country that is clearly retreating from ambition rather than embracing it. And if more confirmation is needed of this picture, then the government's own impact assessment for the recent SI on the National Minimum Wage Amendment Regulations of 2025 confirms the difficulties facing small businesses. It says, and I quote, "There is some evidence of challenging business conditions for SMEs specifically. Around 42.7% and 36.8% of micro and small businesses, respectively, reported having less than 3 months cash reserves in September 2024, compared to 19.2% for large businesses. Around 15.6% and 33.9% of micro and small businesses, respectively, reported the cost of labour as a challenge to business turnover in November 2024. My Lords, it's not clear whether by the cost of labour they were talking about the workforce or the party opposite. My Lords, SMEs will need many exemptions from the provisions of this bill, and yet, my Lords, the picture that I've just painted is about to be made worse as the bill chooses to add yet another burden, and that is the disastrous day one rights for unfair dismissals and statutory sick pay. So let me ask a simple question. Who truly understands what a business needs to thrive and survive? The entrepreneur who's built something from nothing, the employer who fights every day to keep their company afloat, or is it an employment tribunal? Removed from the realities of running a business, yet now empowered to make decisions that could determine its fate. And my Lords, as the data from His Majesty's Courts and Tribunal Service reported last year makes clear, employment tribunals are currently not able to make any speedy judgments at all. The Law Society described the backlog as spiralling, and a very well-known legal firm described the tribunals to us, as I quote, as a bit of a laughingstock, creaking and hugely unreliable. And that firm might be expected to support this bill out of self-interest, but my Lords, they don't. This bill makes it harder for businesses to prove that redundancies are genuine. It creates a scenario where every decision could be second-guessed by tribunals the legal profession think are a bit of a laughingstock. Every restructuring might have to be questioned, and every difficult choice turned into an expensive legal battle. Why, my Lords, would a business fire for no reason? Businesses need motivated, skilled employees, and they need time to assess the likelihood of an employee acquiring those skills and demonstrating that motivation. I think the Noble Lord Vaux put this very well indeed, and comprehensively explained it. But if I might quote one of his colleagues on the crossbenches, this clause, as Lord Moore of Etchingham stated in a newspaper column the other day, is, quote, as if children once admitted to school were immediately deemed to have passed all the ensuing exams. As my noble friend Baroness Cash noted, this is not an us and them perspective. But even if there were no other reason, retention is cheaper than firing and rehiring. Yet this bill assumes without evidence that businesses are acting in bad faith, that they need tribunals to intervene, and that they do not already have a strong incentive to retain talent. My Lords, the cost of all this will be staggering. The impact assessment says £5 billion, which will inevitably prove to be optimistic, and which will inevitably fall, as the government admits, disproportionately on the very SMEs we need to power growth. SMEs that the facts say are already struggling as a result of this government's other misguided policies. Instead of managing their businesses, seeking new markets and customers, they will be bogged down in human resources and get it wrong, and they'll be bogged down in litigation, endless documentation, and the endless hiring of legal experts to justify every strategic decision. This is not just a bureaucratic overreach, it's an outright violation of business autonomy. A business should be able to shape its own workforce in response to market demands, competition, and innovation. And yet, under this bill, it seems that businesses can only make such decisions when faced with an existential crisis. Now, a company struggling with stagnation, trying to bring in fresh talent, trying to stay ahead in a fiercely competitive world, what recourse would they have? So we must ask ourselves, my Lords, do we want a thriving economy? Do we want businesses that grow, invest, and create jobs? Or do we want a system that strangles them in red tape, drags them into courtrooms, and forces them into stagnation. My Lords, this bill as it stands will not boost our declining growth. It will not restore business confidence. It will not create jobs. Instead, it will leave many businesses trapped, unable to adapt, unable to compete, and ultimately unable to survive. So allow me to ask the noble lady, the Minister, a question. Have the government considered the likely impact of the measures in this bill on their recently stated aim to move people off long-term welfare? Can they speculate as to the likely effect of day one unfair dismissal rights and statutory sick pay rights on that ambition? Can they answer why a prospective employer might take a risk on a potential employee who is recovering from a long-term medical condition? The obvious net effect of these measures will be to encourage employers to do more due diligence, be more risk-averse, rely more on references and less on intuition, and that will have a very damaging impact on social mobility and workforce diversity. Now, how does society or the individuals and businesses affected benefit from that? How is that, to use the noble Lord Livermore's words from earlier, either compassionate or fair? Beyond the immediate damage to business confidence, we must consider the broader implications for the UK's attractiveness as a destination for investment. Capital flows where it is welcomed. Investment thrives where there is stability, where there's flexibility and a regulatory framework that encourages and doesn't obstruct growth. Yet this bill sends precisely the wrong message to investors. It signals that the UK is becoming a more complex, risk-laden and bureaucratic place to do business. Why would international companies choose Britain when they can invest in economies with more business-friendly policies? Ministers claim that employment protections will create a fairer economy, but they failed to acknowledge the reality. An economy that cannot attract investment is an economy that cannot create jobs at all, and surely that is the ultimate unfairness. Or to put it another way, and to use the noble Lord Watson's word, the greatest dignity of all is surely to have a job. Yeah. My Lords, as we have heard, there is plenty more in this bill which we will be addressing at committee. My noble friend Lord Young of Acton made a brilliant maiden speech, drawing heavily on his experience with the Free Speech Union and talking to the invidious Clause 20. We will support him, and as a reminder, my noble friend pointed out that employers are already liable for the sexual harassment of third parties under the Worker Protection Act. On flexible working, we struggle to understand the problem is actually trying to fix. As my noble friend Lord Hunt said earlier, a majority of workers on these contracts seem to like them. The Recruitment and Employment Confederation state that 79% of respondents to their recent survey like flexible working because of the flexibility. The Chancellor says she wants to tear down regulation to boost growth. But this bill introduces a new quango with perhaps alarming, as to use the word of the noble Lord Fox's statement, or perhaps Kafkaesque powers. We've spoken to all the major business organisations and many employers with real-world experience, and we can find none that support this bill. We've found unanimity that where it will cause considerable damage. So can the noble lady, the Minister, give me any examples, apart from those four that she's already mentioned, which have been trotted out fairly frequently over the past few months, of actual real employers that support all of this bill? Please name just one, as we'd love to talk to them to see what we've missed. My Lords, we will of course also be turning to the subject of trades unions, to which a number of noble lords have spoken, but I would in particular commend the contributions of the Lord Burns, the noble lady Baroness Fox, and indeed Lord Fox from the Liberal Democrat benches for their thoughtful interventions on this. My Lords, we believe that the UK stands at a crossroads. We understand the intent behind this bill, and of course there are some things in this bill that we can support. But we can either embrace policies that made us a global leader in investment and innovation, or we can burden ourselves and business with regulations that drive them elsewhere. I do believe that the government is serious about growth, but I have no choice but to conclude that the choice here is straightforward. You can have this bill or you can have growth, but you can't have both.
My Lords, it's a pleasure to be able to conclude this debate, which has been as insightful as it has been passionate and informed. And it's been a very well attended debate today. And I do hope Noble Lords will understand that the time constraints means that I'm unable to be able to respond to every individual contribution as I would normally do. But I shall do my best, and where I haven't been able to, I am of course available to talk to Noble Lords and to discuss it, and I'm sure we will have plenty of discussions between now and committee stage and after that. So I hope that this will be an ongoing dialogue. I know many Noble Lords have considerable expertise of running their own businesses. Noble Lords, Lord Lonsborough, Lord Keithley of Camden Town, Noble Baroness Cash spoke of these valuable insights. This bill seeks to raise the floor for employment rights in our country and includes practices that many good employers, such as no doubt those operated by those Noble Lords, are already doing, to the benefit of themselves and their workforces. And I'm sure Noble Lords will value the level playing field for employers that this bill will ensure. I dare say that Noble Lord Balfour was preaching to the choir with his much needed intervention from the benches opposite as to why people join trade unions and the range of benefits that collective bargaining brings. And I hope that the front bench were listening to those points as well. And I would like to thank the Noble Lords, Lord Barber of Ainsdale, Lord Keithley of Camden Town, Lord Hendy, Lord Katz, Lord Watson, Lord Monks, Baroness Carberry of Muswell Hill, Lord Prentice of Leeds, Right Honourable Lord Brown of Ladyton, Noble Baronesses Hazarika and Baroness Boosted, Baroness Lister, all of whom expressed their strong support for this landmark legislation and powerfully articulated the need for it to reach the statute book. I would also like to take my opportunity to pay a tribute to those who made their excellent maiden speeches. I pay tribute to my noble friend Baroness Berger for her marvellous maiden speech. My noble friend brings a valued perspective to this debate, and it's great to hear how she's long proudly advocating for and championing strong employment rights. And I would also like to say how warming it is to see her back in Parliament. I'm sure your Lordship's House will value her wisdom and expertise, as well as the courage and integrity she has embodied so well. I also thank my noble friend Baroness Grey of Tottenham, whose extensive career in the civil service is greatly respected in your Lordship's House, and my noble friend brings a wealth of experience and insights to our discussions on advancing workplace rights. It was a pleasure to hear from the noble Baroness Cash, whose role as Commissioner of the Equality and Human Rights Commission and also as an employer brings a unique insight into many important issues regarding workplace equality. And finally, I pay tribute to the noble Lord Young of Acton. Having another strong voice in your Lordship's House is always welcome. The perspective the noble Lord brings through his work with the Free Speech Union is important, and I've no doubt his discussions on this legislation will continue to be of great interest. Moving on, I thank the noble Lord Palmer of Charles Hill, noble Baronesses Lister, Baroness Smith of Lanfays, for their passionate interest in those with caring responsibilities. An important part of our plans to modernise the world of work is ensuring carers can enjoy a good job and contribute their skills alongside their valuable role as carers. The government will examine the feasibility of introducing paid carers leave in the upcoming Carers Leave Review. With regard to making caring a protected characteristic, many people with caring responsibilities are already likely to be afforded protections under the Equality Act 2010 by the provisions relating to age and disability discrimination, which specifically protect people from direct discrimination by association. Individuals with caring responsibilities for someone who is, for example, elderly or disabled, within the meaning of the Act, are likely to be protected from unlawful discrimination from their association with someone with a protected characteristic. And I'm sure that noble lords will understand that this means that this intervention would be unnecessary. I thank the noble Baroness Baron and the Right Reverend Prelate, Bishop of Newcastle, for raising the issue about kinship care and foster caring. And we are committed to ensuring that all employed parents and carers receive the support they need to strike the appropriate balance between their work and family lives. For the first time, the government's Children's Wellbeing and Schools Bill will create a legal definition of kinship care for the purposes of specific measures in that bill. But by defining kinship care in law, the legislation will ensure that all local authorities have a clear and consistent understanding of what constitutes kinship care. And I hope that Noble Lords, assures Noble Lords of the government's intentions in this sensitive area. A number of noble lords, Lord Hunt, Lord Ashcombe, noble Baroness Foster, Baroness Cash, noble Lord Vokes, Lord Sharp, raised the issue about financial implications of the bill. The noble Lord Sharp suggested that we should only listen, I think, to business voices, but I have to say to him that our history and our economy is based on partnership. That is always what has made us thrive, and that is what will be underlying our growth strategy going forward. This is not a case of hearing one voice over another. The noble Lord Sharp also raised the issue about business confidence. According to the latest Lloyd's Business Barometer, which surveys 1,200 businesses every month, business confidence has increased 12 points to 49% in February, the highest since August 2024. This shows that the government is improving the business environment. But of course, we recognise the concerns about the cost to business. The 5 billion figure from our impact assessment is a top-end estimate, which will largely represent a direct transfer to the lowest paid in society, with the bottom end of the range close to £1 billion. The costs, therefore, are likely to be under 0.4% of our national wage bill and could even be as low as 0.1%. The noble lords, a number of noble lords also mentioned the OBR comments, but I have to say and stress to noble lords that they are yet to make an assessment, and so it's premature to read anything into their comments so far. And meanwhile, improving worker well-being, increasing productivity, reducing workplace conflict, and creating a more level playing field for good employers will grant significant benefits worth billions of pounds per year, offsetting those costs. The noble Baroness, the noble Lords Lord Hunt of Wirral, Lord Palmer of Charles Hill, noble Baroness Noakes, Baroness Coffey, and the Viscount Colville of Colvos, Lord Vokes and Lord Fox raised the issue of parliamentary scrutiny. On the approach taken with regard to delegated powers in the bill, I seek to reassure your Lordship's House that the approach we're taking with respect to many of the delegated powers in the bill is in line with existing precedents for use of delegated powers in employment law, and the Department believes that these are necessary and justified. They will enable the government to remain responsive to the changing needs of the modern labour market and the economy, and to ensure that the employment rights framework remains relevant to these needs. But of course we will give this bill full scrutiny in its stages here, and I look forward to the many conversations we will have with noble lords about this. Noble lords also raised the issue about amendments made by the government in the other place. Throughout the development and passage of this bill, the government have taken great efforts to listen to a range of views from businesses, trade unions, representative organisations, civil society and others. The insights gained, including from the formal consultations which the government have conducted since introducing the bill, have informed the amendments made in the other place. These have been invaluable in ensuring the bill works in practice, both for workers and for businesses of all sizes across the country. The noble Baroness Baron raised concerns about the school staff support negotiating body. While an important part of reinstating the body is to improve consistency, it does not commit us to a one-size-fits-all approach. Our intention is for support staff in all state-funded schools in England to benefit from a core pay and conditions offer while allowing the flexibility for all schools to respond to local circumstances above minimum agreed standards. We will be consulting on this over the summer. My noble friend Baroness Whittaker asked about seafarers. My noble friend is right to point out the important role that seafarers play in our economy and the necessity of improving protections. These clauses provide powers to require operators of frequent international services to the UK to meet certain standards on board their vessels in order to continue access to UK ports without having to pay a surcharge or risk refusal of access. We will continue to engage a consultation stage with the trade unions representing seafarers and seafarer charities to ensure the unique needs and voices of seafarers are represented in this process. The Noble Lords Lord Whitty, Viscount Colville of Colcross, Noble Lord Fox and Baroness Coffey raised issues about the Fair Work Agency. Better enforcement against the non-compliant minority of business means more workers will get their due and businesses are on a level playing field. That's fair for business and fair for workers. We will discuss extensively with businesses and employers and take the view of the Fair Work Agency's tripartite advisory board on how to most effectively use this power. This will include discussing what to do where workers are unwilling to enforce their rights. On inspecting umbrella companies, the bill will bring umbrella companies' activities that are not currently captured in existing framework into scope of state enforcement. This will allow a bespoke regulatory framework to apply to them, which will be set out in regulations and in time enforced by the Fair Work Agency. We will consult on these regulations and I hope that this alleviates Noble Lord's concerns. On the structure and actions of the Fair Work Agency, it will subsume 3 existing agencies and additional functions from HMRC into one single body. So we're reducing the number of quangos, not adding to them, whilst increasing efficiency. The agency will take a balanced approach to enforcement. It will have strong powers that enable it to take action against rogue employers that exploit their staff, and provide support to businesses to help them comply with the law. Noble Lord Young of Acton and Baroness Bray and the Noble Lord Strathcarron raised concerns about third-party harassment. Conduct that is merely upsetting or causes minor offence will not be sufficiently serious to meet the Equality Act 2010's definition of harassment, which requires significantly more than that in order for it to be unlawful. It's not enough for the claimant to simply feel that someone's conduct is offensive. There is an objective test in which the reasonableness and the facts of the individual situation will always be considered. The steps an employer can reasonably take in respect of third parties are clearly more limited than those for their employees. Employers will not be penalised for failing to anticipate the unforeseeable or take other impractical steps. Likewise, any step that was disproportionate interference with a customer's right to freedom of expression would not be reasonable. Therefore, we do not expect this bill to have the chilling effect on free speech the Noble Lords envisage. Several Noble Lords, including my noble friends Baroness Whittaker, Baroness O'Grady, Noble Lord Palmer, Noble Baroness Morrissey and Baroness Kramer, raised the issue of non-disclosure agreements. The bill measures means that a provision in the NDA seeking to prevent a protected disclosure about sexual harassment will be unenforceable. An NDA entered into in respect of sexual harassment may still stand to protect confidentiality in other circumstances, such as requiring the employer to keep the identity of the worker and the details of the incident confidential. This is the case now and is not changed by this bill measure. I respect Noble Lord's interest on this important topic, and we're progressing with some reforms through other legislative means. The government is pressing ahead with plans to commence the provision relevant to NDAs in the Victim and Prisoners Act 2024 and the Higher Education Freedom of Speech Act 2023. The provisions in the Higher Education Freedom of Speech Act 2023 which will, when commenced, ban NDAs for staff members, visiting speakers and students in cases of bullying, harassment, including sexual harassment and intimidation, were an amendment of this government's whilst in opposition, of which we remain proud. When commenced, Section 17 of the Victim and Prisoners Act 2004 will ensure the confidentiality clauses, including those in non-disclosure agreements, cannot be legally enforced to the extent that they seek to prevent victims of crime from reporting a crime, cooperating with regulators in relation to the crime, or accessing confidential advice and support. My Lords, I recognise the points raised by Noble Baroness Browning and my noble friend Baroness Rafferty about the adult social care negotiating body in the bill. The government's immediate work to support the social care sector will help to professionalise the workforce by expanding the national career structure, identifying and funding quality learning and development, and ensuring there are progression and development opportunities so that people can build their careers in care. To reassure noble lords on the scope of the negotiating body, the bodies will be established through regulations, which will have the option to include more details on the remit of these bodies, and could include specifying that training and career progression are included. These regulations will follow further engagement and consultation with the sector. My Lords, I'd like to address the comments made by Noble Lord Burns, Noble Baroness Coffey, and others with regard to the political funds and the supposed contradiction between subscription traps and the reminder to opt out of a political fund. Subscription traps often occur when consumers are misled into signing a contract that they don't want through a free or reduced price offer, or face unnecessary barriers to exit a contract. This is absolutely not akin to how trade union political funds work. The situations are not comparable. A union is a collection of workers, and its political fund should be considered in that right. A union member should be aware of what their monthly fees will be, and that will include the political fund levy. The rate payable stays the same from day one. The member therefore should know what they're paying and are free to opt out. There's no deadline after which their contribution rate will rise significantly. The bill in terms of opt-out is simply restoring the position as it was before the passage of the Trade Union Act 2016. This has been the position for 70 years, and I'm sure noble lords will understand that this is a position that is fair and definitely not the same as a subscription trap. My noble friend Lord Prentice of Leeds raised the dispute involving live housing in Knowsley. I hope I can reassure the noble lord some reassurance on this issue. The government is looking into how the pre-existing range of protections are currently operating, and if and where the law may fall short. We are also conscious that this particular case has not been tested in the courts to see if the existing law offers sufficient protection. The law on inducements and detriments is complex and needs to be carefully considered, but I will continue to liaise with my noble friend on that issue. My Lords, this bill is but the first of the much wider Make Work Pay agenda that this government is endeavouring to implement. Many noble lords have made vital contributions to this debate, suggesting reforms that go further than this bill does at the current time. The noble Lord Freyberg, Viscount Colville of Cole Cross, proposed the creation of a commissioner for freelancers. My noble friend Baroness Prosser proposed further action to tackle gender equality. The noble Baroness Penn and my noble friend Baroness Lister both raised the importance of reforms to parental leave. I respect these contributions and the desire to go further, but we must strike the right balance while continuing to ensure this remains a pro-worker, pro-business bill. But it is, as I stress, part of our bigger reforms in the Make Work Pay agenda, which is an ongoing piece of work. My Lords, to conclude, this bill is a crucial step towards the government's manifesto commitment to enhance workers' rights and improve the lives of millions. Alongside our new industrial strategy, it will increase productivity and create the right conditions for long-term, sustainable and secure economic growth. This bill is a testament to the government's resolve to improve workers' rights while levelling the playing field between good employers and less scrupulous ones. I therefore urge all noble lords to support this bill, and I beg to move.
Is that this bill be now read a second time? As many as are of that opinion shall say content. Content. To the contrary, not content. The contents have it.
My Lords, I beg to move the other motion standing in my name on the order paper.
The question is that this bill be committed to a committee of the whole House. Is that the one that the noble lady means? Okay. Yes, yes. As many as are of that opinion will say content. To the contrary, not content. The contents have it.
My Lords, I beg to move that the House do now adjourn.
That the House do now adjourn.